Senate will come to order. Senators will be in their seats. Clerk will call the roll.
Alley. Argabright. Billinger. Lazy. Blue. Bowers. Bowser. Clays. Clifford. Corson. Dietrich. Erickson. Fagg. Faust-Godot. Francisco. Gossage. Haley. Hill. Holscher. Klemp. Cluse. Masterson. Miller. Murphy. Owens. Peck. Peterson. Petty. Rose. Reichman. Schmidt. Schallenberger. Shane. Starnes. Sykes. Thomas. Thompson. Titus. Tyson. Warren.
Senators and guests, please rise and give prayerful attention to our guest chaplain, Pastor Tim Milby. He's the pastor of First United Pentecostal Church in Arch City, and he's the guest of Senator Alley.
Thank you for letting me be here. We're going to pray now. Dear Lord, we come to you today, and the first thing we want to do is we want to thank you for all of these senators that have given their time and their efforts to serve this great people of Kansas. We ask that you bless them for their service. Secondly, we ask that you guide these senators to pass the best possible laws for the people of Kansas. When there seems to be great division, we ask you, Lord, that you will help them to be willing to reach compromises that will help the work of the government to continue smoothly. We pray as these men and women face challenges in doing their duty, that they will learn to lean on your wisdom and direction. We thank you for allowing us to be involved in this very important hour. We ask all these things in the wonderful name of Jesus. And everybody said amen.
Please remain standing for the pledge.
Allegiance to the flag of the United States of America, and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
For a point of personal privilege, Chair recognizes the Senator from Riley, Senator Starnes.
Thank you, Mr. President. I have the distinct pleasure of introducing the K-State personnel that are accepting the tribute today on behalf of the Kansas State University Biomanufacturing Laboratory and Training Facility that had its recent ribbon-cutting ceremony here last September. Please stand as I call your name, please. Dr. Lisa Wilkin, she's the Associate Professor of Biology, Agricultural Engineering, Director of the Biomanufacturing Laboratory and Training Facility, and led the development of the new Laboratory and Biomanufacturing Certificate Program. She also serves as Program Coordinator for Biological Systems Engineering. Dr. Beth Montalone, Professor of Biology, is a Senior Associate Vice President of Research for the Office of Research Development and Project Director of Biomanufacturing Initiative. Matt Casey, Kansas State University Executive Director of Governmental Relations. And Jalen Lane, K-State Associate Director of Government Relations. The new Biomanufacturing Laboratory and Training Facility at Kansas State University is part of a larger initiative supported by significant public investment by the following groups: the state of Kansas, the federal government, the Kansas State University Research Foundation, the City of Manhattan, Manhattan's Chamber of Commerce, and Manhattan Regional Industry Partners. The Research, Education, and Training Laboratory includes tools and technologies that drive modern biomanufacturing, from cultivating cells and bioreactors to developing scalable processes to create innovative solutions for human health, food and agriculture, and renewable energy industries. This facility is part of an ambitious effort to connect industry, research, and education while establishing Kansas as a national leader in biomanufacturing and biosecurity. I've personally toured the facility. It's amazing things that they're doing. And I think it's very important for us as legislators to understand what our tax dollars are working for. And these people are doing great work to advance all the things that they can do to help Kansans, to help our ag in those areas, as well as all the other technologies that are available. And they're in Manhattan as well with NBAF and other programs, biosecurity, all the things that are valuable and important that we don't think about, but we expect. So please join me in welcoming and honoring this group to the Senate.
Second point of privilege, Senator Shawnee, Senator Cluse.
Thank you, Mr. President, and it's my delight to first introduce my wife, Penny, hiding over there somewhere in the VIP. First time on the floor, and so thank you, Mr. President. And I'd also like to introduce some friends of ours. In particular, you know, I was thinking of a well-known scripture that says, "Give honor to whom honor is due." And so today I have my friend, Staff Sergeant Barry Hockenberger. If you would stand, Barry, and just remain standing for a few here. So I want to just talk a little bit about Barry today. He was sent to Vietnam in March of 1971 and was assigned as the personal analyst of the MTOE section. And he was instrumental in establishing an automated personnel database for all units assigned to the United States Army in Vietnam. While serving in that capacity, he was responsible for actions involving reorganization, reduction, and redistribution of military space, personnel, and equipment. He willingly accepted the challenge of every task assigned to him and continually strove for and achieve excellence. These tasks required that he be sent to units and outposts throughout the Republic of Vietnam to obtain firsthand knowledge of the needs of the units he visited. Due to Staff Sergeant Hockenberger's excellent performance, he was awarded the Bronze Star Medal by direction of the President for his achievements in ground operations against hostile forces in the Republic of Vietnam during the period of March 1971 to March of 1972. And Barry is here with his wife, Cindy, if she would stand. You always got to have a great helpmate there. And so let's fast track now, okay, all the way to 2026. He just celebrated his 80th birthday, and he also works as a maintenance technician for all of God's storehouse facilities. Does a great job, and if you think you can keep up with him, you're wrong, because he will go to heights that you don't know, and he just gets the job done. But it's my privilege and honor to honor him and his wife and his 80th birthday. So could we just give him a warm Senate welcome this morning? Thank you.
Do you guys need a moment to distribute tribute? Do I need to stand at ease for a minute? I'll stand at ease for a minute. See, we have pages today. With those that have pages for introduction, would you please stand up? Senator Sedgwick, Senator Falscudo.
Thank you, Mr. President. I have a page here today from Wichita, Kansas. She is the daughter of a very dear friend, Judy Nolan, and if Nisi would stand to be recognized, she's my page for a day. Thank you, Mr. Vice President. Mr. President.
Senator from Montgomery, Senator Peck.
Thank you, Mr. President. I do have a couple Caney Valley Bullpups with me today serving as pages. We've got, actually, before I give you their names, for those of you who have been here a few years ago, you will remember that I introduced and invited you to an Easter drama that I was participating in. The young man who was here at that time was their older brother. He was serving as the young Jesus in the temple. And for those of you who have asked, no, I'm not in a drama this year. There's plenty of drama up here for me to deal with. So, but my pages, I've got Levi, if you would stand, please. Good. And as his dad says, the boy with the blonde mullet, Josiah, which is his brother, are both here serving as pages today. Boys, gentlemen, good to have you with us today. Thanks for your help for the Kansas Senate.
Senator Shawnee, Senator Cluse.
Thank you, Mr. President. And just here to let everyone know that some of the lobbyists around here do have a life outside of this chamber as well. And so it's a privilege today to have Steve Green's two of his children with us today. And it's Sam and Ezra. And if you guys would stand and let's give them a warm welcome. Thank you, Mr. President.
We are now ready for final action. And bear with us, I think we have 7 roll calls. So on this first roll call, we will take the following: House Bill 2552, Senate Bill 329, 393, 454, 517, Senate sub for House Bill 2018, 2237, 2320, 2346, and Senate sub for House Bill 2372. Clerk will read the titles.
House Bill 2552, an act concerning crimes, punishment, and criminal procedure. Senate Bill 329, an act concerning property taxation. Senate Bill 393, an act concerning alcoholic beverages. Senate Bill 454, an act concerning crimes, punishment, and criminal procedure. Senate Bill 517, an act concerning education. Senate sub House Bill 2018, an act concerning crimes, punishment, and criminal procedure. House Bill 2237, an act concerning state agencies. House Bill 2320, an act concerning education. House Bill 2346, an act concerning economic development. Senate sub House Bill 2372, an act concerning immigration.
Clerk will call the roll.
Alley. Argabright. Billinger. Lazy. Blue. Bowers. Bowser. Clays. Clifford. Orson. Dietrich. Erickson. Fag. Falscadeau.
This is first roll call.
Francisco. Gossage. Haley. Hill. Holscher. Klemp. Cluse. Masterson. Miller. Murphy. Owens. Peck.
Yeah, maybe in a simpler format. Please. Thank you, sir.
Peterson. Petty. Rose. Reichman. Schmidt. Schallenberger. Shane. Starnes. Sykes. Thomas. Thompson. Titus. Tyson. Warren.
Has every senator had an opportunity to vote? Senator from Finney.
Thank you, Mr. President. No on Senate Bill 393. No on House Bill 2346. Aye in the balance.
Does any senator wish to explain their vote? Change their vote. Senator from Miami, Senator Shane.
Thank you, Mr. President. Most DUI crashes occur between midnight and 3 o'clock in the morning, corresponding to when many individuals who have consumed alcohol are leaving parties, bars, and social events. In 2024, 1,100 individuals were injured and 83 killed in DUI crashes in Kansas alone. In Kansas, we have placed limits on alcohol sales for good reason. Even though alcoholic beverages can be refreshing and enjoyable, they also carry a risk. Having international tourists does not change or outweigh these risks we know exist. Just because our neighbor has made changes to alcohol sales does not mean we should follow the same bad idea. I firmly believe there are things in life more important than money. Working to ensure our roads do not have an influx of drunk drivers from 5 o'clock to 6 o'clock in the morning when many Kansas citizens and parents are going to work is not something I am willing to compromise.
Senator from Dickinson, Senator Hill.
Yes, Mr. President. I would like to change my vote on House Bill 2237 from aye to nay.
So ordered. Senator from Pottawatomie, Senator Titus.
Thank you, Mr. President. Could we get a preliminary count on 393?
On my monitor, it's 24 in favor and 18 opposed, 16 opposed.
Thank you, Mr. Chair. I'd like to explain a vote. I vote no on House Bill 2346 because this bill creates a taxpayer grant program that subsidizes taxpayer-funded entities that in turn utilize taxpayer-built facilities. While no one can deny the economic impact of youth travel sports, we often ignore the immense impact on our children and families that participate. I do not believe the state of Kansas should subsidize this industry.
Senator Johnson, Senator Sykes.
Yeah, I'd like to explain my vote on Senate sub for House Bill 2018.
Please proceed.
Protecting the right to worship is critically important, but it must be balanced with protecting the fundamental right to free expression. Because Kansas law already provides tools to address disruptive and harmful conduct, Senate sub for House Bill 2018 risks creating unnecessary criminal penalties while threatening core constitutional freedoms.
Senator Johnson, Senator Holscher.
Explanation of vote, please.
Proceed.
Sub HB 2372 shifts legal and financial responsibility for federal immigration enforcement onto Kansas taxpayers, creating an unfunded mandate. This bill requires Kansas sheriffs to enforce federal law, even though our local law enforcement agencies are already stretched thin with mental health responses, gun violence, and substance abuse cases. Our law enforcement systems were designed to support local public safety functions, not federal immigration operations. Expanding them in this way introduces additional risk and financial implications for our Kansas communities. More troubling, this bill expands authority to detain without criminal charges and brings increased risk of wrongful detention and due process violations. For those reasons, I oppose this bill.
Senator from Wyandotte, Senator Haley.
Thank you, Mr. President. Aye to no on sub for 2018. And with her permission, I'd like to join the senator from Johnson, Senator Holscher, on her explanation of vote just given on 2372.
So ordered. Senator from Meade, Senator Reichman.
Thank you, Mr. President. With permission from the senator from Miami, I'd like to add my name to his remarks.
Senator from Cowley, Senator Alley.
Thank you, Mr. President. Aye to a no on Senate Bill 393, and I'd like to join the remarks Senator from Miami, if he's so like.
Senator from Montgomery, Senator Peck.
Thank you, Mr. President. The senator from Miami did a great job of writing an explanation of vote. A little surprised by that. But with his permission, I would like to join in his explanation of vote. Thank you, Mr. President.
Senator Johnson, Senator Gossage.
Thank you, Mr. President. With his permission, I would like to join the explanation of vote from the Senator Miami, Senator Shane. And with his permission, I would like to join the explanation of vote from the senator from Pottawatomie. Thank you, Mr. President.
Senator from Sedgwick, Senator Erickson.
Thank you, Mr. President. With his permission, I'd like to join the remarks on the senator from Miami on 393 and the senator from Pottawatomie on 2346.
Senator Senator Johnson, Senator Warren.
Thank you, Mr. President. While I do appreciate the senator from Miami's comments on Senate Bill 393, I'd like to add my own. We do regulate in this state alcohol. We do also work hard on increasing penalties for DUIs, and being in the position of chairing a committee which takes a good, long, hard look at increasing penalties for DUI, it would be rather inconsistent of me to support Senate Bill 393. So therefore, I vote no.
Senator from Sherman, Senator Billinger.
Thank you, Mr. President. I'd like to go from aye to no on 393 and join the senator from Miami's explanation, please. Thank you.
Senator Johnson, Senator Thompson.
Thank you, Mr. President. I too would like to join the remarks of the Senator from Miami, Senator Shane, with his permission.
Senator from Reno, Senator Murphy.
At the risk of piling on and not being original, I would like to join the senators from Miami and Potawatomi both, please.
Senator from Wyandotte, Senator Petty.
Thank you, Mr. President. I would like to join the remarks of the senator, both the senators from Johnson, Senator Sykes on 2018 and Senator Holscher on 2372.
So ordered. Senator from Douglas, Senator Francisco.
Thank you, Mr. President. I would like to join the remarks from the senator from Johnson, Senator Sykes, on 2018, and with his permission, the senator from Potawatomi on House Bill 2346.
Ordered. Senator from Johnson, Senator Holscher.
What's the count on 393?
393 is now 22 in favor, 18 opposed. Any further explanations? Changes? Chair goes aye to no on 393. Clerk will close the roll and tally the vote. $38 having voted in favor and 2 opposed to the passage of Senate Bill 329, 21 in favor, 19 opposed to 393, 40 in favor, none opposed to 454, 39 in favor and 1 opposed to 517, 34 in favor, 6 opposed to House Bill 2018, 29 in favor, 11 opposed to 2237, 40 in favor, 0 opposed to 2320, 28 in favor, 12 opposed to 2346, 40 in favor, none opposed to 2552, and 31 in favor, 9 opposed to the passage of House Bill 2372. These measures having received the required constitutional majority are hereby declared passed. All right, on the second roll call, we will take the following. House Bill 2374, House Bill 2378, 2416, sub for House Bill 2435, 2437, 2440, 2444, 2462, 2464, and House Bill 2467. Clerk will read the titles.
House Bill 2374, an act relating to healthcare professions. House Bill 2378, an act establishing removal of Squatters Act. House Bill 2416, an act concerning civil actions. Sub House Bill 2435, an act concerning natural gas public utilities. House Bill 2437, an act concerning elections. House Bill 2440, an act concerning property taxation. House Bill 2444, an act concerning crimes, punishment, and criminal procedures. House Bill 2464, an act concerning income taxation. House Bill 2467, an act concerning traffic regulations.
Clerk will call the roll.
Alley. Argabright. Bellinger. Blasey. Blue. Bowers. Bowser. Clays. Clifford.
No on 2467, aye in the remainder.
Corson. Dietrich. Erickson. Fag. Falscadeau. Francisco. Gossage. Haley. Hill. Holscher. Klemp. Cluse. Masterson. Miller. Murphy. Owens. Peck. Peterson. Petty. Rose. Reichman. Schmidt. Schallenberger. Shane. Starnes. Thomas. Oh, wait, excuse me, Sykes. Now Thomas. Thompson. Titus. Tyson. Warren.
Has every senator had an opportunity to vote? Does anyone wish to explain their vote or change their vote? Senator from Johnson, Senator Holscher.
Explanation of vote, please.
Proceed.
Explanation on HB 2378. Currently, Kansas property owners already have the legal tools they need to evict someone from their property. The process provides a court hearing where both parties are given the opportunity to make their cases. But with this bill and the removal of the Squatters Act, a loophole is created wherein there is nothing compelling law enforcement to verify whether or not the person has a lease. This would allow a landlord to skip the legal eviction process and have a tenant removed anytime for any reason. Additionally, tenants facing eviction almost never have legal representation. It is highly unlikely that a tenant who has been wrongfully removed would be able to afford an attorney and prevail in a court case. For those reasons, I vote no.
Further explanations or changes? Senator Sedgwick, Senator Fauskido.
Thank you, Mr. President. I vote aye on House Bill 2467. I appreciate the work that the body in the House and Senate has done to help those regain their driving privileges, to get back to work and school, etc. So for that reason, I vote aye on House Bill 2467. Thank you.
Senator Johnson, Senator Holscher, were you not finished?
Yeah, another one. Thank you, Mr. Chair, Mr. President. Explanation of vote on HB 2437. While this bill is presented as an election integrity measure, it would instead increase the risk of wrongful voter removal, reduce transparency in election administration, and impose new administrative burdens on county officials without evidence of a widespread problem requiring such intervention. History shows that database matching, particularly citizenship data matching, as required in this bill, has a high error rate and has repeatedly resulted in eligible U.S. citizens being wrongfully flagged or removed from the voter rolls. Kansas already has a secure method of checking voter lists, and numerous studies have found very few ineligible persons on the voter registration list. HB 2437 creates unnecessary risk to voter access, relies on flawed data practices, weakens transparency, and undermines due process protections for eligible Kansas voters. For those reasons, I vote no.
Further explanations or changes? Seeing none, clerk will close the roll, tally the vote. With 40 having voted in favor and none opposed, the passage of House Bill 2374, 39 in favor, 1 opposed to 2378, 38 in favor, 2 opposed to 2416, 28 in favor, 12 opposed to 2435, 32 in favor, 8 opposed to 2437, 40 in favor and none opposed to 2440, 35 in favor, 5 opposed to 2444, 40 in favor, none opposed to 2462, 39 in favor, 1 opposed to 2464, 37 in favor, and 3 opposed to 2467. These measures having received the required constitutional majority are hereby declared passed. On the third roll call, we will take the following. House Bill 2470, 2482, 2487, 2497, Senate sub for House Bill 2501, House Bill 2505, 2509, 2515, 2518, and House Bill 2520. Clerk will read the titles.
House Bill 2470, an act concerning economic development. House Bill 2482, an act concerning education. House Bill 2487, an act concerning post-secondary education. House Bill 2497, an act concerning financial institutions. S-sub House Bill 2501, an act concerning firearms. House Bill 2505, an act concerning public records. House Bill 2509, an act concerning health and health care. House Bill 2515, an act concerning money transmission. House Bill 2518, an act concerning crimes, punishment, and criminal procedure. House Bill 2520, an act concerning adult care homes.
Clerk will call the roll.
Alley, Argabright, Billinger. Blazy. Blue. Bowers. Bowser. Clays. Clifford. Corson. Dietrich. Erickson. Fagg. Vascudo. Francisco. Gossage. Haley. Hill. Holscher. Klemp. Cluse. Masterson. Miller. Murphy. Owens. Peck. Peterson. Petty. Rose. Reichman. Schmidt. Schallenberger. Shane. Starnes. Sykes. Thomas. Thompson. Titus. Tyson. Warren.
Has every senator had an opportunity to vote? Would any senator wish to explain their vote or change their vote? Senator from Miami, Senator Shane.
Thank you, Mr. Chair. I vote no on 2482, not because I disagree with the premise of increasing competition in college assessment, but because I worry the current bill changes Kansas standards and expectations in a negative way. As a scientist, I think it is important for separate assessment of scientific skill and knowledge. I've been given more time to consider the agreed upon language in the Senate bill, and I have found myself struggling to accept the language wherein the requirement would be to measure or report a science score as opposed to explicitly testing scientific knowledge and skill. Thank you to the committee for their hard work on this bill. I recognize this is a change from my position in the committee. Thank you.
Further explanation or changes? Seeing none, clerk will close the roll, tally the vote. 40 having voted in favor, none opposed, the passage of House Bill 2470, 39 in favor, 1 opposed to 2482, 40 in favor, none opposed to 2487, 36 in favor, 4 opposed to 2497, 37 in favor, 3 opposed to 2501, 39 in favor, 1 opposed to 2505, 37 in favor, 3 opposed to 2509, 40 in favor, 0 opposed to 2515 and 2518, 37 in favor, 3 opposed to 2520. These measures having received the required constitutional majority are hereby declared passed. On this roll call, the fourth roll call, we will take House Bill 2524, 2534, 2535, 2536, 2537, 2539, 2542, 2560, 2562, and 2564. Clerk will read the titles.
House Bill 2524, an act concerning child care facilities. House Bill 2534, an act concerning health professions and practices. House Bill 2535, an act concerning crimes, punishment, and criminal procedure. House Bill 2536, an act concerning the Kansas Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. House Bill 2537, an act concerning crimes, punishment, and criminal procedure. House Bill 2539, an act concerning libraries. House Bill 2542, an act concerning roads and highways. House Bill 2560, an act concerning the disposition of state real property. House Bill 2562, an act concerning motor vehicles. House Bill 2564, an act concerning insurance.
Clerk will call the roll.
Alley. Argabright. Billinger. Lazy. Blue. Bowers. Bowser. Clays. Clifford. Corson. Dietrich. Erickson. Fag. Falscadeau. Francisco. Gossage. Haley. Hill. Holscher. Klemp. Cluse. Masterson. Miller. Murphy. Owens. Heck. Peterson. Petty. Rose. Reichman. Schmidt. Schellenberger. Shane. Starnes. Sykes. Thomas. Thompson. Titus. Tyson. Warren.
Has every senator had an opportunity to vote? Anyone wish to explain their vote or change a vote? Senator from Finney, Senator Clifford.
Thank you, Mr. President. I vote yes on House Bill 2542, which designates a portion of US Highway 56 in Morton County as the Bill Tucker Memorial Highway. Bill was a very successful farmer and rancher in Morton County and was proud that he lived in his entire 93 years there. He was civic-minded and served 19 years in the Morton County Hospital Board and was trustee of the Kansas Hospital Association and a delegate to the National Hospital Association. He also enjoyed politics, thought everyone should be involved. He was honored to serve as a Kansas delegate to the RNC in Detroit in '84, which nominated President Ronald Reagan for his second term. He was in New Orleans in '88 that nominated George H.W. Bush. He had great stories about campaigns for many great Kansas leaders at the local and state level. This highway dedication will help memorialize his contributions for those of us who knew him, but also for future generations. Thank you, Mr. President.
Senator from Meade, Senator Reichman.
Thank you, Mr. Chairman. I vote aye on HB 2535 for all cat lovers, and especially for my wife, who has helped several thousand cats to have a better life.
Further explanation or changes? Seeing none, clerk will close the roll, tally the vote. With 40 having voted in favor and none opposed, the passage of 2524, 39 in favor, 1 opposed, to 2534 and 2535, 2536. 40 in favor, none opposed, to 2537, 37 in favor, 3 opposed, to 2539. 40 in favor, none opposed, to 2542, 2560, 2562. 34 in favor, 6 opposed. The passage of House Bill 2564. These measures, having received the required constitutional majority, are hereby declared passed. On the fifth roll call, we'll take the following. House Bill 2569, Senate sub for House Bill 2571, House Bill 2574, 2587, 2590, 2591, 2593, 2594, 2601, 2602. Clerk will read the titles.
House Bill 2569, an act concerning elections. Senate Sub House Bill 2571, an act concerning counties. House Bill 2574, an act concerning cybersecurity. House Bill 2587, an act concerning health and healthcare. House Bill 2590, an act concerning trusts. House Bill 2591, an act concerning financial institutions. House Bill 2593, an act concerning contingent fee contracts for legal services. House Bill 2594, an act concerning crimes, punishment, and criminal procedure. House Bill 2601, an act concerning children and minors. House Bill 2602, an act concerning labor and employment.
Clerk will call the roll.
Alley. Argabright. Bellinger. Lazy. Blue. Bowers. Bowser. Clays. Clifford. Corson. Dietrich. Erickson. Bag. Valscado. Francisco. Gossage. Haley. Hill. Holscher. Klemp. Luce. Masterson. Miller. Murphy. Owens. Peck. Peterson. Petty. Rose. Reichman. Schmidt. Schallenberger. Shane. Starnes. Sykes. Thomas. Thompson. Titus. Tyson. Warren.
Has every senator had an opportunity to vote? Does anyone wish to explain their vote? Senator from Sedgwick. Changes the vote. I will accept. So ordered. Further changes or explanations? Seeing none, clerk will close the roll, tally the vote. 26 having voted in favor and 14 opposed to the passage of 2569, 36 in favor, 3 opposed to 2571, 38 in favor, 2 opposed to 2574, 40 in favor, none opposed. The passage of 2587, 2590, 2591, 23 in favor, 17 opposed to the passage of 2593, 40 in favor, none opposed to the passage of 2594, 2601, and 2602. These measures having received the required constitutional majority are hereby declared passed. On the sixth roll call, we will take the following: House Bill 2603, 2606, 2618, 2626, 2627, 2639, 2653, 2700, 2719, and 2727. Clerk will read the titles.
House Bill 2603, an act prohibiting regulation of battery charge security fences by municipalities. House Bill 2606, an act concerning motor vehicles. House Bill 2618, an act concerning education. House Bill 2626, an act concerning veterans and military. House Bill 2627, an act concerning veterans and military. House Bill 2639, an act concerning children and minors. House Bill 2653, an act concerning the Secretary of Corrections. House Bill 2700, an act concerning consumer protection. House Bill 2719, an act concerning administrative rules and regulations. House Bill 2727, an act concerning abortion.
Clerk will call the roll.
Alley. Argabright. Bellinger. Blasey. Blue. Bowers. Bowser. Clays. Clifford. Corson. Dietrich. Erickson. Fagg. Valscado. Francisco. Gossage. Haley. Hill. Holscher. Klemp. Cluse. Masterson. Miller. Murphy. Owens. Peck. Peterson. Petty. Rose. Reichman. Schmidt. Schallenberger. Shane. Starnes. Sykes. Thomas. Thompson. Titus. Tyson. Warren.
Has every senator had an opportunity to vote? Does anyone wish to explain their vote or change their vote? Senator from Johnson, Senator Holscher.
Explanation of vote, please, Mr. President.
Proceed.
In August of 2022, Kansans voted overwhelmingly to protect reproductive rights from interference by the state. Yet this body has ignored the will of the people and introduced so many bills that infringe on that right that I've totally lost count. And that long list of bills that work to chip away at access to reproductive health care is HB 2727. This bill's purpose is to undermine reproductive health care providers by allowing intimidation through baseless lawsuits. There's no safety benefit to removing the state standard of medical malpractice screening panel reviews as required through this bill. This bill promotes misinformation and imposes religious ideology onto pregnant women seeking support and health care. It is past time for this body to honor the will of the majority of Kansans who voted in 2022 to uphold the right to safe and legal reproductive health care. I vote no.
Senator from Finney, Senator Clifford.
Thank you, Mr. President. I to no on 2603 and explanation of vote.
Please proceed.
I vote no to preserve local control. Thank you, Mr. President.
Senator from Johnson, Senator Thompson.
Thank you, Mr. President. I vote yes on House Bill 2727. It creates a streamlined statutory damages process for women to enforce their rights under the Women's Right to Know Act. The district court judge's decision in the motion to dismiss in Hodes Nauser Planned Parenthood versus Kobach stated that the decision did not preclude women from pursuing civil remedies to a violation of the Women's Right to Know Act. This bill provides an option for a simple legal pathway for those women who feel they have not been fully informed of the risks of the abortive procedure they're considering. This ensures that women will have their day in court, and I vote yes. And I'd like it spread across the journal.
So ordered. Senator from Douglas, Senator Francisco.
Thank you, Mr. President. With his permission, I'd like to join the remarks of the senator from Finney on 2603. And with her permission, would like to join the remarks of the senator from Johnson on House Bill 2727.
Senator from Sedgwick, Senator Erickson.
Thank you, Mr. President. Explanation of vote on 2727.
Please proceed.
Abortion is not health care. I vote to protect the preborn and women, and I would ask them to join the remarks of the senator from Johnson, Senator Thompson.
Senator from Wyandotte, Senator Petty.
Thank you, Mr. President. With their permission, I'd like to join the remarks of the senator from Finney on 2603 and the senator from Johnson on 2727.
Senator from Johnson, Senator Gossage.
Thank you, Mr. President. With his permission, I would like to join the remarks from the senator from Johnson, Senator Thompson.
So ordered. Senator from Finney, Senator Clifford.
Thank you, Mr. President. I'd also like to join the remarks to the senator from Johnson.
So
Senator
ordered.
Thompson. Thank you.
Chair will also join the remarks of the senator from Johnson, Senator Thompson, and the remarks of the senator from Sedgwick, Senator Erickson. Senator from Riley, Senator Starnes.
Thank you. Thank you, Mr. Chair. I'd like to join the comments made from this senator from Johnson as well. Thank you.
For explanations or changes? Seeing none, clerk will close the roll, tally the vote. Oh, we have one more. Clerk will close the roll, tally the vote. With 29 having voted in favor and 11 opposed to the passage of House Bill 2603, 40 in favor, none opposed to the passage of 2606, 2618, 2626, 2627, 2639, 2653, 2700, and 2719. 31 in favor, 9 opposed to the passage of 2727. These measures having received the required constitutional majority are hereby declared passed. On this seventh and final roll call, we will take the following: House Bill 2729, 2731, 2747, 2760, 2762, and 2769. The clerk will read the titles.
House Bill 2729, an act concerning abortion. House Bill 2731, an act concerning public assistance. House Bill 2747, an act concerning crimes, punishment, and criminal procedure. House Bill 2760, an act concerning health professions and practices. House Bill 2762, an act concerning crimes, punishment, and criminal procedure. House Bill 2769, an act concerning property taxation.
Clerk will call the roll.
Alley. Argabright. Bellinger. Blasey. Blue. Bowers. Bowser. Clays. Clifford. Corson. Dietrich. Erickson. Fag. Vauskado. Francisco. Gossage. Haley. Hill. Holscher. Klemp. Cluse. Masterson. Miller. Murphy. Owens. Peck. Peterson. Petty. Rose. Reichman. Schmidt. Schallenberger. Shane. Starnes. Sykes. Thomas. Thompson. Titus. Tyson. Warren.
Has every senator had an opportunity to vote? Does any member wish to explain their vote or change their vote? Senator from Douglas, San Francisco.
Thank you, Mr. Chair. So in talking more about House Bill 2769, I'm learning that it may be targeted at a specific library and library district. I know from previous legislation regarding those districts, they can be complicated, and I believe in this, there is a case in which what we think of as representation or taxation without representation, there may be a case where this makes sense. Thank you.
Any further explanation or changes? Seeing none, clerk will close the roll, tally the vote. 31 having voted in favor and 9 opposed to the passage of House Bill 2729. 37 in favor, 3 opposed to 2731. 40 in favor, none opposed to 2747. 39 in favor, 1 opposed to 2760. 40 in favor, none opposed to 2762, and 33 in favor, 7 opposed to 2769. These measures having received the required constitutional majority are hereby declared passed. Motion to concur. Chair recognizes the senator from Leavenworth, Senator Klemp, on House Sub for Senate Bill 366.
Thank you, Mr. President. I move that the Senate concur in House amendments to House Sub Senate Bill 366.
Please explain.
Thank you, Mr. Chair. There has been a lot of good conversation around 366. This bill is out of the Transportation Committee. This is a targeted safety bill focused on school zones and highway construction zones, the 2 highest risk areas on our roads today. First, it limits handheld phones used in those zones only, not a full ban, but still allows hand-free navigation and emergency calls. It starts with warnings, so it's education first, not punitive the first year. Second, it improves highway construction zone safety through better lighting, allowing modern, high visible lights so drivers can recognize hazards sooner and react faster, protecting workers on the ground. Concerns about blue lights were addressed in our committee, restricted use, stationary trailers only, and under controlled conditions. One of the things that we have talked about is kind of some wording around do officers have the ability to confiscate phones? And I want to spend just a second on that. And I want to highlight from Senate Bill 366 on page 2. A law enforcement officer shall not, I tend to focus on shall not, I think it's pretty clear. Without the consent of the person, confiscate a mobile telephone device for the purpose of determining compliance with this section. Confiscate a mobile telephone to retain it as evidence pending trial for a violation of this section. Extract or otherwise download information from this mobile device. Those 3 things I think are quite clear and allow us to feel good about this bill that we've been kicking around for the last 3 years, myself too. So I do feel we have a very clear definition of what an officer can and cannot do. And in addition to that, I have received information from a lawyer who has been in this space, and he states the bill balances the driver's right to protection to protect their device and does not allow law enforcement to confiscate a mobile phone for violating this section of law. They cannot confiscate the phone to determine compliance with hands-free. They cannot confiscate the phone as evidence, and they cannot extract data from that phone. And what I thought was interesting, these exceptions are squarely consistent with the 4th Amendment of the United States Constitution and are a basis for any lawful search and seizure, because there are a couple call-outs where if there is probable cause, if you're dealing drugs or you have an abuse order, there's a valid search warrant, those are the call-outs that allow an officer to seize a phone, which is consistent with today. We've spent time in committee really working through the details of this bill. The prima facie language was replaced with reputable presumption, which is similar to the city of Manhattan, which actually has a stronger bill than ordinance than what we have today. Language is added to clarify phones cannot be confiscated, further define the use of a mobile phone so it is not in violation when using a cell phone in hands-free mode. It requires contractors to post a sign when workers are present. I think those are some really interesting points. And what I would also say is this passed the House 116-7. So I stand for questions.
Questions for the senator from Leavenworth. Senator from Finney, Senator Clifford.
Thank you, Mr. President. I rise in support of this vote to concur. I have a constituent named Tom Linder, whose daughter, Cassie, was tragically killed at the age of 16 by a distracted truck driver. Todd's been a real advocate for this type of legislation. He comes here to the Capitol monthly. He's always present in our legislative activities back home. And for Cassie and for Todd, I will be supporting this bill. Thank you, Mr. President.
Senator Johnson, Senator Warren.
Thank you, Mr. President. Appreciate the work that has been done on this bill. It has gotten a lot better. However, I believe there's still some concerns with the bill, especially since this is the very first time this body has debated the subject. This procedure comes to us in a motion to concur with no prior opportunity, none in the last 3 years for this body to consider this issue. So I'd like to make 3 main points, if I may. First is that distracted driving is a legitimate public safety concern, but balance in law matters. So I have a couple questions for the carrier of the motion. Does the law presume that while on your speakerphone and you're holding an apple, that the driver is reckless?
Senator from Leavenworth.
Thank you, Mr. President. I think the law and how it's stated is pretty clear. It doesn't really discuss apples.
Senator Johnson.
Thank you, Mr. President. And I mean not just this bill, I mean in law. In law, if I'm on my speakerphone while holding an apple, am I presumed under Kansas law to be reckless?
Senator from Leavenworth.
Thank you, Mr. President. I might have Senator Warren answer that for me.
Senator Johnson, Senator Warren.
Thank you, Mr. President. The answer would be no. I mean, do we presume that if I'm holding my wallet while on my speakerphone that I'm a danger to others? No. Do we presume that if I'm holding an unopened book while on speakerphone, I'm being inattentive under the law? No. Do we presume that holding a soda while I'm talking to my husband in the passenger seat is distracted driving? No. Do we make holding any of those objects while on your speakerphone a crime? No. So I want to point out one other thing. We're also all concerned about drinking and driving, right? So do we, under the law, make it a presumption that if you are holding a container with liquid in it, that you are drinking alcohol and driving? No, we don't. So with those above examples, this bill, it would make it a crime of being on a speakerphone, not holding an apple, not holding a wallet, not holding your soda, not holding an unopened book, not holding a cheeseburger, but if you're simply holding a different, perfectly legal object, a mobile phone, you then have committed a crime. And I mean crime because we have a definition in statute of crime, and it does include traffic violations, and if this bill were to pass, it would include this specific type of traffic violation. So I would assert that Kansas already has prohibitions against distracted driving, against reckless driving, against inattentive driving, and also laws that prohibit all drivers from manually writing, sending, or reading a text message while on a wireless device while operating a vehicle. And holding a phone under this bill would be a primary offense, a primary reason, no other distracted driving observations, nothing, for government to impede the progress of an otherwise lawfully engaged driver on the roads. So Kansas already has laws, like I said, to punish genuinely dangerous driving and real harm. So my question is this: given that existing authority, do we truly need additional laws in this area, especially where this bill creates a crime, like I said, out of holding a perfectly legal object, even when no one is harmed and no property is damaged? I would assert it's overreach because it criminalizes behavior without requiring any criminal intent. You're merely holding an object. There's no requirement that the bill would have the driver intend to endanger anyone, or actually did. And quite frankly, the reason we don't presume that holding an apple is reckless, or a wallet, or an unopened book, or a soda is dangerous or reckless because there's nothing inherently dangerous about holding an object in your hand while operating a vehicle, right? I mean, remember the days we all used to have to hold a stick shift just to make our vehicle go. We all used to have to adjust the radio dial, perfectly get it aligned to the radio station. We all used to have to manually roll down your window while driving. So none of those were ever a crime. So the second point I want to make is that this proposal carries every hallmark of the law of unintended consequences. So under the banner of safety, right, which we all appreciate, under the banner of safety, it makes it easier for government to deprive regular people, otherwise on the roadways, of liberty. And it incentivizes more traffic stops, more citations, and deeper law enforcement intrusion into routine daily activity. It uses the heavy hand of government to unnecessarily impede the liberty of drivers. That in turn increases demand for defense counsel, who we have heard are already in short supply, and pushes more unrepresented defendants into county courts. We've all heard the downstream effects of more involvement in the legal system, right? Fines, fees unpaid, ultimately license suspensions. We've heard many of us from Kansas Legal Services. Kansas already has roughly 220,000 suspended driver's licenses. And over the last 2 or 3 years, this body has worked hard to make sure we can properly reinstate those suspended or revoked driver's licenses. In fact, just yesterday, we debated a bill that would restore CDLs that had been suspended or restricted due to prior convictions or sanctions for failure to comply with traffic citations. We just passed that bill today. So I assert that 366 takes us in the opposite direction. It would create more suspended and revoked licenses without ensuring further safety. And you know why? Because writing a ticket is easy, but navigating the legal and financial maze to resolve the ticket is not. And for many, it's prohibitively expensive. Again, regarding House Bill 2467, we heard that bill was about fairness, consistency, removing barriers for employment, and to help facilitate Kansans participate fully in our economy. I would assert 366 is not consistent with those lofty principles. I believe government does not exist to protect itself or its own systems. Instead, it exists to protect, among other things, the constitutional rights and liberty of the people. This bill makes it unnecessarily easier for government to intrude on liberty and get around the requirement of having a reasonable suspicion that a crime is being committed in order to stop that driver. And how does it do that? It makes the crime the simple act of holding the object. That's the crime itself, regardless of whether the government is right or wrong about what you were actually holding. So third and finally, we see that technology connecting cars, drivers, and mobile devices is constantly evolving and very rapidly. Many newer vehicles you've seen include integrated dashboard systems designed to reduce distraction and promote safer driving. Older vehicles do not have that. And if you look at cars, that screen in the dashboard is getting bigger. And you can perfectly operate that while operating your vehicle. So your hand is over here pushing on the screen, scrolling, and your eyes over there as well. But that would not be the crime. The crime would be holding your mobile phone. So who is this going to impact? It's going to impact those who have older vehicles. That disparity is a really simple reality. And who does the bill punish the most? It impacts those the most who can't afford the newest cars with the big dashboard screen to operate. And at the same time, mobile phones themselves continue to advance, offering more hands-free and voice-activated features that reduce driver distraction and interaction. So before layering on new statutory mandates, we should ask whether we are regulating a problem that technology is already in the process of diminishing. And we should also ask ourselves, will we choose to make it easier for the heavy hand of government to punish those holding an object while driving, or will we choose to protect liberty? I also finally want to point out, I said there were only 3 points, but one more, that while I misspoke slightly in caucus that government would not be able to confiscate the mobile phone during these stops, Government could, however, extract or otherwise download information from your mobile phone because, like I said, this bill would be a crime, and the bill provides that the government could extract or otherwise download information from a mobile phone if government has probable cause to believe the mobile phone has been used in the commission of a crime. Like I said, what was the crime? Holding your mobile phone. So with that, Mr. President, I think it's important that rather than have no opportunity to consider these matters, because this body has not had that opportunity previously, that we should have an opportunity in some respect to take a look at that. And the avenue to do that is this, that I would make a substitute motion to non-concur and have the Senate appoint a conference committee and send this bill to conference. This bill hasn't even come out of a conference committee, Mr. President. So when we are impacting the daily lives of Kansans, everybody drives, everybody has a mobile phone. This is different than when we look at tax issues or regulating land type issues, because this is going to impact everybody every day. So I would move make a substitute motion to non-concur, appoint a conference committee, and send it to conference committee. Thank you, Mr.
Motion to
President. I'd stand for
non-concur
questions.
and non-concur to the House amendments and have a conference committee appointed is in order. It is debatable. So now we're on the question of non-concur and conference committee. Senator Leavenworth, did you have comments before I move to other debate on that question?
Which senator, sir?
Leavenworth.
Thank you. I didn't hear the Leavenworth. It's a long word. First city of Kansas, by the way. All right. So just, are we in this part of the conversation, can we?
We are now on the substitute motion from the Senator from Johnson to non-concur to the House amendments and have a conference committee appointed.
Can we ask questions or make a statement?
You may. She's carrying the question. Yep.
Thank you, Mr. President. I do want to go back to the points that we've made. I think we need to simplify this a little bit. We are talking about driving in a school zone, and we're talking about driving in a construction area. And I think there's some critical points that need to be made here. This is not that difficult. So according to KDOT statistics, there's 15,000 crashes due to distracted driving per year. And I think it's fair to say we know there's lots of ways to be distracted in a vehicle, but we also know that the #1 way is on the phone. KDOT reported also in 2024 there were 1,705 construction zone crashes resulting in 8 deaths, a 31% increase in accidents since 2021. So I want to bring this back to reality and looking at this through the eyes of we have people that are dying as a result of this. And I think I'll finish with a law enforcement officer shall not, and one of those shall nots is extract data off of a mobile phone. We have this conversation around a crime, and I think what this says is you cannot extract data off of a phone, you can't confiscate a mobile phone, you can't retain it as evidence. Excuse me, that's confiscate. And you can't use it as a purpose for determining compliance with this section. And it's also important to note that the whole first year is a warning. We're educating, we're taking time to educate. So I don't think we need to move to non-concur. I think this has been simple. We've debated this with the good senator from Johnson for the last 3 years. It hasn't been popular with the good senator from Johnson, I understand that, but I think we need to take this and look at this through the eyes of common sense and move this forward. Thank you, Mr. President.
Senator from Johnson, Senator Warren.
Thank you, Mr. President. Since a comment was directed specifically at me, over the last 3 years and debate, I strongly suggest that that is not accurate. This bill has not been up for debate by me or anyone else. So given that it's a fresh issue, I think it deserves some more look at it. I also want to address that it's simply not true that the government would be prohibited from looking in your phone, because the crime is the holding the phone, and government could then look in your phone.
On the question, Senator from Johnson, Senator Corson.
Thank you, Mr. President. I would be strongly in opposition to the senator from Johnson's motion to send this back to conference committee. We heard yesterday about death by fiscal note. This is really an attempt at death by conference committee, and we should just be honest about that. As long as I've been in the Senate, which is 6 years, we have been debating this issue. We have had hearing after hearing after hearing in the Senate Transportation Committee. We've made numerous changes to this legislation to try to address some of the concerns that were raised, and I think that we've really done that in a very reasonable way to try to, again, improve the concerns that were raised and address those in a way that I think is fair, but does preserve the original intent of the bill. The good senator from Leavenworth did point out that confiscation is not permitted under this bill. We had 14,000 distracted driving accidents in 2024. We had 70 fatalities in Kansas. This is all just in Kansas. 450 injuries. I think that we all know we could point out various hypotheticals about what about this thing or what about this other thing, but I think we all understand that cell phones present a uniquely distracting presence in our lives, especially when we're driving. They're distracting for several reasons. Number one, you're taking your hands off the wheel, you're taking your eyes off of the road, and you're taking your mind off the task of driving safely. I also want to point out that this is an incredibly limited piece of legislation. 32 states have total bans on driving while operating a cell phone. Here in Kansas, we are talking about a very narrow piece of legislation, Senate Bill 366, which only says not only when you're driving through a school zone, it is even further limited to only when that school zone period is being enforced, which is just the brief period when students are arriving at school at the beginning of the day, and then the brief period when students are departing at the end of the day. The rest of the day, this bill would have would not be enforced in school zones. With respect to construction zones, again, we're not even saying any construction zone. We are just saying a construction zone when workers are present. And the reason that those periods are important is because that is exactly when you have what is a really deadly combination of drivers and people. The good senator from Johnson mentioned that, you know, you could be cited and you haven't even had an accident. I don't think we need to wait here in Kansas until a student is killed by a distracted driver to take action. This bill provides it. These are just going to be a warning until July 2027, so folks have time to familiarize and understand what is being asked of them under the law. Again, I think this is a very common sense safety measure. It has had ample discussion, ample debate. The good senator is a member of the Transportation Committee. She has been in all of the hearings that we've had on this piece of legislation. She's raised a lot of very good questions of proponents and opponents. We've addressed many of those concerns, so she has had more than ample ability to weigh in and craft this legislation. We're talking about a $60 fine, or we're talking about making people much safer and making our state safer for little kids going to school and our construction workers. I also would just push back against what I think is an implication that our really brave, well-trained law enforcement officers in Kansas would be looking at this piece of legislation and using it to abuse their authority or to take away the rights of Kansans. I have an incredible amount of trust and respect for our brave law enforcement officers, and I have no doubt that, as they do with all of our other laws, that they would enforce this law as it was meant to be and as it was intended in a way that would keep Kansas kids and Kansas construction workers safer. So I would be strongly opposing the Senator from Johnson's motion to send this to a conference committee. Would hope the body would join me.
I'd note to the body, we are outside of general orders, so just be mindful that you can address twice. Senator from Sedgwick, Majority Leader Blasey.
Thank you, Mr. President. I too stand in opposition to this motion with my colleagues here in the Senate. You know, this is a bill that the Senate Transportation Committee has kicked out 3 of the last 4 years, or some version of it. The Kansas House of Representatives has passed this bill, I believe, in 2023, 2024, and I believe in 2025. And here we are in 2026, and this bill's come a long way. There's a lot of provisions in this bill originally that I did not like. And last year, I made my concerns known, and the committee has taken a lot of those concerns into consideration as other concerns in this body, and they've removed several provisions of this bill. I've held numerous meetings of all stakeholders and all viewpoints of this legislation from members of the Senate in my office. We have discussed this at great length. We have amended the bill to, I believe, to make it better. And so I think this product is worthy of a Senate vote and worthy to become law. And so I ask the Senate to vote no on the motion to non-concur, and let's get this legislation to the governor. Thank you.
Senator Riley, Senator Starnes.
Thank you, Mr. President. And I also am supportive of the vote no. It's being a former school superintendent and involved with students, anything that we can do to protect our students and the valuable, important lives that we look at. Obviously, too, with the situation in the city of Manhattan, as the good senator talked about earlier, Manhattan has a stricter policy due to college-age students and being distracted. It's an issue. And the whole body of this, the 366, has the entire support of all our law enforcement agencies as proponents. So I think that they're speaking very highly of the importance to concur with this. And so would again support that and rise in opposition to the going back to committee. Thank you.
Senator from Finney, Senator Clifford.
Thank you, Mr. President. Always a hazard to hold a microphone when 2 lawyers are debating in the chamber, but I also stand in opposition to this non-concur motion. I think Senator for Leavenworth has shown us that this is almost a trial period to educate the public, and I really think we need to move this out as soon as we can. Children are dying, citizens are dying, our maintenance workers and highway workers are dying. Thank you, Mr. President.
Senator Shawnee, Senator Cluse.
Thank you, Mr. President. You know, this bill has been around. I don't want to just keep going over everything on this, but I would like to just say a couple of things. And while I appreciate the Senator from Johnson and, you know, her words on this, I got to go with my gut on this bill. And, you know, the practical thing that I've been saying for the last few years is, as we have had deep conversation in transportation, school zones, and, you know, there's so many kids playing and, oh, sorry, phone just vibrated there. And, you know, a little kid can run out in a moment. And we're talking about being in a work zone. And let me just get down to, you know, I'd like, maybe we could ask my wife's dad, my wife was here earlier, and ask him about what he thinks about, oh, that's right, we can't. Because a young gal was on her phone at a high rate of speed, driving down 81, distracted, and hit him on his motorcycle, and he was killed instantly. So I think I got to go with my gut. I get all the logistics of this. We need to vote this down. Let's make this a law. Let's just help somebody. And that's all I got to say. Thank you.
Senator Johnson, Senator Thompson.
Thank you, Mr. President. I am in support of this motion. I think the senator from Johnson, Senator Warren, made a lot of good points. You can be distracted in a number of different ways, and to be presumptively guilty of something just for holding a phone or anything else just opens a very dangerous door. When I was a kid, the first thing my dad did when he bought a new car was to cut the seat belts out. And I never liked the seat belts law because I thought it was a nanny state telling us what we had, or if you want to drive without a seat belt, you take that risk. If you want to hold the phone, you want to hold a sandwich in your hand as you're driving down the street, you're taking a risk. There's no evidence of distracted driving, no clear evidence of distracted driving until there is an accident. And if there's not an accident, it's like one of these crimes. It's like, oh, you were holding a phone, you were distracted, you're guilty. That's a dangerous precedent to set, and I just can't go along with that. So I will support the motion. Thank you, Mr. President.
Before I get too far out ahead of you, Senator Johnson, do you want to have intermediate comments, or do you want to hold for close? Senator from Sedgwick, Senator Miller.
Thank you very much, Mr. President. And I'll be brief. I am also opposed to sending this back to conference committee. I think we need this bill. It's a start, but I think we should eventually take it a lot further. As someone who drives on Kellogg in Wichita almost every day, I can honestly say I'm surprised to hear that the recent year's numbers of distracted driving accidents is only 14,000. As I see it, every single time I get behind the wheel, every single time I look to another driver, they're almost always on their phones. But personally, I've been in 3 separate accidents in the last 20 years. All 3 of them were due to the other driver being distracted. The first one, I was rear-ended by a teenager who was texting, not realizing that I was stopped in front of her. That was in a work zone. The second one, someone made a left turn in front of me across the lane, not realizing that I was coming because they were holding their phone in front of them, speaking on their speakerphone, and that was actually in a school zone. The third time I was on my motorcycle on Kellogg in Wichita, which is already so dangerous to be on a motorcycle, but I'm a thrill seeker. But a motorist was driving, they were texting, they were veering over into my lane, ultimately knocking me into the shoulder, and I had to lay my bike down. The closest I've come to dying so far in my life. So ultimately, I think that distracted driving does need to be taken care of. I think this bill is a start, but I think that we can take it a lot further, and I know that we've talked about it for years, and I'm tired of talking about it. I'd like to do something about it. So I will oppose sending this to the conference committee, and I hope everybody will vote in favor of this bill. Thank you, sir.
Senator Johnson, Senator Corson for second time.
Thank you, Mr. Chair. I just wanted to rise based off something that the good senator from Johnson, Senator Thompson, said. He said, when you're holding the phone, you're taking the risk. The thing is, though, you're not taking the risk. You're putting that risk on the innocent kid who's crossing the crosswalk, who's going to school in the morning. You're putting that risk on the good senator from Shawnee's father-in-law. They didn't sign up to take that risk. You're putting the risk on the construction worker who kissed their wife and kids goodbye in the morning to go out and do a very hard, very dangerous, very respectable job to both improve Kansas and provide for their family. They're the ones who are hurt by you taking the risk. This is not something where the risk is just on the driver. The risk is not on the driver. The risk is on the school kid, and the risk is on the construction worker. And that could be a family member of me. That could be a family member of any of us. That could be your kid, that could be your grandkid, that could be your uncle, your cousin, your brother, your sister. This is a simple, straightforward bill. It is incredibly limited. 32 states have already said that you can't drive at all with a cell phone, and this is just limited to school zones when kids are present, construction zones when construction zones are present. So again, I'm just hoping that we will vote down this motion.
Senator from Lynn, Senator Tyson.
Thank you, Mr. Chairman. I don't think there's a person in this body that doesn't know where they're going to vote on this motion. And I do appreciate the good senator from Johnson bringing it. It's that time of session. We see legislation that has never crossed the Senate floor. I'm not saying no to this bill. I'm not saying no to what's in the policy. I'm just saying let's get another set of eyes to look at it for the conference committee report. I will be standing in support of the motion, and I hope the rest of the body will too.
Senator from Leavenworth, Senator Klemp, do you have any comments before we move to the motion?
Yes, thank you, Mr. President. I think the reason that this bill is ready for prime time is because of the good senator from Johnson and the good senator from Potawatomi. They're legal minds, and I was nice I got included to be a lawyer. However, I don't know if that's a badge of goodness or badness, but I'm not a lawyer. But that being said, I look at that, and this bill is better because of their effort and the impact they've had on how we've constructed this bill. That is why I feel it's ready for prime time, in addition to all the other reasons that we've talked about. And I just wanted to make that statement because there's a lot of good work that's gone into this by the good folks that are talking that would like to see it go to conference. And I just think we're past that. It's a great product. Thank you, sir.
Senator Johnson, Senator Warren, you may make closing remarks on the motion.
Thank you, Mr. President. Appreciate everyone's time and attention today. And let me be clear about a couple of things. First, I could stand in full-throated support of this bill with one small change, and that is making it a crime to hold the phone. One small change. I support. We need to be careful in our construction zones. We need to be careful in our school zones. Of course, our construction workers, our kids, right? And we are at that time of session where procedure matters too, right? So this is the first bill, hopefully, probably won't be the last, where a bill is coming across this floor in a concur that has not been debated or passed across this floor prior. If the intent was to kill the bill, the motion would never have been made, because if a concur that hasn't come out of a conference committee like this bill fails, the bill dies. So the motion is actually to help save the bill and help address the concern that holding the phone is evidence of the crime, whether you're using it or not. And with regard with what other states have done, maybe 38 other states have done something, but no one has been as aggressive about making it a crime to hold a phone as this bill. So don't be misled that this is, just something that all other states or a majority of other states have done. Regarding statistics, you know, you could have statistics, every single one of those is a tragedy that, of course, we don't want to happen. But if we're looking at statistics, what's the statistics on how many times accidents don't happen in those zones, with how many tens of hundreds of thousands of motorists who safely traverse those areas? So I do have to have made the motion, I feel, because I am about protecting individual liberty. And if we go too far down the road in the name of safety, where's the end point? We heard one good senator during the debate say, wishes the bill would go further. Well, what's coming next later, right? A slippery slope. You have to drive only with two hands on the wheel, period. And this bill does raise some concerns. Overall, I appreciate it's gotten better, but for that reason, Mr. President, needs a little more eyes on it, and it has not come out of a conference committee. So therefore, I move that...
The motion has been made.
There we go. Okay, thank you.
We're voting on the motion made by Senator from Johnson to non-concur to House amendments and a conference committee be appointed. All those in favor say aye. Opposed, no. Noes appear to have it. Noes do have it. We are back on the motion to concur, carried by the senator from Leavenworth, Senator Klemp.
Thank you,
Any further questions? Seeing none, do you have any closing remarks? Please proceed.
Thank you, Mr. President. I appreciate the robust debate, and I appreciate where this bill is today. And I would finish with, there are a lot of good proponents that supported this bill. Everyone from Kids Safe Kansas, League of Municipalities, the Chief of Police, the Chief of Peace Officers, Highway Patrol, Kansas Sheriff, General Motors, AAA, Kansas Department of Transportation. I think we all feel that the state of this piece of this product is ready for prime time, and it's ready to move forward and concur. Thank you, Mr. President.
We will hold for final action because the motion to concur is final action, and we are now ready for final action. On this roll call, we will take the following. The motion to concur on House Senate Bill 366. Clerk will read the title.
House Substitute for Senate Bill number 366, an act concerning traffic regulations.
Clerk will call the roll.
Alley, Argabright, Bellinger, Lazy, Blue, Bowers, Bowser, Clays, Clifford, Corson, Dietrich, Erickson, Bag, Faustido, Francisco, Gossage, Haley, Hill, Holscher, Klemp, Cluse, Masterson, Miller, Murphy, Owens, Heck, Peterson, Petty, Rose, Reichman, Schmidt, Schallenberger, Shane, Starnes, Sykes, Thomas, Thompson, Titus, Tyson, Warren.
Has every senator had an opportunity to vote? Senator from Butler, Senator Fagg.
Thank you, Mr. President. I vote aye.
Senator from Sherman, Senator Billinger.
Thank you, Mr. President. I vote aye.
Senator from Sedgwick, Senator Clays.
I vote aye.
Does any member wish to explain their vote or change their vote? Senator from Wyandotte, Senator Haley.
Thank you, Mr. President. Regrettably, I vote against this measure. I vote no on this conference committee report. Mr. President, I've been in this body for quite some time and remember the discussion of driver safety and distractions, and ensuring public safety is better for those that navigate our highways and byways. I recall the primary seat belt law for public safety and how it was necessary to have, for public safety, primary seatbelt law. I remember the discussion regarding texting and driving and how it was debated on this particular floor. And I'm a strong proponent of public safety and believing that we do need to work on distracted driving being lessened in our state. What's happened, and the reason I have to vote no, is that these have been gateways, these measures and others, for allowing for selective enforcement of our laws that often disproportionately impact many constituents. The pretext for stopping and for ticketing many people who are ill-equipped to sustain a ticket or to brought in because of that particular often discriminatory action is why I regrettably vote against yet another measure that has the unintended consequences, perhaps to some, of bringing more people in for tickets who otherwise would not be. Thank you.
Senator Johnson, Senator Warren.
Thank you, Mr. President. We always look for balance in our laws, and we do work hard in providing safety as well as protecting individual liberty. So I vote no because, in part, this bill doesn't strike the right balance between those two competing interests, if you will, and it goes too far. I also vote no because of the process that brings it to the floor. The process is that it has never had debate in a manner where it was subject to amendment, has not crossed our floor. It is not even a conference committee report. So with that, Mr. Chair, while I do stand in strong support of public safety and the underlying bill, except for the one provision of holding your phone, I vote no.
Senator Johnson, Senator Thompson.
Thank you, Mr. President. With her permission, I'd like to join the remarks of Senator for Johnson, Senator Warren.
So ordered. Senator Marino, Senator Murphy.
Thank you, Mr. President. I would like to change my aye to no and join the senator from Johnson.
So ordered. Further explanation or changes? Seeing none, clerk will close the roll, tally the vote. Thirty-one having voted in favor and 9 opposed, the passage of Senate Bill 366, this measure having received the required constitutional majority, is hereby declared passed. Before recessing, are there announcements? Seeing none, Chair recognizes the Majority Leader from Sedgwick, Senator Blasey.
Thank you, Mr. President. The Senate is going to break for recess, or is going to recess for lunch. And I'm sure everyone has received an invitation to the bill signing of the cell phone ban in K-12 schools in Kansas. That's at 1 o'clock on the second floor. So all are invited for those who are interested. So with that, I move the Senate recess until 2 p.m.
You've heard the motion. All those in favor say aye. Opposed, no. Motion carries. Senate is recessed. Senate will return to order. Messages from the House. Clerk will read.
Announcing adoption of SCR 1603 as amended. Announcing passage of HB 2036, HB 2073. Announcing passage of Senate Bill 55, Senate Bill 334, Senate Bill 425. Announcing passage of SB 51 as amended by H sub for SB 51. SB 260 as amended by House sub for SB 260. Senate Bill 364 as amended. Senate Bill 356 is amended by H sub for Senate Bill 356. Senate Bill 391 is amended. Senate Bill 434 is amended by House sub for Senate Bill 434. Announcing passage of Senate Bill 232 as amended. Senate Bill 374 is amended. Senate Bill 375 is amended. Senate Bill 380 is amended. Senate Bill 398 is amended. Senate Bill 408 is amended. Senate Bill 418 is amended. Senate Bill 459 is amended. Senate Bill 462 is amended. Senate Bill 480 is amended. Senate Bill 487 is amended. The House adopts the Conference Committee report on Senate Bill 254. The House concurs in Senate amendments to House Bill 2622. The House concurs in Senate amendments to House Bill 2737. The House non-concurs in Senate amendments to House Bill 2412, request a conference, and has appointed Representatives Humphreys, William L., and Osman as conferees on the part of the House. The House non-concurs in Senate amendments to House Bill 2579, request a conference, and has appointed Representatives Francis, Essick, and Helgerson as conferees on the part of the House. The House non-concurs in Senate amendments to House Bill 2647, requests a conference, and has appointed Representatives Francis, Essick, and Helgerson as conferees on the part of the House. The House non-concurs in Senate amendments to House Bill 2763, requests a conference, and has appointed Representatives W. Carpenter, Bryce, and Ruiz S. as conferees on the part of the House. House Bill 2036, an act concerning income taxation. House Bill 2773, an act concerning taxation.
This constitutes introduction of those bills previously read. Please see the March 19th Journal for notice for USD 501 and USD 499 for notices to dispose of school buildings. Consideration of motions, occur, non-concur. Chair recognizes the Senator from Sedgwick, Senator Blasey on SCR 1603.
Thank you, Mr. President. I move the Senate non-concur and House amendments to Senate Concurrent Resolution 1603 and request a conference committee be appointed.
For the motion, all those in favor say aye. Opposed, no. Motion carries. Chair appoints the Senator from Lynn, Senator Tyson, Senator from Montgomery, Senator Peck, and Senator from Johnson, Senator Corson. Motion to concur, non-concur. Chair recognizes Senator from Sedgwick, Senator Erickson on 361 and 382.
Thank you, Mr. President. I move the Senate non-concur and House amendments to Senate Bill 361 and Senate Bill 382 and request a conference committee be appointed.
You've heard the motion. All those in favor say aye. Opposed, no. Motion carries. Chair appoints as conferees a part of the Senate, Senator from Sedgwick, Senator Erickson, Senator from Johnson, Senator Thompson, Senator from Johnson, Senator Sykes. Chair recognizes the Majority Leader from Sedgwick, Senator Blasey.
Thank you, Mr. President. I move the Senate resolve itself in the Committee of the Whole for consideration of bills on the calendar under the heading of General Orders.
You've heard the motion. All those in favor say aye. Opposed, no. Motion carries. Chair appoints the Senator from Johnson, Senator Thomas, to preside over the Committee of the Whole.
All right, thank you, body. The Senate, having resolved itself into the Committee of the Whole, will now consider those items listed on the calendar under the heading of General Orders. We'll now turn our attention to Senate Bill 524. The chair recognizes the Senator from Lyon, Senator Argerbright, to explain the bill and adopt the committee report.
Thank you, Mr. Chair. I move we adopt the committee report.
You've all heard the motion. Those in favor say aye. Those opposed, no. Motion carries. You may continue.
Thank you, Mr. Chair. SB 524 is a trailer bill for the public monies pooled method legislation enacted last session and substitute HB 2152. This legislation created the KCP, the Kansas Collateral Program for municipalities to invest in Kansas. Colleagues, that was the bill that we want to keep money, Kansas money in Kansas in our Kansas banks. It actually passed the House last session
117 to 5, and this chamber 40 to 0. SB 524 is all about making sure that when your local government, like your city or your state of Kansas, puts its money into a real bank, that the public money is completely protected. SB 524 requires banks to enter into a written agreement with the state treasurer to be a depository of public monies, increasing the market value of securities necessary to secure the public monies. It also includes investment pool board. Most of the bill, colleagues, is rules and regulations. A lot of detail on rules and regulation, creating some transparency for us. It also includes a 102% backup rule. This bill changes the rule so the bank must hold 102% of the amount deposited. Federal law will not be in effect. State law will not counter federal law. Basically, this bill is a strict set of rules telling banks that if they want the privilege of holding onto the public's money, they have to prove they are highly responsible and keep extra backup funds locked away. Under the new law, municipalities can choose their own Kansas bank, but must follow specific security and geographic guidelines. This bill is more technical in nature. It does have a small fiscal amount. The bill is necessary to comply with previously passed HB 2152. Proponents were Stephen Johnson, Kansas State Treasurer, Special Legal Counsel for the State Office, and the Kansas Bankers Association. There was no neutral, no opponents. Mr. Chair, I'd stand for questions.
Are there questions for the senator from Lyon? Seeing none, Senator, you may close.
Thank you, Mr. Chair. Our banks across Kansas, through our Kansas Bankers Association, has worked really hard to try to get some incentives that keeps Kansas money in Kansas. Appreciate their work on all this. I move that when the committee rises and reports, it reports 524 favorable for passage.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. The chair recognizes the senator from Sherman, Senator Billinger, for an announcement.
Thank you, Mr. Chairman. The Senate, we're going to call, the House has called a conference committee on House Bill 2513 at 2:45 in room 112 North to start the conference on the budget.
Thank you for that. We'll now turn our attention to House Bill 2767. The chair recognizes Senator from Cali, Senator Alley, to adopt the committee report and explain the bill.
Thank you, Mr. Chair. I adopt the committee report.
All heard the motion. Those in favor say aye. Those opposed, no. Motion carries. You may continue.
House Bill 2767, as amended, would establish the Kansas Military Affairs Commission within the Office of the Governor. The commission would then be a continuation of the Governor's Military Cabinet. This is different from the Kansas Office of the Veterans Affairs. The membership into this committee would be 15 voting members appointed by the governor and, like they normally do, the Senate President, Senate Minority Leader, and such on, as well as the House. That would appoint the 15 voting members. In addition to the voting members, there would be 11 non-voting members, and these coming from one member from Fort Leavenworth, one from Fort Riley, one from McConnell, and the United States Coast Guard Pay and Personnel Center. One member each from University of Kansas, Kansas State University, Wichita State University, Emporia State University, Pittsburgh State University, and Fort Hays State University, as well as one member from the Kansas Fusion Center. And these members would also serve a 3-year term. Mr. Chairman, this commission would provide advice, counsel, and actionable recommendations on military-affiliated issues and economic and industrial development related to the military, to the governor, the state, and the federal agencies. This commission was basically, when we do, if this bill passes, it will codify that this commission would serve at the governor's functions and the governor's military council. And it was originally established and continued by the executive order. So this will replace the executive order and codify this commission. The fiscal note for this would actually be zero. The governor's salary, or the general salary, will be transferred back to the Military Affairs Commission. And with that, I'll stand. Well, one more thing that was important when I visited with the general. You talk about the economic impact of our military bases and our military personnel here in Kansas. Kansas itself, the combined total impact GSP would be at least $10 million, 170,000 jobs indirectly and indirectly, and a total of, they thought, $5.7 billion in wages. And the fiscal impact from the activity in Kansas would be close to $50 million in city and county revenues. So with that, I will stand for questions.
Are there questions for the senator from Cali? Chair recognizes the senator from Sedgwick, Senator Blasey.
Thank you, Mr. Chairman. Let's just jump right in it, and I'll just say I have an amendment, 4482.
All right. Give us a moment while we pass that out. You've turned it in?
Yes, sir.
Amendment appears short. Would you like to explain, sir?
Mr. Chairman, I'll go ahead and explain it. So I believe, I understand this is just a continuation of an executive order which created the Governor's Military Council, and it solidifies it into state law as the Kansas Military Affairs Commission. And this new commission will be designated of 16 voting members. But as we approach the end of one administration at the end of the year, we're going to have a new governor come January. And I just think it's only right that he or she has the right to have a military council that's under their office that serve at her or his pleasure. So this amendment would just say that the appointees by the governor serve at the pleasure of the governor. That is all.
You stand for questions?
Yes, sir.
All right. Are there questions on the amendment? Chair recognizes the senator from Sedgwick, Senator Fauske-Doe.
Thank you, Mr. Chairman. So that individual that the senator just spoke of, so the governor appoints that person?
Senator from Sedgwick.
Solely?
So, Mr. Chairman, the governor appoints numerous members of this commission, a representative from several counties that have military installations like Leavenworth, Sedgwick, Shawnee, Riley, or Geary, as well as a military spouse, as well as others. And so this amendment would just say that those members who are appointed by the governor serve at the pleasure of the governor.
Further questions for the carry of the amendment? All right, Senator from Cali.
Thank you, Mr. Chair. I believe this is a friendly amendment. Thank you very much.
Seeing no further questions, Senator, you may move your amendment.
Thank you, Mr. Chairman. I move my amendment.
You've heard the motion. All in favor, say aye. Aye. Opposed, no. Motion carries. We are back on the bill. Further questions from the senator from Cali? Chair recognizes the senator from Lyon, Senator Argabright.
Thank you, Mr. Chair. Just a few comments. I appreciate the efforts to stay very well connected with our bases in Kansas and the importance of having those bases in Kansas, our military bases, and appreciate the work done on this. Thank you, Mr. Chair.
Any further questions? Seeing none, Senator, you may close.
Thank you, Mr. Chair. I move that when the committee rises and reports, it reports House Bill 2767 as amended, favorable for passage.
You've all heard the motion. Those in favor say aye. Those opposed, no. Motion carries. We will now turn our attention to House Bill 2485. The chair recognizes the senator from Sedgwick, Senator Erickson, to explain the bill and adopt the committee report.
Thank you, Mr. Chair. I move we adopt the committee report.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. You may continue.
Thank you, Mr. Chair. House Bill 2485 establishes clear and consistent requirements for agreements between school districts and community or technical colleges when post-secondary courses are taught in secondary schools by district-employed teachers. First, this bill ensures fairness and transparency and compensation, establishing a standard predictable amount for teaching and site coordination services. Second, this bill promotes fiscal accountability by clearly delineating what costs post-secondary institutions are responsible for, including instructional materials and supplies not otherwise provided by the school district. Third, the bill respects existing local agreements by not limiting or restricting any negotiated agreement between a school district and the faculty, or any negotiated agreement between the community or technical college and its faculty. The bill supports the long-term sustainability of CTE programs by creating a clear statutory framework that aligns with the Kansas Board of Regents' service area and concurrent enrollment policies. Additionally, this bill would authorize the Chief Executive Officer of the Board of Regents to negotiate and settle any repayment obligations arising under any scholarship, grant, or other student financial aid program administered by the board. It also would prohibit the payment of additional funds to any student who is subject to repayment obligations under those financial aid programs. With that, I will stand for questions.
Are there questions for the senator from Sedgwick? Chair recognizes the senator from Riley, Senator Starnes.
Thank you, Mr. Chair. Senator, I just want to make sure I understood. So it would not affect the negotiated agreements that they've already established and or affect any of the agreements with the community colleges or VOTEC schools.
Senator from Sedgwick.
Thank you, Mr. Chair. That is correct.
Thank
Senator
you.
from Riley. Further questions for the senator from Sedgwick? Seeing none, Senator, you may close.
Thank you, Mr. Chair. I move that when the committee rises and report House Bill 2485 favorably for passage.
You've heard the motion. All in favor say aye. Those opposed, no. Motion carries. We will now turn our attention to House Bill 2613. The chair recognizes the senator from Johnson, Senator Rose, to explain the bill and adopt the committee report.
Thank you, Chair. I move we adopt the committee report.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. You may continue.
Thank you. The Crime Victims Compensation Board, which I will refer to as the board, provides financial assistance to victims of violent crime who suffer an economic loss as a result of their victimization. House Bill 2613 would transfer the responsibility of paying for sexual assault examinations from Kansas counties to the Crime Victims Compensation Program. This bill is brought by the Attorney General's office, and the board voted unanimously to support this bill. This bill would save all Kansas counties money. This bill also helps Kansas hospitals and medical clinics by streamlining the payment process. There are an estimated 1,500 examinations conducted each year. They cost a total of $1,087,500 per year to the board. But the board will receive a 75% match for all state expenditures through the Federal Victims of Crime and grant, so the net annual cost of the program will be just $271,875, which is an amount that can be absorbed with the existing revenues through the Kansas Crime Victims Compensation Fund, which has maintained a healthy balance for more than a decade. These revenues do not consist of any state general funds, are funded only by offenders throughout the criminal justice system, and will not reduce compensation to any victims. And with that, I stand for questions.
Are there questions for the senator from Johnson? The chair recognizes the senator from Johnson, Senator Holscher.
Thank you, Mr. Chair. I rise in support of this bill. Streamlining the process regarding payment for a cost of the sexual assault evidence collection kits is important, meaningful change. Having the fees paid through the Crime Victims Compensation Board reduces preventable harm and removes a significant barrier to healing and seeking justice. Passage of this bill would benefit thousands of Kansans each year. I ask the body to vote yes.
Further questions for the senator from Johnson? Seeing none, Senator, you may close.
Thank you, Chair. I move that when the committee rises and report House Bill 2613 favorably for passage.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. We'll now turn our attention to House Bill 2651. The chair recognizes the senator from Pottawatomie, Senator Titus, to explain the bill and adopt the committee report.
Thank you, Mr. Chair. I move adoption of the committee report.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. You may continue.
Thank you, Mr. Chair. House Bill 2651 would amend the Kansas Parentage Act to authorize a challenge to a voluntary acknowledgement of paternity, or VAP, as soon as is practicable after discovery of fraud, duress, or mistake of fact, and specifying that genetic testing results would constitute a change of circumstances that warrants a court finding of a material mistake of fact. VAPs are typically signed at the time of birth while the mother and father are at the hospital. The committee heard testimony from several men who had signed a VAP that no longer had contact with the children or even the women with whom they were previously associated with, and in all cases, the signer was not that biological father. All parties in these situations wanted to end the arrangement, but the current law would not allow this to happen, to cancel child support or any of the related legal agreements. The bill would allow for a challenge to a VAP within 60 days of signing or before any court order establishing child support. In the case of a minor that signs a VAP, they may challenge the determination until they are 19 years old. This bill also provides criteria for the court to consider when revoking existing child support orders, and benefits already paid would not be recoverable. The bill would apply retroactively, and I will stand for questions.
Are there questions for the senator from Potawatomi? Seeing none, Senator, you may close.
Thank you, Mr. Chair. I move that when the committee rises and report House Bill 2651 favorably for passage.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. We will now turn our attention to House Bill 2596. The chair recognizes the senator from Cali, Senator Alley, to explain the bill and adopt the committee report.
Thank you, Mr. Chair. I adopt the committee report.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. You may continue.
Thank you, Mr. Chair. House Bill 2596, as amended, would authorize the Secretary of Corrections to enter into a contract for production of manufactured or modular homes under the Prison-Made Good Acts of Kansas. The bill would require the Secretary to charge a private contractor for the regional average commercial rate for rent for the square footage used, and also for regional average wage for the skills utilized without any deviation for training wages. And this bill was brought to us by a representative from Hutchinson. And we did amend it in committee to have a 3-year sunset on this bill, and then also report on the skill level that the prisoners would get, and as they come out, are they graduated, are they be able to get a job? And so with that, I will stand for question.
Are there questions from the senator from Cali? The chair recognizes the senator from Reno, Senator Murphy.
Thank you, Chair. I do have an amendment for this.
Have you turned it in?
I have. It's 4505.
Okay. Give us a moment to get those handed out. Body, this amendment is being scanned in now, so we'll stand at ease for just a moment. All right, very good. We're back on the bill. We will pause as we get the copies of the amendment ready here. Thank you. The amendment appears short. Senator, would you like to explain?
Certainly. Generally in favor of this bill. There's a little consternation about maybe competing with private business, but I think we've sort of worked with that a little bit. And there was issues in relation to maybe if these homes that were built were retained and rented out by a nonprofit, what that would do to the local tax base. And so this is just pretty simple. I have talked to a county commissioner and some other folks back in Hutch, and they are on board with this. Also, as the representative who brought this bill to begin with, he has seen the amendment and is in favor of it. And all this does is says that if a nonprofit retains this house, they cannot apply for a property tax exemption.
All right, we stand for questions.
I stand for questions.
Are there questions on the amendment? Chair recognizes the senator from Cali, Senator Alley.
Thank you, Mr. Chair. Not a question, but during testimony on this bill, we heard that in Hutchinson, they need up to 1,000, or Hutchinson area, they need up to 1,000 housing units, and they were mentioning that they would like to get these started right away. So this amendment will make sure those housing units would go out, and they wouldn't be for the rental units.
Chair recognizes the senator from Wyandotte, Senator Petty.
Thank you, Mr. Chairman. So I just need clarification. So would that mean, for example, and to be fair here, I don't know the answer. So for example, if these were being, if Habitat was working with, or an organization like that was working with the Department of Corrections, would they then the local unit of government would then not be able to provide them with any kind of a tax break? Is this correct?
Senator from Reno.
This just applies just strictly to these homes that are built into this program. They're in Hutchinson, and actually is Interfaith. They actually have had, in the past, they've had ARPA funds and to do housing projects, and the county required them to put those on the tax rolls as well, because it gets to be quite a burden on the community if you get all these houses that aren't paying property taxes. And so this just goes along with what is already being done there.
Senator from Wyandotte.
Thank you for that clarification. So I am not certain where I see that this just applies to Hutchinson.
Senator from Reno, care to respond?
All I know is this is what we asked for the revisor to apply to strictly this program that has a three-year sunset. So it's strictly these houses.
Senator from Wyandotte.
And I appreciate the information, but could the senator from Reno, so this program dealing specifically with these homes is only going on in Hutchinson? Is that what I was not aware of?
Senator from Reno.
That's correct.
Senator from Wyandotte.
Thank you.
Further questions on the amendment? Seeing none, you may move your amendment.
I move my amendment.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. We are back on the bill. Any further questions for the senator from Cali? Chair recognizes the senator from Sedgwick, Senator Faust-Cadeau.
Thank you, Mr. Chair. So my question for the senator carrying the legislation is, so in committee, did we address the concern from the manufacturing housing that they were concerned that it would the original bill would create competition? Did we address that concern? Thank you, Mr. Chairman.
Senator from Cali.
Thank you, Mr. Chair. Yes, we did. We heard their concerns. Our concerns were competition. We solved that by making sure that the wages that they were billed back to the from the inmates that are working on the program would be competitive wages. We also said that the price that they would lease the facility for would have to be the average commercial rate, and they would be required to carry insurance while they're producing these houses. So it is. I think we took care of most of their concerns, and they I think, came to a neutral on the bill.
Any further questions? The chair recognizes the senator from Montgomery County, Senator Peck.
Thank you, Mr. Chairman. No matter what anyone says, this is government competition against private industry. We have got in this legislation authorization for a correctional facility to build manufactured homes. We have a manufactured homes industry in Kansas. pretty vibrant one. Do a good job. Not saying that these homes built at the Hutchinson Correctional Facility will not be quality. I don't know. I don't know if they're going to be a certain brand name, if they're going to be working with a certain manufacturer, or there are a lot of unanswered questions. I do understand that the manufactured housing industry went from a solid opponent to a, well, okay, we'll let this one go. That doesn't mean that it's the right thing to do. So I had asked some questions in caucus. I have not gotten an answer, so I'm going to ask again. I do know that the inmates in the facility will be working for a private entity, but I would, Mr. Chairman, ask the question of the carrier, is this private entity a current manufacturing home entity, such as a Skyline in Arc City or Clayton Homes, and I could name on and on.
Senator from Cali.
Thank you, Mr. Chair. We have not received, or I have not received during the hearing, who the manufacturer, the contractor would be. I've heard Interfaith Ministries Homes, but I do not have the identity of that manufacturer at this time.
Senator from Montgomery.
Thank you, Mr. Chairman. So we don't know who's going to be operating. Is this going to be someone that just decides, you know, this is a good opportunity. I think I'm going to start a business and I'm going to have manufactured homes manufactured at a much lower cost, because I'm confident, Mr. Chairman, that the manufacturing businesses are paying more than $20 an hour, probably more than $25 an hour, probably closer to 35 or 40 to manufacture these homes. So that's disconcerting to me. These homes, once they're built, will they be sold at a competitive price with other manufacturers, or are we going to be selling them significantly under market value?
Senator from Cali.
Thank you, Mr. Chair. Well, let's start with the program itself. Today, the inmates from, I think, well, let's just use Winfield. The inmates of Winfield are working in the manufacturing home facility in Arc City. They're being paid the prevailing wage. They're on a work release program. They have to pay the prevailing wage. The thing they don't pay would be, number one, their health insurance, number two, any retirement. But they're paying the same wages. That's question number one. So this is being done in the manufacturing housing industry today on a work release program. Number two, the question about, well, give me the second question, if you would. Tell me the second question again.
Senator from Montgomery.
Thank you, Mr. Chairman. The second question is the finished product, the home. And I'm presuming they have the appliances in the home. Otherwise, it's not a true manufactured home, because all manufactured homes come with appliances. But the finished product, will it be priced very competitive with other manufactured homes? Will it be priced lower?
Senator from Cali.
We did not consider price on these homes. We weren't given a price on the home. All we were given was these would be able to be manufactured in an existing facility, not a new facility, in the Hudson area only. And they would be at a competitive price as far as their labor that they would have to charge. And with that, I don't know what the appliance brand will be in that, so I don't have those details, and they didn't give us those details. But like any manufactured home or regular home, the stick-built home, you have a lot of options. So I would assume they would also have options with them.
Senator from Montgomery.
Thank you, Mr. Chairman. I could ask multiple questions, and I won't. I'll just ask one more. When you go to purchase a manufactured home, you can go to the lot, is what I'm going to call it, go through several homes, but then you can customize somewhat the home that you are going to purchase, or the one that you want. Will these just be sort of stamped out homes, or will the builders, the manufacturers in the facility, in the correctional facility, be allowing for the customer to go ahead and say, well, I want it this particular design, I want to move this wall a foot this way or that, or is it just going to be, if you will, sort of a stamping out of homes?
Senator from Cali.
Thank you, Mr. Chair. These homes, again, have not been identified. The reason that this bill was brought forward is because the prison used to make cabins for our different state parks, and that was stopped several years ago. This gives them the authorization to begin again. But as far as the details, the carpet color, the paint color, the tile on the wall, I don't have that information.
Senator from Montgomery.
Thank you, Mr. Chairman. I'm not going to ask additional questions, but this legislation just doesn't pass the smell test for me. Government competing against private industry, private jobs. And I have no problem with inmates from a correctional facility being on a work release going to the location to build the manufactured homes. But when we, as I understand it, are now going to be manufacturing these homes within the walls or the fences of a correctional facility using strictly inmate labor, it just doesn't seem right to me for us to be allowing for, again, government-held individuals to compete against private industry. So I'm going to be a no on this legislation. Thank you, Mr. Chairman.
Further questions? Chair recognizes the senator from Harvey, Senator Owens.
Thank you, Mr. Chairman. I can very much understand where the senator from Montgomery is coming with his concerns. A couple of points I want to point out. First of all, manufactured housing is the only private industry that is excluded from working within our prison system. Currently, working within our prison system are companies, and the list is long. You can Google Kansas Private Industry Prison Partners and find this list. That's what I did, right on the KDOC website. So currently operating in our facilities is Aramark, Barkman Honey, Blue Hill, Cal Maine, Creekstone Farms, Electrics, Evergreen, Great Plains, Kansas Protein Foods, Kirby Cattle, Martin Machine and Welding. Let's see. It says the NFL even, although maybe it's not the National Football League, although that would be a pretty good football team, I imagine. Mill Creek South, Pioneer, PKM Steel, Polo, Russell Stover even is inside the Topeka Correctional Facility. Seat King, hold on, that's Skyline. Doesn't Skyline build manufactured? I don't know what Skyline does at Winfield Correctional Facility, but they're currently operating inside of Winfield. WIFCO, Wilkins, Zephyr, and the list just goes on and on. Private industry within our prisons is an incredibly important part of preparing inmates to exit with a skill set. I would also like to add that in this legislation specifically, because again, all we're doing is removing the single carve-out that blacklisted manufactured housing. That's all we're doing here, and adding guardrails on how it can come back into the prison. It says the secretary shall establish and maintain the pilot program, that they should receive certificates when so doing, but more importantly, for any such contract, the secretary shall charge the regional average commercial rate for rent on the square footage, as well as the appropriate wage set for the skill level and levels to be used for the project. For any such contracts, the secretary shall require the private industry pay all costs associated with the project, including but not limited to utilities, startup costs, project costs, on and on and on. What I'm trying to drive the point home here is, while I understand the concerns of competition of private industry, once this pilot program, assuming this pilot program is successful, nothing would stop any other manufactured home facility from utilizing this exact same opportunity within a facility in one of their areas. So I just wanted to add a little bit of color, a little bit of context. The private industry in our prisons, one, is essential. It pays a living wage to these individuals that are preparing to exit. They only get these jobs if they are in good behavior, following their programming, doing the things they want to do. It's an incentivization for them to act appropriately, do what they need to do. 25% of their wages goes back to the prison, offsetting the cost of their health care, their lodging, and everything else while they're there. 10% of that money goes into a savings account to ensure that they have money when they are released. They're able to pay their court costs, fines, and fees through these private industry, their child support back home through this private industry. Private industry is essential in our prisons, Mr. Chairman, and I would encourage everybody to take a deeper look at this bill and recognize that the committee has done really good work putting the appropriate guardrails to ensure we're not competing in a way that is unfair to private industry. Thank you, Mr. Chairman.
Any further questions? Chair recognizes the senator from Sedgwick, Senator Faust-Cadeau.
Thank you, Mr. Chairman. I too want to rise and support again for the legislation. I initially had the concerns about the competition and about the inmate service, but again, we have passed legislation to help our inmates that are being released go to work release centers, have jobs, be able to add to the tax base, provide for their families. And I've actually heard since that hearing, I've heard from, I heard from a family, a young lady that was in the Topeka Women's Correctional Facility, and she worked outside at the M&M company, and actually she got permission to not return home to Wichita, but she wanted to stay here in Topeka to keep that good job. And so, again, my concerns were addressed with those inmates being able to earn a wage. And so I think it's a win-win, and so I rise in support. Thank you, Mr. Chairman.
Any further questions from the senator from Cali? Chair recognizes the senator from Sedgwick, Senator Erickson.
Thank you, Mr. Chair. Just a quick question. I truly believe in the dignity of work and helping these inmates acquire skills that they can use when they're released. But I do have a quick question. What is the process for determining which private business is allowed to go into these prisons and have a program like this?
Senator from Cali.
Previously, as I said, they had a program in our prisons to build cabins for our state parks. And I don't know the background behind that, why that was stopped, but this program here will allow the inmates to learn a skill. And this skill that can then take after they're released, and they can get a wage, they can have a job out there. But I don't have an answer for the good senator.
Senator from Sedgwick.
Yeah, I want to support this, and I think it's a great idea. I just don't know the detail. I would be very curious to know how it's determined. What is the process for determining which businesses can partner and do this? What if you have competition? I just don't know the process for determining who gets to partner with the prison and take part in this program and who doesn't. Thank you, Mr. Chair.
Senator from Cali, care to respond?
Yes, thank you. As you may know, in Winfield, we do have a minimum security prison in Winfield. We had a balloon manufacturer that worked inside the facility there. We've got other manufacturers that work inside of the facility. Right just north of the facility was a milking operation to milk cows 3 times a day. They wanted to get the prisoners and bring them across over there and let them do the milking on the early shift. And that was stopped by the warden. That wasn't what he wanted them to do. So I don't know what the process is. I do know with this legislation, that would allow them to put in manufacturing housing back into this, the same way they're manufacturing other products. So with that, there's no further question.
Chair recognizes the senator from Johnson, Senator Gossage.
Thank you, Mr. Chair. I'm just following up of a question from another senator. And again, I've visited our prisons where people will put in a bus, go to Russell Stover's, work, earn a living wage, come back, they're able to save that money. I think that's terrific. But they're not going somewhere else to make chocolates to compete with Russell Stover's. So that's the concern that I have, that was brought by another senator, that they are manufacturing something that could compete with private enterprise. All of the other ones that are mentioned, they are basically working for this enterprise. So could that be addressed, please?
Senator from Cali.
As I mentioned earlier, in the Skyline Manufacturing Homes in Ark City, Kansas, they manufacture homes. They're sold all over the United States, or in the Midwest, I should say. And in their factory, they have, I know the last time I heard, about 30 inmates with a work release that are working in there, getting the prevailing wage, and they are working in the factory in Ark City, but they bus back and forth every day to the prisons.
Senator from Johnson, Senator Gossage.
So to clarify, then they would be working for a private enterprise, which would be Skyline. Is that correct?
Senator from Cali.
My understanding is there will be a contractor that will be assigned. They will be given a contract to build these homes. They're given the authorization to build the homes inside the facility. They will be charged a prevailing wage. It will be required to pay the same as a commercial rate on the real estate. And so that will be a contractor. They will be responsible for everything. The prisoners would be doing the labor.
Senator from Johnson.
So then not necessarily Skyline, but an industry that could bid on this.
Senator from Cali.
That is correct.
Senator from Johnson.
Thank you very much, Mr. Chair.
Any further questions from Senator from Cali? Seeing none, Senator, you may close.
Thank you, Mr. Chair. I move that when the committee rises and it reports House Bill 2596 as amended, favorable for passage.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. We will now turn our attention to House Bill 2573. Chair recognizes the senator from Sedgwick, Senator Erickson, to explain the bill and adopt the committee report.
Thank you, Mr. Chair. I move we adopt the committee report.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. You may continue.
Thank you, Mr. Chair. The American Institute of Certified Public Accountants has reported that 75% of CPAs will retire in the next 15 years. To help address this, House Bill 2573 amends law related to licensure of certified public accountants by creating an alternative set of qualifications and by extending recognition of CPAs licensed in other states if these qualifications are met. Currently, to become a CPA in Kansas, you have to have a bachelor's degree in accounting plus 30 additional credit hours or a master's degree and at least 1 year of work experience under a licensed CPA and pass the CPA exam. What this bill would do would say you could pursue a CPA if you complete a bachelor's in accounting, work at least 2 years under the supervision of a CPA, and pass the CPA exam. More than 20 other states have adopted similar pathways, and with that, I'll stand for questions.
Are there questions for the senator from Sedgwick? Seeing none, Senator, you may close.
Thank you, Mr. Chair. I move that when the committee rises and reports, it reports House Bill 2573 favorably for passage.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. We will now turn our attention to House Bill 2481. Chair recognizes the senator from Leavenworth, Senator Klemp, to explain the bill and adopt the committee report.
Thank you, Mr. Chair. I move that we adopt the committee report.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. You may continue.
House Bill 2481, as amended, would require transient guest taxes to be collected for lodges of 1 or more bedrooms, and between May 15th, 2026 and July 25th, 2026, require the collection of transient guest taxes for any short-term rental or vacation unit, and prohibit city and county governments from limiting the number of permits or other authorizations required for the operation of such units. During this time, a municipality would be required to process the issue and respond to a completed application to operate a short-term rental or vacation unit within 15 days, or be automatically deemed to be approved and no additional regulation or code requirement by the municipality as a condition of approval would be permitted. I stand for questions.
Other questions for the senator from Leavenworth? Seeing none, Senator, you may close.
Thank you, Mr. Chair. I move that when the committee rises and reports, it reports favorably passage of House Bill 2481.
You've heard the motion. All those in favor say aye. Those opposed, no. Motion carries. We will now turn our attention to House Bill 2781. The chair recognizes the senator from Harvey, Senator Owens, to explain the bill.
Thank you, Mr. Chairman. House Bill 2781 would authorize the Kansas State Historical Society to acquire from the Kansas Office of Veteran Services the junior officers' quarters on Fort Dodge, and would designate the junior officers' quarters as a historical landmark and authorize the Kansas State Historical Society to adopt the necessary rules and regulations to manage that facility. Ultimately, as I understand it, this was brought to us by the representative from the area that the Veteran Services wants to basically gift over this to the Historical Society. Historical Society would then invest some resources and then manage that as a historical structure. And I'll stand for questions.
Questions for the senator from Harvey? Chair recognizes the senator from Wyandotte County, Senator Haley.
Thank you, Mr. Chair. And I've been waiting for an amendment. I thought there might be longer discussion or debate previously, but I think it should be up. It's a very short amendment. It should be here soon. Would ask if this might retain its place when we return to it. It should be here shortly.
Very well. We will pass over House Bill 2781 and reserve its place. With that, we will now turn our attention to House Bill 2114. The chair recognizes the senator from Montgomery, Senator Peck, to explain the bill and adopt the committee report.
Thank you, Mr. Chairman. I move adoption of the committee report.
You've heard the motion. Those in favor say aye. Opposed, no. Motion carries. You may continue.
Thank you, Mr. Chairman. What House Bill 2114 does, it clarifies which structures will be considered water structures and not a dam, and it establishes some new application fees for a permit to construct, modify, or add to a dam. Requires some pre-construction permits. And it also allows a licensed professional engineer to inspect the dams versus a government engineer, as long as the person having the dam inspected is good with the inspector they're using. We have in Kansas, one reason this is important, by the way, this has been a bill that's been being worked on for a long time. It took a lot of stakeholders getting together and everyone compromising some, but in Kansas we have 6,490 dams, which is second highest in the United States. Of those almost 6,500, over 2,500 are state regulated, and that includes some 328 high hazard dams, as well as 176 significant hazard potential dams. So having a large number of dams in the state of Kansas is important to ensure that the state effectively manages its inventory and protects public safety. In the legislation that came over from the House, there were some pretty significant fees that we had. As a matter of fact, some of the fees were in the thousands. We dropped them back down from, they're currently in law, $200. We changed them to $500 and made it one fee versus different fees for different dam classes. That didn't sound very good. Classes of dams, I'll put it that way. And with that, there's a lot that I could say, but it's not one of those issues that is probably going to garner a lot of attention from the legislature, but it is vitally important to the stakeholders and the groups that have been involved with putting this legislation together. And I appreciate the efforts of a couple of my committee members, particularly, who brought some amendments to the committee and got some language together with the stakeholders. So I think we're good to go. I'll be glad to stand for questions, Mr. Chairman.
Are there questions for the senator from Montgomery? The chair recognizes the senator from Jackson, Senator Bowser.
Thank you, Mr. Chair. And I just want to emphasize some of the things that the carrier of the bill said. I serve on the Ag Committee, and I rise in support of 2114. And I just want to give the body some context on this bill. Again, this is, as the carrier said, this bill has been incubating for years. I bet somebody this morning I'd be able to use the word incubating. But this bill's about dam safety. And when it comes to the Senate Ag Committee, as the carrier said, there were a lot of concerns with this bill. And I want to commend the Ag Committee again. And I also want to commend the senator from Dickinson, Senator Hill, who's not even on the Ag Committee, but who worked diligently with a number of stakeholders. The bottom line here is that we had to work with our watershed districts. We had to work with our farmers and ranchers. We had to work with the Department of Ag, Division of Water Resources. And again, we brought everybody together. We hashed out those differences. As a result of that work, there were some significant amendments that came forward, and we were able to move the opponents to neutral, and the neutral folks went to positive proponents. So a real good example of how to move a bill forward. And it's about, 2114 is about doing the basics right when it comes to public safety and water infrastructure. Dams and watershed infrastructure are critical to our state. They protect property, they support agriculture, and they manage floodwaters. This law updates kind of our current law with some modern standards and brings some clarity and consistency to the system. Urge passage of House Bill 2114, Mr. Chair. Thank you.
Chair recognizes the senator from Dickinson, Senator Hill.
Thank you, Mr. Chair. This has been a really good experience to work with the chair of Ag and the many stakeholders and getting together legislation that really balances the needs of industry and the desire to promote safety and control by the state. And as we went through that process, it became clear coming out of committee that we had an overlook in some of the language. And so with that, I have an amendment.
Have you turned in your amendment, Senator?
I have.
What is the number?
It is 4468.
The amendment appears short. Would you like to explain it, Senator?
I would like to explain it. It's a very short amendment. There's actually 3 strikeouts in it. It strikes out 3 proposed changes and a fee increase on the 4th page of the bill. It strikes out a $200, a $400, and a $1,000 fee.
Will you stand for questions on your amendment?
I stand for questions.
All right, questions for the senator from Dickinson. Senator from Montgomery, Senator Peck.
Thank you, Mr. Chairman. It looks like the amendment takes out the amendments that the House had put in or that had come over from the House as it relates to the increase in the construction permit fees, because in current law, they're 100, 200, depending on the size of the water, and 500. And as it came over to the House, it was double that. And this looks like it just takes it back to the current law. So I think it's probably a good thing. It saves money, reduces fees, which as a conservative, I kind of like the idea. But I'll leave it up to the will of the body, but I'm going to be voting for it.
Further questions on the amendment? Chair recognizes the senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. I believe I understand the intent, but in the testimony, this is setting a different fee for a application when that the application is made after the dam has already been constructed. Right now, you can get a permit application fee for $100 if it's less than 5 square miles, but only if you ask for that application before the dam is built. And it is more expensive to try to inspect a situation when you're not seeing it before any construction started. So why would the senator not want to, the senator from Dickinson, not want to differentiate between applications fees that are applied for before construction from those applied for afterwards?
Senator from Dickinson.
Thank you, Mr. Chair. Yeah, I appreciate that question. It's a insightful question. However, the category that these fees are for, it's not because they're requested after the structure is built. It's for a different type of structure. It's a structure that's considered an obstruction of a stream rather than a dam. It fits into a different category, and so these particular structures are feed differently because of that.
Senator from Douglas.
I understand the fees are different, but the numbers that the senator is asking to have struck from this bill are just the ones that are post-construction permit fees. So again, so he's saying you can't have post-production construction permit fee. Why would we not, again, why would we not want to? They are different, the fees are lower or were lower. Why would we not want to allow that post-construction fee?
Senator from Dickinson.
Thank you, Mr. Chair, and thank you for the question. It has to do with the type of structure, the fees that you have to get for, or the fees you have to pay for what is considered a dam. Have to watch the spacing on that. It is done prior to the construction of the dam. For an obstruction in a stream bed, it is done after the structure is already in place.
Senator from Douglas.
Why would you make an application, or why could you not make an application before you are adding a water obstruction or changing or diminishing the course? Why would you, how can you tell that that's been added if you aren't asking for the application before?
Senator from Dickinson.
Thank you, Mr. Chair. It has to do with whether you have to have an engineering report submitted. I mean, you could ask for the permit or the after construction permit, I suppose, at any time, but you don't have to have an engineering report on these lesser structures.
Senator from Douglas.
Thank you, Mr. Chair. I do understand you may not need that same engineering report, but we're leaving in the $100, the $200, and the $500 fees for these same structures?
Senator from Dickinson.
Thank you, Mr. Chair. That is correct.
Senator from Douglas.
So what's the differentiation then between the $100 and what you're trying to strike in terms of $200? They refer to the same permits to construct, modify, or add to a water obstruction.
Senator from Dickinson.
Thank you, Mr. Chair. That is correct.
Senator from Douglas.
I was asking for what is the difference. I'm assuming this will go to conference committee. I hope to have a chance to talk with the senator from Dickinson a bit more, but the testimony in committee, and I did ask about this particular portion of the bill, was just having a more expensive inspection if it's after the construction has already been done.
Senator from Dickinson, care to respond?
Thank you, Mr. Chair. Yes, I'd be glad to visit more about it, and there has been some confusion on this particular section. Thank you.
Chair recognizes the senator from Finney, Senator Clifford.
Yes, thank you, Mr. Chairman. Appreciate you keeping an eye on the proceedings this afternoon. You know, we don't have much water out in western Kansas, and I figured if I talked about it, we'd get a little bit of rain maybe by the time I got home. But mainly, you know, I hate dam fees, so I'll be supportive of this amendment.
Any further questions for Senator from Dickinson? Senator from Montgomery, Senator Peck.
Thank you, Mr. Chairman. Not a question, but in looking closer at the amendment and what it is striking, it's clear that there was an additional fee put on the legislation, a post-construction permit fee. Now, I have no idea what on earth would be a post, which means after construction permit fee, or why would you need a permit after the construction, I'm guessing, is completed. And so what he is striking is the post-construction permit fee. I think it's the right thing to do. If it's not, we do have conference committee coming up. So again, I'm still going to say that this is a good amendment. Thank you, Mr. Chairman.
Further questions? The chair recognizes the senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. I think something has been changed in a water, a river or another water feature, and someone has constructed, modified, added a water obstruction, changed or diminished the course, current, or cross-section of a stream. So they have affected that water course. The intent is for someone to apply for permission before you do that and get a permit. But if it's found that you've already done the construction, then they're still wanting to review that change. And it may be that it's a change that has to be taken out or removed. Again, it's probably more expensive. This was a request from the Department of Agriculture, and I think it's appropriate. Thank you.
Further questions on the amendment? Seeing none, Senator, you may move your amendment.
I move the amendment.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. We are back on the bill. Further questions for the senator from Montgomery? Seeing none, Senator, you may close.
Thank you, Mr. Chairman. I move when the committee rise and report, report House Bill 2114, favorable for passage as amended.
You've all heard the motion. Those in favor say aye. Those opposed, no. Motion carries. We will now turn our attention to House Bill 2466. Chair recognizes the senator from Harvey, Senator Owens, to explain the bill and adopt the committee report.
Thank you, Mr. Chairman. I move adoption of the committee report.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. You may continue.
Thank you, Mr. Chairman. House Bill 27, excuse me, let me go to the next bill. How about we do House Bill 2466, would extend the sunset for the angel investor tax credit. The title shows that it is extending it to 2031. However, it was amended in committee so that it is extended only through 2029. In addition to amendments made in Commerce Committee required a portion of the credits, 25%, to be more specifically available to rural Kansas first, instead of them all being utilized only in our urban areas. The Angel Investor Tax Credit is a very important tool that is utilized throughout the state of Kansas for up-and-coming tech type of companies or bioscience or other companies. Let's see, the investors, KAITC, the Angel Investor Tax Credit, makes early stage investing more accessible by reducing tax liability when an individual supports a qualified Kansas business. Thus far, the Kansas Angel Investment Tax Credit has created 2,116 direct jobs, retained nearly 800 positions, assisted in raising over $450 million in capital in Kansas companies. It does a number of other very important things in helping our startup ecosystem be able to thrive. And so, Mr. Chairman, I would stand for questions.
Are there questions for the senator from Harvey? Seeing none, Senator, you may close.
Thank you, Mr. Chairman. I move that when the committee rises and reports, it report HB 2466 favorably.
You've heard the motion. All those in favor say aye. Those opposed, no. Motion carries. We will now turn our attention to House Bill 2528. Chair recognizes the senator from Johnson, Senator Gossage, to explain the bill and adopt the committee report.
Thank you, Mr. Chair. I move we adopt the committee report.
You've heard the motion. All those in favor say aye. Those opposed, no. Motion carries. You may continue.
House Bill 2528 would amend the statutes regarding the Board of Nursing. On September 8th of 2025, the House Oversight Committee heard numerous testimonies over 2 full days, reviewed hundreds of pages of documents. They heard testimony such as since 2005, well over 3,000 Kansas RNs, LPNs, and APRNs have been reported to the National Practitioner Data Bank for adverse actions regarding licensure and reinstatements, resulting in a permanent scarlet letter on the careers of those nurses. Many of those nurses should never have been subject to discipline from KSBN, according to the testimonies. That scarlet letter would put a permanent stain on their record, saying things such as practicing without a license or unprofessional conduct. So on September 2025, after the committee concluded, they approved a resolution that found, among other things, and I quote, "Whereas the committee finds that in too many instances, the nursing board has applied the laws, regulations, and policies in ways focused on punishing innocent mistakes that do not adversely affect patient care, rather than in helping good nurses remain important contributors to the health of Kansas. Whereas the Oversight Committee believes that the relicensing process in Kansas, as currently administered, is contributing to a nursing shortage in Kansas and to unfair treatment of nurses. Therefore, the committee believes that fundamental change is needed in the laws, regulations, and policies governing the relicensing of nurses in the state of Kansas, as well as the administration of those laws, regulations, and policies by the nursing board," and I end quote. Thus, we have the bill, House Bill 2528. So regarding the problems that they heard in testimony over disciplining licensees for clerical errors and non-practice issues, excessive punishment, over-reporting to the national databases, and more, in this bill, it will void disciplinary record for non-practice matters and prohibit discipline for errors in license and renewal applications, while maintaining a discipline action in force for cases involving practice violations, crimes, abuse, or other high-risk matters that could harm patients. The Oversight Committee also heard about vindictiveness of the board toward licensees. Therefore, in this bill, there is civil cause of action for licensees to protect from retaliation from the board based on the Federal No Fear Act. They also heard that there was no grace period for any missed renewal deadlines. This bill does address this. On the House side, they gave a 90-day grace period. This was reduced by amendment in the Senate to 30 days in the bill. The bill also adds a $300 late fee for renewals submitted after the renewal date. They heard of board misbehavior and closed board selection process. Excuse my tickle. So this bill would allow removal of board members for cause, requires Senate confirmation of the governor's board appointees. They heard of a lack of transparency regarding board policies and their communication with us, the legislature. This bill would require publication of board policies and notifications to licensees of the board's proposals to the legislature. No refunds for overpayments and duplicate payments for licensing. They claim that they lack statutory authority to refund licensing. This bill gives the board that authority by expressly authorizing refunds where warranted. It leaves discipline cases open indefinitely. We heard of some cases that were still pending after 5 years. This would require inactive discipline investigations to be considered and closed within 22 months. Finally, it prevents nursing schools from withholding transcripts to delay the NCLEX testing. There were lots of amendments, Mr. Chair, on both sides in both the House and the Senate. The Senate amended the bill, for example, to allow the board 6 months to make changes to the records of the nurses who have been affected. Our hope is that they will take immediate action on correcting these issues. And we had proponents, of course, from Representative Pickard, the Midland Care Connection, as well as American for Prosperity, Representative Carmichael, Kansas Advocates for Better Care, Kansas State Nursing Association, Pacific Legal Foundation, and 25 or more private citizens. Opponent testimony came from the executive administrator and the director of operations of the board. With that, I'll stand for questions, Mr. Chair.
Are there questions for the senator from Johnson? The chair recognizes the senator from Johnson, Senator Sykes.
Thank you, Mr. Chair. We have a member who has an amendment, and she's in conference committee on the budget, so asking that we pass over this.
Very well. We will pass over House Bill 2528 and come back to that when the amendments are ready. Body will now turn our attention to House Bill 2521. Chair recognizes the senator from Johnson, Senator Rose, to explain the bill and adopt the committee report.
Thank you, Chair. I move we adopt the committee report.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. You may continue.
Thank you, Chair. House Bill 2521 would provide legal protection through the Kansas Tort Claims Act for child placement agencies that contract with the Secretary for Children and Families to place Kansas foster children into foster homes. This is of urgent importance because the liability market, insurance market for these providers has collapsed nationally, resulting in high liability insurance premiums that are putting child placement facilities at risk of closure. Frankly, we cannot afford to lose any of these important facilities. House Bill 2521 provides an effective solution to this critical problem, as it would offer child placement facilities legal protection through the Kansas Tort Claims Act. This would provide immediate relief with insurance premiums while still keeping Kansas foster kids safe. This would not be the first time for private contractors to receive this legal protection, as according to the KDHE website, KU Med students doing their clinical work, employees at prisons and juvenile corrections, mental health workers, and court-appointed guardians are already protected under the Kansas Tort Claims Act. If these other private contractors are protected, it makes all the sense in the world for child placement agencies who are contracted with the state to be protected as well. This bill does not eliminate accountability, but it will enable child placement centers to continue providing their state contracted services at a high level. If we don't pass this legislation and these private centers go out of business, the work will return to the state to be done by state employees who will have the same legal protections that this bill would grant private child placement centers today. Please support this bill so we can keep private child placement centers and all of the valuable services they provide foster kids in Kansas. I move that I stand for questions.
Jumping the gun just a little bit, Senator. All right, are there questions for the senator from Johnson? The chair recognizes the senator from Johnson, Senator Corson.
Not so fast, good senator. But no, I'll be brief. It was very well explained, and I do think that there is a very serious challenge being presented here, which the good senator explained. But I do think we need to be cautious when we are providing these sort of essentially immunity protections for providers. And really, I think what came out of the hearing is that essentially this is, as was mentioned, really an insurance issue more than anything. This is really an issue of making sure that these providers are able to get the kind of coverage that they need to operate. It's something that we talked about as a committee. We didn't necessarily have the bandwidth to really go full as deep as we might have liked into the insurance piece. So with that, I have a brief amendment. I have turned it in. And
What is the number?
25, I'm sorry, not 25, 4503.
All right. Just hold a minute while we get that available to everyone. The amendment appears short. Would you like to explain your amendment, Senator?
Thank you, Mr. Chair. This amendment would change nothing about the bill other than it would provide a sunset of December 31st of 2027. The reason I wanted to bring this is that this will hopefully create a period where these providers are able to get the insurance coverage that they need, but also at the same time allowing the legislature to take a deeper look at the insurance issues that were presented by the committee. I think it'd be appropriate to have an interim take a look at this and try to better understand it. And then the legislature, when we come back in 2028, could make a decision that they wanted to extend this, the sunset, that we wanted to approach this issue differently based off a more in-depth study of what we learn during the interim. So again, all this is a sunset of December 31st, 2027. And with that, I would stand for questions.
Questions on the amendment? The chair recognizes the senator from Dickinson, Senator Hill. Very good. The chair recognizes the senator from Sedgwick, Senator Clays.
Thank you, Mr. Chair. I 100% agree with this amendment. And in fact, if this amendment passes, I will be able to support this bill. I mentioned in caucus that I had some misgivings about providing sovereign immunity to private companies. But of course, we do have an issue with the insurance. It just feels like this is a heavy issue. And as mentioned, the bandwidth we have, we weren't able to study necessarily all of the many different ways maybe we could have solved this problem. I was reading up recently about how Florida was handling it and some others, but again, you know, these kinds of things take time to really flesh out all the details. So I agree, this would give us the time and also would give them the relief during that time where we can study this more thoroughly and make a good decision for our kids in this state as well as the providers. I just want to remind everybody that foster children are the most vulnerable population in the entire state. They don't have lobbyists, they don't have trade associations, they only have the courts, and this bill could potentially be diminishing that one avenue of accountability that's available to them. Thank you.
Further questions? Chair recognizes the senator from Johnson, Senator Rose.
Thank you, Chair. I would leave this amendment up to the will of the body. This issue is of critical importance. Time is of the essence. We need to act this session to provide liability insurance relief to these child placement agencies. There will be discussions in the interim whether or not we do this amendment. So it's really up to the will of the body.
Further questions? Chair recognizes the senator from Johnson, Senator Sykes.
Thank you, Mr. Chair. I too stand in support of this amendment, and I think this is an insurance issue, and we need to make sure that they're able to get the coverage that they need. So I'm hoping that this amendment gets on, and also hoping that the LCC, the Legislative Coordinating Council, will call for an interim committee over the summer so that we can look at this and address it and be more reasonable in our approach. Thank you.
Further questions? The chair recognizes the senator from Potawatomi, Senator Titus.
Thank you, Mr. Chair. I would just share the sentiments of Senator Clays, and if this amendment is adopted, then I'll move from a no to a yes on the final bill as well.
Further questions on the amendment? Seeing none, you can move your amendment.
Thank you. As one of my good colleagues said, the breathing room, I think that's the right term. I think this will hopefully allow these providers, we obviously want them to be able to continue to operate. They've raised a real issue. The carrier did say time is of the essence. I agree with that. So this will be able to hopefully ease some of the pressures that they are facing with respect to insurance coverage, but also give us as a legislature the ability to both see how this solution works and whether we want to extend it, or upon further review, if there's maybe a different approach that the body would like to take. So with that, I would move my amendment.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. We are back on the bill. The chair recognizes the senator from Dickinson, Senator Hill.
Thank you, Mr. Chair. I stand in support of this bill, even as amended, or maybe especially as amended. But a little bit of history, if you go back into the 90s, we were a state-run foster care system, and it was fraught with problems. And the solution that came up was to privatize that system, and the privatization of that system has worked really good. And I think it's important to know that these agencies that we're talking about are not actually providing the foster care, they're contracting with foster care providers. And so they take away a job that had been assigned to the state previously. And I think it's important that we don't go back to a state-run system that is not feeling, does not care, and ends up putting kids in bad situations. And I think this bill is an excellent way to provide some protection for those entities. And we are losing them because of what everybody's saying, insurance. It is an insurance problem. And this is a way of addressing that insurance problem by giving some limited protection to those groups. And so I stand firmly in support of this bill and encourage everyone else to as well. Thank you.
Further questions for the senator from Johnson? Seeing none, Senator, you may close.
Thank you, Chair. I move that when the committee rises and report House Bill 2521 favorably for passage.
As amended?
As amended. Thank you.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. Body will now turn our attention to House Bill 2527. Chair recognizes the senator from Johnson, Senator Warren, to explain the bill and adopt the committee report.
Thank you, Mr. Chair. I move we adopt the committee report.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion passes. You may continue.
Thank you, Mr. Chair. So this bill deals with placement by a court, by a judge, upon conviction of a crime. So when the court adjudges you to be guilty, the court has several options. The court can commit the defendant to the custody of the Secretary of Corrections, can release the defendant on probation, can assign the defendant to a community correctional services program, can assign the defendant to a conservation camp, assign the defendant to a house arrest program, order the defendant to attend and satisfactorily complete an alcohol or drug education or training program, or assign the defendant to a work release program other than a program that's run by the Department of Corrections. And that program would be you go to work during the day and then you return at home at the end of, or not at home, but to the work program at the end of each day. What the bill does is there was such a person in such a work release program go to work during the day, then you come back to the work release center at night. And the person was a registered sex offender and was going to be sent out on work release to a place which would be a opportunity to possibly reoffend. So what the bill does is it would prohibit a work release program such as the kind where it's not run by the Department of Corrections, work release program. If you're a registered sex offender, you won't be able to be in that type of work release program, okay? So you're not gonna be in anywhere except then these other opportunities or the Secretary of Corrections. And what it does is if you are a registered sex offender and you committed the crime when you were over 18 years of age and the victim was less than 16 years of age, you will no longer be eligible to be committed to work release run by anyone other than the Secretary of Corrections. So what the bill also does is we put into the bill in committee, if you'll remember, a bill regarding sex offenders that we passed out of this body last session. It contained a prohibition on registered sex offenders on school property. So if you had committed a crime against a victim who was less than 18 years of age, it was a sex crime against a person less than 18, and you were 18, then that bill would prohibit you from entering school property. If you'll remember, in that bill, it went to conference committee, it came back, and in conference committee, we added that the provisions of that prohibition don't apply if the person is entering school property for the sole purpose of attending a religious service, or, and we also excluded non-public schools such as home schools or micro schools, and it would only apply to non-public schools if they met more than 4 days a week. So that bill passed this chamber 36-4, and it's in a conference committee in the House. So committee determined, let's put it in with this sex offender bill so that we could address this issue and get it resolved, keep our kids, our community safe. With that, Mr. Chair, I'll stand for questions.
Are there questions for the senator from Johnson? Chair recognizes the senator from Lynn, Senator Tyson.
Thank you, Mr. Chairman. Would the carrier of the bill stand for questions?
She is standing.
Thank you. Did the carrier of the bill mention this during caucus?
Senator from Johnson.
Yes, today.
Senator from Lynn.
Thank you, Mr. Chairman. I don't think so. In fact, it wasn't mentioned because I remember last year there was quite discussion on the portion that was added to the bill that the carrier just talked about. I know we had situations in different scenarios across the state. The good senator from that covers Atchison area has a constituent that's reached out to many of us who had a son that was accused and is on the list and cannot get off of the list because once you're on the list, there is no way to get off of it. And it was a Romeo and Juliet scenario. He was over 18, she was below 18, and the parents pressed charges. So if this was to become law, he would never be able to go to any of his children's activities in the school. Is that correct?
Senator from Johnson.
Mr. Chair, before I answer that question, a point of order. The good senator may not remember what was said in caucus, but I'm not sure what to say when it was spoken about in caucus this morning. If she didn't hear it, that's one thing, but to assert that it was not mentioned in caucus when it was, I find that very troubling to be so accused here on the Senate floor. And with that being said, what was the question again?
Senator from Lynn.
So the good senator from Johnson, I apologize if it was mentioned in caucus, but I remember last year there was much debate over it. And this year, nothing hardly said at all. So I'm just surprised that, anyhow, let's move on. The question being, Romeo and Juliet scenario. He's 18, she's just under, the parents press charges, he's on the list forever. There is no way to get off that list. Would he be able to attend school functions of his children as a result of this legislation?
Senator from Johnson.
Thank you, Mr. Chair. So the bill having passed 36-4 last session, which was mentioned in caucus. If you are subject to this bill, if it were to become law, if you were over the age of 18 years when you had a conviction for an underlying crime for which the victim was less than 18 years of age, and it was a sex crime, there's a list of the crimes, you would be prohibited as provided in the bill. I do recall that last session there was some question about, well, 18 years of age, what about 16 years old, what about 17 years old? That was the debate we had last session. The bill passed 36-4. If the body would want to align this part of the bill with the underlying bill and make it so that when the victim was less than 16 years of age, that would be something that we could look at in conference.
Senator from Lynn.
Thank you, Mr. Chairman. Well, that means that the good senator is going to go to conference and not negotiate the Senate position if she's willing to come off of the age that the Senate. This is a catch-22 situation, Mr. Chairman. I just have concerns. I've heard from this gentleman from Atchison for years, and it is a heart-wrenching story, and I know there's other ones out there. Thank you, Mr. Chairman.
Further questions for the senator from Johnson? Chair recognizes the senator from Wyandotte County, Senator Haley.
Thank you, Mr. Chair. Sorry I'm late to this discussion. Finally got the amendment for another bill that came in and was perusing it to make sure we were on point. I raised some of these questions in committee, in the Senate Judiciary Committee, on this particular measure. I don't know who it was that contacted me during the interim over their concern because of not just the Romeo and Juliet, but those that are adjudicated inside of these programs, this program that we have. Kansas has, it should be noted, Mr. Chair, that we have one of the more vigorous or the more strenuous or the more, I don't know what to call it, the harshest programs for the sex offenders in the country. And the permanence of the scarlet letter from these offenses has been problematic in other areas that have come up in the legislature quite some time, most notably the distance for housing for those that are released and how far they can live close to a school or what have you, and such points that reasonably may not even affect someone, in that many of these offenders don't reoffend. I think it's less than, it's single digits. I think I heard 8% of those that are likely to reoffend after having spent a certain amount of time and have matriculated from the program. So the perennial scarlet letter and the branding can be problematic. And when we heard this bill in the Senate Judiciary Committee, I did have some questions as to whether or not we could look at the offense itself. Certainly all of us want to ensure that those violent offenders, those that have perpetrated horrible acts, sex acts, rapes, and what have you, may have to continue with the perennial stigma, even after matriculating from their time in prison. But as was mentioned during this discussion, many of these who are branded as sex offenders are often caught up in consensual acts that consensually don't count, because we as a society protect by the pure category of age, usually, although we've had it go both ways, it doesn't matter. I guess we've had the gender application either way, but under a certain age, to have a sexual relation with someone over a certain age creates the very crime in and of itself. And because of that, even with consent and even ongoing, we protect our children. I won't say overly protect, as a father of, well, they're grown now, but I remember bringing up and being concerned about the interaction that they were, 4 children myself. And I've seen and heard from so many people who continue to labor under a harsh, continuing penalty, categorization, and inability to really move back into society well after their offense has been meted out and they've served their time because of Kansas's policies. I say that to say, I had discussed in committee, in the Judiciary Committee, that we would hold those violent offenders to this higher standard, but not those who necessarily were caught up in the, quote, statutory provisions only. Didn't have that amendment here today. I did raise it in committee. As the chair might know, the carrier of the bill, the senator from Johnson, because I too have heard, in conclusion, from a very concerned grandfather, Mr. Chair, who is unable, even though this has not been implemented, there are certain jurisdictions that have already begun this practice, knowing that this bill was floating and perhaps waiting to be passed. And I wish I could pull up the email. I was trying right here to find it. It was very well reasoned and articulated. He said he can't participate or is not able to drop off, thank you, not able to drop off his, I don't know, it was his grandson or his grandchild can't go to the school because of the policy being implemented because of his status from something from 30 years ago, before he was married to his wife, the grandmother of their grandchild, before they even had the mother, or the father, I don't remember, of the grandchild, because of this status. I thought that's unduly harsh, Mr. Chair. I think there should be a level of time when we afford a parent or grandparent or legal guardian to be exempt from the bill that's before us right now. That if there is a legal parent, grandparent, or guardian, that they should be allowed to take their kid to and from school or participate in one of the activities at the school, because there is a very strong sliver of potential for any reoffense that could have been decades ago that has them so branded that they can't. So I say that to say I just hope that we could, I hate to throw the baby out with the bathwater for what has some pretty good points in this bill, but it's too harsh and it doesn't make sense. It needs to be tweaked to allow for those occurrences, real life examples where we have a parent, grandparent, or some other reasonable family member who needs to participate for transportation or otherwise, or desires to participate in their child's events at school. I hope that somehow I've brought some clarity to my hesitation in supporting this, but in real life examples, I would hope that we would look at what happens in our communities and know that some of these offenders, especially those that were the victims or the offenders of statutory, what are not Romeo and Juliet exceptions, but statutory differences that created their offense for which they served time to have occurred in the first place. Thank you, Mr. Chair.
Senator from Johnson, care to respond? Very good. Chair recognizes the senator from Reno, Senator Murphy.
Thank you, Chair. Just a quick question for the senator from Johnson. We had a private conversation a little earlier, and I thought I understood that the issues with a 16 or 17-year-old had been removed from this. Is that accurate or not?
Senator from Johnson.
Thank you for the question. The underlying bill applies to persons 16 and under, and the bill regarding school property, because it passed 36-4 with the age of under 18 for the victim, remains under 18. I'm sure if this gets to conference, there will be some discussion about Do we keep them 16 for the one and 18 for the other or not? As discussions progress, but we're not there. We're at 18, and you can't enter school property if the victim was under 18. And if folks are worried about, you know, the 16, the 17-year-old Romeo and Juliet, remember, you're not going to be on the sex offender registry because of those type of activities unless you were prosecuted for it, right? So the prosecutor is going to have to take up the case, find there are egregious facts, and decide this is one that is so bad, we're going to have to prosecute it. And going to have to get that conviction. And it's not just because someone is mad at someone else or a situation that I think you'll find in most circumstances. Of course, there are exceptions, but who are we trying to protect here? We're trying to protect kids from sex offenses, from sex crimes.
Senator from Reno.
I think that's all I need to know. Thank you.
Further questions for the senator from Johnson? Seeing none, Senator, you may close.
So thank you, Mr. Chair. Appreciate the conversation. In committee, I think last year, I don't recall, but we did hear from our prosecutors, our district attorneys, that these folks who have committed sex offenses and are on the registry actually have high rates of recidivism. We heard that from some of our victims, organizations to assist victims, that oftentimes these folks are, they are sometimes respected members of their community, but they're oftentimes grooming others to get access to additional victims. So that's what we're trying to prevent here, and that's what the bill would do. And with that, Mr. Chair, I move that when the committee rises and reports, it reports House Bill 2527 favorably for passage.
You all heard the motion. Those in favor say aye. Those opposed, no. Motion carries. Body, we are going to return to action on House Bill 2781. That was carried by the senator from Harvey, Senator Owens. Questions on the bill? Chair recognizes the senator from Wyandotte, Senator Haley.
Thank you. I appreciate the court's indulgence, your indulgence, Mr. Chair, and the body's indulgence. As mentioned, I do have a small amendment, and it has been turned in to, for 2781.
What is the number, sir?
It is 4514.
Very good. Give us a minute to get that ready. Would you care to explain your amendment, Senator, or have it read?
I will. It'd probably be quicker for me to explain it. I know the time is shorter. We're probably anxious to move forward as a body and get on out of here. This is, and by the way, I support the underlying bill. It's a great bill. It's a simple bill, the underlying bill. I'll let the senator from Harvey explain the underlying bill, which I do support regarding Fort Dodge. This is the amendment that I offer is the sum and substance of Senate Bill 290, which has sat below the calendar. It is in our book. Senate Bill 290 just allows for the State Historical Society to do a scope statement, plan the work to be accomplished, and issue requests for proposals for a master plan for the Quindaro Ruins Archaeological Park in Wyandotte County, Kansas. Again, Senate Bill 290, which is the sum and substance of the amendment in front of us now that I offer, came out of Ways and Means. It just hasn't moved above the line in a year. I'd be happy to stand for any questions.
Questions for the senator from Wyandotte. The chair recognizes the senator from Meade, Senator Reichman.
Thank you very much, Mr. Chair. And as I'm looking at this amendment, this looks like more of an appropriation. And I am, Fort Dodge is my district. And this is where talk about the Kansas State Historical Society is to acquire the Kansas House of veterans services to go by the junior officers' quarters. So I would request to check the germaneness of this amendment.
Germaneness has been challenged. Rules Committee will meet, make a decision. Chair recognizes the senator from Cherokee, Senator Schallenberger.
Thank you, Mr. Chairman, and the good senator from Dodge, can't think of, Meade, pointed out that it looked like an appropriation. That's not prohibited. It is the State Historical Society that would be relative to both of these, so the committee has decided that it is germane.
Very good. We are back on the amendment. Chair recognizes the senator from Sedgwick, Senator Faust-Godot.
Thank you, Mr. Chairman. If the question, I have a question for the senator from Wyandotte.
He is standing.
Thank you. So is this similar to a measure that we were looking at, our former deceased colleague, Marvin Robinson?
Senator from Wyandotte.
Mr. Chair, Senator from Sedgwick, indeed, there was a large amount that came. I don't know if many people here knew, but there was a state representative, Marvin Robinson, who was a strong advocate for Quindaro, the Quindaro Ruins Township. There was a large bipartisan support from the House for this measure. In his name, after he was his untimely demise. And want to again recall many of the commitments by several of the members from this chamber in bipartisan fashion, and of course from the House, who came to his services and who spoke in support of our having this and more done to give his passion, Representative Marvin Robinson's passion, which is in his former House district and certainly still in my Senate district, to finally get something moving with this. So the short answer, Mr. Chair, the senator from Sedgwick is yes.
All right, the chair recognizes the senator from Harvey, Senator Owens.
Thank you very much, Mr. Chairman. So really, it's completely up to the body of whether you want to spend $600,000 SGF to do what is provided for here in this amendment. It looks like it is to create a master plan and to do some work at the Quindaro Ruins Archaeological Park in Wyandotte County. I'm not overly familiar with it, although it's certainly been a topic of conversation over the years. So really, this is a budget question. Probably would have been a bit better suited when we were working the budget for this to come up, but it would still ultimately be decided by this body as to whether or not they felt spending $600,000 on this project is warranted. And so I will leave it up to the will of the body, Mr. Chairman.
Further questions on the amendment? Seeing none, Senator, you may move your amendment.
Well, thank you. First clarify, it's up to 250,000, not 600,000, Mr. Chair, for the study. Then the ancillary between the 250 and 600 would be because there's a well-vetted, well-developed plan for how it's to be implemented. So it's really, the initial is for 250,000. And again, this came through last year through Ways and Means, where there was a lot of discussion, for those that may recall it or not, it was very well reviewed and implemented, and then it's been, and I noted here on our calendar, just below the line. But there was a hearing, significant hearings, and it was well vetted by our own Ways and Means, and it was presented to be considered by the body after having come through committee. And I hope that we're able to do something to move it. For many years, in closing, Mr. Chair, what I think is one of the more stellar points to be visited for the rich history of Kansas. And for those who may not be familiar with Quindaro, Quindaro, there's very much history. It's endemic and close to Kansas's history. It's a beautiful story of a township, 30 seconds or less, Mr. Chair, a township that existed from 1850 to about 1875 in what's now Wyandotte County, before Kansas was a state. And it was most noted for being intercultural, interracial, that there were Native Americans that were there. There were of course, white settlers there. Of course, there were freed slaves and escaped slaves. There were even, they have said, some Latino, all living together in harmony in what is now Kansas. It's a rich history of all living together, and Quindaro's story has been told throughout the world. And indeed, in our country, it has quite a little bit of tourism, but not what it could if it were better developed. We're exceptionally proud, we should be as Kansans, of its story, and we should be doing more to enhance. We're going to miss FIFA, which really burns me up, Mr. Chair. They'll be here. We should have been doing this decades ago. And again, Marvin Robinson made this the pinnacle of his brief tenure in the legislature. He did get this through. There's bipartisan support, bicameral support in this legislation when it came out in bill form. And putting it off yet another year does a disservice to the rich history that is Kansas, you know, very close to what Kansas is. And I would hope that we could adopt it at this time and finally move this jewel forward. And with that, I move my amendment.
You've heard the motion. Those in favor say aye. Those opposed, no. The noes appear to have it. Division has been called. Those in favor of the amendment, please rise. All right, you may be seated. Those opposed, please rise. With a vote of 12 in favor, 18 opposed, the motion fails. We are back on the bill. Any further questions for the senator from Harvey? Seeing none, Senator, you may close.
Thank you, Mr. Chairman. I move that when the committee rises and report, it report HB 2781 favorably.
You've heard the motion. All those in favor say aye. Those opposed, no. Motion carries. We will now turn our attention to House Bill 2553. The chair recognizes the senator from Sedgwick, Senator Clays, to explain the bill and adopt the committee report.
Thank you, Mr. Chair. I move we adopt the committee report.
You've all heard the motion. Those in favor say aye. Those opposed, no. Motion carries. You may proceed.
Thank you, Mr. Chair. A few weeks ago, I proposed redirecting funds for public broadcasting towards transportation for Kansans with disabilities. This is a group that desperately needs transportation to get to their jobs. While it wasn't part of my debate, during the question period, I did lovingly refer to a constituency as the wine and cheese crowd. The Kansas Reflector has helpfully informed me that the wine and cheese are in fact delicious and cheap. But I would like to comment and just say that if you're drinking $17 wine, I think that you might be LARPing. Nonetheless, if you have Aspen Energy and you're on an Omaha budget, I do have a way for you to make a difference when it comes to public broadcasting. HB 2553 authorizes the Kansas PBS distinctive license plate beginning January 1st, 2027. The Kansas Public Broadcasting Council would authorize the logo, design the plate, set the royalty, and distribute the royalty payments to Kansas public television stations based on the zip code of the registered vehicle. This would be via the PBS National Streaming Geofencing System. The Kansas PBS plate is voluntary. It's a self-funding mechanism. There's no taxpayer dollars, no general fund draw, just the book fair bourgeoisie reaching into their own pockets. So listen, if you're performatively conscientious, this gives you an opportunity to financially support PBS while also virtue signaling that you support to your friends at the local fair trade coffee shop. And I have to say the Kansas PBS plate would look perfect on a late model Subaru or even a Volvo. Another tile on the mosaic of fading resist and Bernie or bust bumper stickers sitting nicely between the canonical "My Other Car is a Bicycle" and the Darwin fish. This is how it should work. You love public broadcasting? Here's the vehicle to support it. Well, it's the plate for your vehicle, which is a vehicle to support it. Nonetheless, I stand for questions.
Are there questions for the senator from Sedgwick? Chair recognizes the senator from Cherokee, Senator Schallenberger.
Thank you, Mr. Chairman. I don't have any questions. I'd hate to ask the Senator from Sedgwick a question, but I do have an amendment.
Have you turned in the amendment,
Number 4493.
Very good. Give us just a minute to get that prepared. The amendment appears long. Senator, would you like to explain your amendment?
I'd be happy to explain it. What this does is, what's the simple version of this is it sunsets all of these types of plates 10 years after they're originally approved. And the entities that have asked for these plates would come back or send a letter to the chairman of the Transportation Committee and simply say they want it to continue. The legislature would approve it, and on we go. But if it's a group that has, had great gusto when they started going to sell these plates to everyone and it didn't work the way they wanted to and it's not worth the hassle to them anymore, they will just automatically sunset. So it'll be a rolling 10 years. Everything on the books now that's 10 years older will have 1 year from the enacting date of this bill to get reapproved. Every year thereafter, every 10th year, it will be sunset.
Will you stand for questions?
Yes, sir.
All right, questions for the senator from Cherokee. Senator from Sedgwick, Senator Clays.
I don't have questions. This does no harm to my beautiful bill, and in fact, honestly, I support the idea. So, yeah, I'll leave it up to the will of the body.
Chair recognizes the senator from Barton, Senator Blue.
Thank you, Mr. Chair. I have a question for the carrier of the amendment. Do you happen to know how many distinctive license plates we have?
Senator from Cherokee.
No, I don't.
Senator from Barton.
Nope, that's fine. I just tried to count real quick and I lost count after 60. And so I greatly appreciate this amendment because we're starting to get way too many and we're starting to create them for small little things. And then I wonder if people are actually utilizing them. And I think it's a waste of government time, money, so forth. So I support this amendment. Thank you.
Further questions for the senator from Cherokee? Senator from Johnson, Senator Gossage.
Thank you, Mr. Chair. I was just curious about these. I was just told that they have to pay an upfront fee of like $5,000 to start one. If we're going to sunset it and then they wanted to continue, how would that fee process work, or would there be a fee?
Senator from Cherokee.
I don't think that there would be a fee as long as they renew before the sunset happens. So if you want to keep it going, you just have the legislature pass a bill like we do now, and away we go.
Senator from Johnson.
Thank you, Mr. Chair.
Chair recognizes the senator from Sedgwick, Senator Faust-Cadeau.
Thank you, Mr. Chairman. So when I served in the House of Representatives, I introduced a legislation to allow for the Wichita flag to be on license plates. And at that time, we required that some of the proceeds from the purchasing of those license plates go to our parks and recs. So my question for the other gentleman, the gentleman from Sedgwick, is, so are we talking about license plates just for certain entities, but would it or would not, would it not apply to what I just described of our Wichita flag on license plates, but it's, adding money back to the base? If he could clarify the tags are for which entity, that his amendment, does it affect if a city is doing this as opposed, not you, never mind, Mr. Chairman. I was speaking to the actual bill, sorry, not the Cherokee amendment. Thank you.
That's okay. All right. Chair recognizes the senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. I appreciate the intent, and I know this is an issue, but I'm reading on page 3, which starting G, which I think is the underlying statute, and it says the Director of Vehicles shall discontinue the issuance of any distinctive license plate if fewer than 250 plates, including annual renewals, are issued for that license plate by the end of second year sales, and fewer than 125 plates, including annual renewals, are issued for that plate during any subsequent 2-year period. So why would we want, since we have a way to stop the issuance of plates that are no longer, I guess, quote unquote, in demand, why would we want to start as of July 1st, 2027, discontinuing some?
Senator from Cherokee.
Thank you, Mr. Chairman, and thank you, the senator from Douglas, for the question. I don't think that the state should be continuing to issue plates for that small a number of people. That may be the current law. But the way this happens is a group will come to Topeka. Mothers Against Drunk Drivers may have a plate, I don't know. And they come to Topeka and they ask for it, and they have to put up $5,000, and they have to sell so many plates. But after a number of years, the group may be gone. They may be only selling 125 plates. And I just think if they want to have that plate continue, all they have to do is come back to the legislature, say, keep us going, and it will happen.
Senator from Douglas.
Thank you, Mr. Chair. I appreciate that response. I think another way to take care of this would be to get some more information about the number of plates that are issued and actually increase those numbers that would be required to not discontinue the issuance. Thank you.
Any further discussion on the amendment? Chair recognizes the senator from Sedgwick, Senator Miller.
Thank you, Mr. Chair. I wanted to maybe rephrase a question that was asked earlier to the carrier of the amendment. Would this sunset apply to every single personal plate, including ones that were brought from cities such as the Wichita flag?
Senator from Cherokee.
Yes.
Senator.
It's intended to. Thank you, Mr. Chairman. It's intended to. When I asked for the amendment, they said, are there any you want to exclude? And I said, no, everyone can come back. Send a letter to the rep. I'm sure the senator from Sedgwick would be happy to carry a message back to us that Sedgwick wants to keep it, and they would. But this gets them all.
Senator from Sedgwick.
Thank you.
Any further questions on the amendment? Seeing none, Senator, you may close or move your amendment.
Thank you very much. Back in the 90s, when Governor Finney was leaving office, she had a director of motor vehicles named Betty McBride. Betty McBride had been my county treasurer in Cherokee County. For any of you here that may go back that far, Betty's still alive, and she refused, as the director of motor vehicles, to let the legislature pass any bills that allowed for these special plates. She said license plates are identification of the car and a driver for the highway patrol and the police. They're not vanity. We do not have a license plate on the front of your car. You can put your Disney World license plate or you save the Wells license plate there. When she left, the dam broke. And here they came. And I don't know, I think we have nearly 75 now. It's just time to stop the madness. A license plate is not an advertisement. Sure, a fundraising group can use it as long as they are using it and getting a number of people to buy them. It's one thing. When the fund's gone from this and there's only 100 or so, 125, I guess, as the senator from Sedgwick said, being issued, it's time to take a look at it, come back, get it renewed. With that, I move my amendment.
You've heard the motion. Those in favor, say aye. Those opposed, no. Yeah, the ayes appear to have it. The ayes do have it. We are back on the bill. Further questions for the senator from Sedgwick? Seeing none, Senator, you may close. Oh, I apologize. A senator from Shawnee, Senator Dietrich.
Thank you, Mr. Chair. I really just stand in support of this bill. When we were in transportation, we had one entity come from Sedgwick County, a PBS station, who wanted the opportunity to do fundraising for that single station. And it just seemed not quite fair when we have so many PBS stations across our state who need some additional funding. We're not providing it. And if there are people in their community that would like to be able to purchase this license plate and add to their funds for that specific station, it just seemed like a fairer way to approach this, whether you like the license plate concept or not. So I fully support what the senator from Sedgwick is doing with this bill and encourage folks to vote yes.
Any further questions for the senator from Sedgwick? Seeing none, now you may close.
Thank you, Mr. Chair. I move that when the committee rises in report, it reports HB 2553 as amended favorably for passage.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. Body, we will now turn our attention to House Bill 2644. The chair recognizes a senator from Lynn, Senator Tyson, to explain the bill.
Thank you, Mr. Chairman. So a few years ago, legislation was passed that if you challenged your appraisal on your property, then the valuation on it could not raise for 3 years. And it was thrown out in court. So this is an attempt to kind of rein in that process. It seems like if you do challenge the valuation, you go through all that work and all that effort, and then the next year you get a 20 or 30% increase again. So what this legislation would do is that if you appeal your property taxes and the next year and you are successful, and the next year, if your valuation increases over 5%, then the local county appraiser must do a fee simple appraisal, basically establish market value for your property. And they must do that for the next 5 years. With that, I'd stand for questions.
Are there questions for the senator from Lynn? Seeing none, Senator, you may close.
Thank you, Mr. Chairman. I move that when the committee rises in report, it reports House Bill 2644 favorably for passage.
You heard the motion. All in favor, say aye. Those opposed, no. Motion carries. Body, we will now turn our attention to House Bill 2739. The chair recognizes the senator from Harvey, Senator Owens, to explain the bill and adopt the committee report.
I move adoption of the committee report.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. You may continue.
Thank you, Mr. Chairman. So House Bill 2739 comes to us as an attempt to solve a problem that has been created by statutory language that conflicts with national fire standards. Specifically, the bill before us today is an effort to address some of the issues we face in our state fire codes. Specifically KSA 31-132A, which currently defines an apartment house as any building with 3 or more dwellings in it, conflicts with the definitions in national codes and places the State Fire Marshal's office in an unenviable position of enforcing an obsolete standard. So this bill was originally introduced to further define what a townhouse was, but after it worked its way through the House and the Senate, it was ultimately determined in the Senate that what makes all conferees happy is simply the elimination of 31-132A. So that's what brought all the opponents, and neutrals together to support this legislation, was simply to repeal that statute. And that's exactly what we do, and I will stand for questions.
Are there questions for the senator from Harvey? Chair recognizes the senator from Sedgwick, Senator Blasey.
Thank you, Mr. Chairman. I have an amendment, and it's 4509.
And you've turned it in?
I have.
Very good. Give us a moment, please, while we get that ready. The amendment appears long. Would you care to explain your amendment, Senator?
Sure. Really, the painting of the amendment is on page 2, and more or less, Kansas is the only state in our nation's union that goes off the 2006 International Fire Code. Most states go off the 2024 code. So 2006, I'll say the senator from Barton was probably running around on the playground in middle school, and that's a long time. Technology has changed. The world has changed. And so it's time for Kansas to get up to speed. All this amendment does is allows the state fire marshal to begin the process and put forth regulations that allow the state to adopt the 2024 code of some kind. Doesn't mean it has to be every code. It allows them to start working on it. So not every code is going to be applicable to Kansas, like an earthquake, you know? And so this just states that he can put forth regulations, and that the Attorney General, who at the end of the day has the ultimate authority to ensure they're promulgated, is 120 days. So with that, I will stand for questions.
Are there questions on the amendment? The chair recognizes the senator from Barton, Senator Blue.
Thank you, Mr. Chair. I just want to speak that I am very much in favor of this amendment. As somebody who works in an industry that has to deal with the state fire marshal constantly, we must do something about updating our codes. We are currently at 2006. The fire marshal sent over rules and regs over 3 years ago to go up to 2018 code. It's over 5,000 pages sitting at the Attorney General's office, and just the other day received 3 pages back saying, please change a comma here, strike this word here. So if we're not even there, this drastically has to be done. And they were starting at 2018, and now they're going to 2024 because so many other so many other cities are now going to 2024. So this is a much needed amendment. It is a cost burden for contractors and for cities across the state to stay at the 2006 code. And I'll gladly stand for questions if anybody wants to know what's going on, but to do the economic impact is almost nearly impossible. They're trying so hard to do an economic impact from 2006 to 2024, and it's getting to the point now that it's nearly impossible, and they are now hung up and trying to get this code over. They have traveled the state, had meetings with contractors. I was at the one in Garden City, and they were saying how they are creating their own Kansas code because they do not want to adopt all of the international code, and that is drastically needed in the state of Kansas. I can't say enough how much I appreciate this amendment, and I really hope that you support it, and I'll stand for questions to help out the carrier of the bill, or carrier of the amendment, if there are any questions.
Chair recognizes the senator from Dickinson, Senator Hill.
Thank you, Mr. Chair. I appreciate the effort by the carrier of the bill, or of the amendment, to bring some relief. However, in discussion with my builders in my area, say that they are currently building to 2018 code, which is a local issue. But they say that to change to 2024 code would require fire suppression requirements in all their buildings that they're building. They say that doing that would dramatically increase their costs and would essentially run them out of business. So my concern is that we're doing this as an amendment on a bill without really discussing what the impact is on the different parts of our state, from rural to urban. This is pretty sweeping. It's a pretty big deal to make that big a jump. I think the desire to go from 2006 to a more modern code is admirable. I'm just concerned that we don't go so far as putting people out of business at the same time. So I would urge a no vote on this amendment.
Senator from Sedgwick, care to respond?
Yes, Mr. Chairman. I'll just say, I would support those concerns if the concerns, I think, didn't have enough barriers in place to ensure we do this right. When the fire marshal puts forth regulations, there are public hearings. There are going to be tons of stakeholders giving input. Then it goes before the Joint Committee on Legislative, Administrative Rules and Regs, who review them, give input, and then the Attorney General is where the buck will stop. The Attorney General will review these regulations and ultimately will have to approve them. So there are plenty of checks, there will be plenty of opportunities for the public, the folks who are experts, the folks who deal with these every day, to give their feedback. However, we do know today there is a problem. Today, some of the urban counties have already adopted the 2024 code. However, if you're operating nursing homes or child care agencies or hospitals in various parts of the state, the codes aren't the same, and it's costing those entities to have to update going back to the 2006 code, because they're thinking, well, maybe we're on the 2024 code because we have a facility in an urban county. So we need parity across our state. There's a reason why sometimes the state has uniformity on rules, and this is a reason. This is an opportunity where for us we can do that and update our regs from 2006 to 2024. Again, if there's certain instances that the senator from Dickinson mentioned that might be more costly, we're going to hopefully get that feedback from the public, and we can tweak the rules to ensure that there's not a huge burden pushed on folks. However, we do know there's a burden today with 2006 regs across the entire state.
Chair recognizes the senator from Harvey, Senator Owens.
Thank you, Mr. Chairman. So a question for the maker of the motion. Did the fire marshal submit to the Attorney General's office the 2024 regs or the 2018 regs for approval?
Senator from Sedgwick.
Mr. Chairman, the senator from Barton might be able to answer better, but I believe he has not submitted the 2024 regulations, but she might know if it's 2018 or other.
Senator from Barton.
Thank you, Mr. Chair. 2018 regs have been sent to have been trying to go through this process, and through this process, they've been, so many cities and counties have updated to 2024. They know that they are getting outdated because at this point, by the time 2018 is done, cities and counties are going to be maybe on every 3 years as a new code. So then they're going to be on 2027 code, and by the time we get 2018 done. So they started the process of creating the Kansas code, which is just specifically to Kansas, and they're starting the process of 2024, and that is the process that they are in the middle of right now to get to the Attorney General, or to start the process.
Senator from Harvey.
Thank you. If I may just follow up on that, because I know that we heard, if I recall, we heard in committee, the number one concern with going from 2018 to 2024 was that the 2024 code included a lot of environmental related type of requirements that would add cost to building that have nothing to do with public safety. And so my only hesitation here is, without fully understanding the difference between 2018 and 24 and that overall impact, the fire marshal, I know when I had spoken to him, was really focused on 2018. So the fact that they're moving somehow with 24 is certainly news to me. And I'm very hesitant to support going to 24 at this time. I also wanted to simply mention that we really are setting aside all of 77,415, whether you agree with setting that aside or you disagree. I agree that there's a quagmire in the process as it relates to this code, but it is important for the body to understand that we are circumventing the standard process by doing this. Thank you.
Senator from Sedgwick, care to respond?
I'll continue to allow more discussion. Thank you.
All right, Chair recognizes the Senator from Johnson, Senator Rose.
Thank you, Chair. Would this apply to single-family residence, new home construction?
Senator from Sedgwick.
I'm not a fire code expert. All I know is I've heard in the last several years from healthcare providers and child care providers that 2006 regulations are a problem. If the legislature does not act, we will continue to be stuck with the 2006 regulations because of the economic impact study requirement under law. So if you're asking me about fire code specifics, I unfortunately cannot answer that. Maybe the senator from Barton can. That's maybe her expertise professionally. But at the end of the day, the state of Kansas will be able to amend the rules, 2024 fire code rules, that best serves the state of Kansas. We're not required to require all these environmental impacts if that's not what's best for Kansas. We'll hopefully get that feedback from stakeholders. But what we know today is 2006 is outdated.
Senator from Barton.
Thank you, Mr. Chair. When it comes to commercial, such as when it comes to building multifamily homes, and I'm saying multifamily homes, I'm talking about apartment complexes, I'm talking about hospitals, child care providers, nursing homes, all of that has to be stamped by the local or by the state fire marshal. And so the issue that we're turning into, so homes, that has nothing to do, homes, we don't deal with homes, I'm gonna be upfront on that. But if there is if you do have to get those approved, which I'm sure that your city and your local fire marshal makes you do, that all is local. The issue is what's happening is we'll get plans stamped by the fire marshal. And I don't know if you guys knew this, but a PE stamp is expensive. And we are spending thousands of dollars as contractors to get plans re-stamped because we're up to the fire marshal's code locally, but we're not, and then we have to go back down to the state fire marshal's code. So when we're talking about spending money, currently contractors are spending money on this issue right now.
Senator from Potawatomi, Senator Titus.
Thank you, Mr. Chair. I would share the concerns expressed here. One, just putting a 120-day limit or a demand on the Attorney General doesn't ensure the regulations will get done, or if he just drops them off and doesn't finish the review, I don't know that that benefits anybody in the state. The other piece of this is, and I'll admit this is just a Google AI search, but I asked, does the 2024 National Fire Protection and Safety Standards increase the construction costs of homes? And it says yes, generally 2 to 3% up to $30,000 in upfront costs. And that's why waiving the, again, there's probably a lot in that number, but waiving the economic impact statement, I think, is a huge mistake, because each of these successive fire codes has increased costs and requires different materials. And the National Association of Home Builders is where that information comes from. People are doing this work, and I don't know why we can't quantify that based on national studies that have been done, but I think we hurt affordable housing if we don't take a hard look at what we require to be put in new homes. So I'll be opposed to the amendment.
Senator from Sedgwick, care to respond?
Thank you, Mr. Chairman. So it's my understanding that state law, Kansas state law, exempts single-family units and 1 to 2 family dwelling units. So these codes would not apply to those. Thank you.
Senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. I stand in strong support, knowing that we are not through this legislation, or maybe this is a question for the senator from Sedgwick. This legislation does not adopt the 2024 code. It simply starts the review of that code by our fire marshal and asking for recommendations of which parts of that code make sense for this state. And I'm guessing the fire marshal will have public hearings, and certainly public hearings are required by the Joint Committee on Rules and Regs.
Senator from Sedgwick.
Yes, Mr. Chairman, that is correct. This amendment is not the state of Kansas adopting 2024 regs. It is just allowing the process. That is correct.
Chair recognizes the senator from Meade, Senator Reichman.
Thank you very much, Mr. Chair. I just have a lot of problems, I said before, with these amendments on the floor. I just love them better with a hearing when people talking back and forth. The fire marshal doesn't necessarily need this bill to start the regs, and I just have concerns of just changing things. We had people talk in Commerce that they were concerned about the higher regs, the years, and that was for the cost of new homes. And that the idea that it was so hard for young people, they're so disillusioned of getting into home for the price of it. And so I will not be supporting this. Thank you.
Further questions on the amendment? Seeing none, Senator, you may move your amendment.
Thank you, Mr. Chairman. I appreciate all the dialogue, and I appreciate everyone's input. I think there's a lot of confusion around residential property. These codes have nothing to do with single-family units. So in terms of concerns about the cost of housing, I do not believe this is applicable to that. And with that, I move my amendment.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion carries. We are back. Division has been called. Those in favor, please stand. You may be seated. Those opposed, please stand. (20) voting in favor and 12 against, the motion passes. We are back on the bill. Any further questions for the senator from Harvey? Seeing none, Senator, you may close.
Mr. Chairman, I move that when the committee rises and it report House Bill 2739 as amended favorably.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion passes.
We now turn our attention to House Bill 2357. The chair again recognizes the senator from Harvey, Senator Owens, to explain the bill and adopt the committee report.
Thank you, Mr. Chairman. I move adoption of the committee report.
You've heard the motion. All in favor, signal by saying aye. Opposed, same sign. You may continue.
All right, thank you, Mr. Chairman. So this House Bill 2357 specifically let me try that again. House Bill 2357 specifically deals with landlord and tenant relations, specifically the expungement process of an eviction. So when a tenant fails to pay their rent or meets other criteria that violates the lease, the landlord then has the ability to file for eviction. That eviction is then processed through court and then can be ordered. What this specifically does is really focuses on the eviction process, and once an eviction has hit your record, how does it come off? Under current law, the eviction is there permanently, and so any new landlord that is considering renting to a tenant will see a previous conviction, which certainly does make it more difficult for that tenant to be able to rent a unit again. What this does currently is it provides, in essence, a 3-year sunset on that eviction being on your record. And it creates a process by which that eviction will roll off. Notice will be sent to the landlord. It does require that all of the past financial obligations be met, and that if all of the qualifications and requirements are met after 3 years, then it will roll off. With that in mind, Mr. Chairman, I do have an amendment that I need to bring forward that was meant to be brought forth in committee, but we ran out of time in committee. Has been turned in, and it is amendment number hold on, that's the wrong one. It is amendment number 4476.
You want to explain your amendment or have it read?
I'll be happy to explain it, Mr. Chairman.
Is it short?
Well, I would say it's medium.
We'll wait for distribution. You may proceed.
Thank you very much, Mr. Chairman. So, one of the concerns brought forward by the landlords is that it wasn't very specifically clear in the bill that all financial obligations had to be met before that eviction rolls off. Because the way the language reads in the bill, it is that the expungement docket number be tied to the eviction docket number. Under current law, the eviction docket is a standalone docket. The civil cause of action or civil course to recoup your past due rent or any damages is a different docket number. So what this attempts to accomplish, and I believe we do accomplish, and it is satisfactory of those involved in this discussion, is it simply says that we are going to insert in different areas of the bill owed by the defendant to the plaintiff arising out of the underlying tenancy or rental agreement. So simply, if you owe the money, we're very much clarifying that that eviction docket and that expungement filing has to satisfy the underlying issues as it relates to any of the monetary judgment. In 7, the very end there on where it says number 7, it adds even a further clarifying piece of language that says, in the event that an order expunging an eviction action pursuant to this section shall not be construed to satisfy or extinguish or otherwise offset the monetary obligations. Again, just in case it happens to be missed, it allows the landlord still to go back and collect via that civil cause of action. So it's really clarifying that any of the financial obligations are met before the expungement is allowed. And I'll stand for questions.
Are there questions on the amendment? Seeing none, you may move.
I move my amendment.
You've heard the motion. All those in favor say aye. All those opposed, same sign. Ayes have it. We're back on the bill.
I'll stand for questions, Mr. Chairman.
Chair recognizes Senator from Johnson, Senator Rose.
Thank you, Chair. I have an amendment.
You turned it in?
I have. The number is 4488.
Okay, we'll pause while it's distributed. Is it short?
Yes.
Whew. You may explain your amendment.
Thank you, Chair. When I consider the relationship between landlord and tenants and legislation therein, I think that we should prioritize protecting good tenants from bad landlords while also protecting good landlords from bad tenants. I don't see any value in preventing a landlord from knowing the rent history of a potential tenant. After just 3 years, that tenant could have been evicted under the current legislation that we're considering here. Federal credit reporting law allows for a 7-year look-back period on credit history. So what this amendment does is it says instead of the eviction being erased from the rental history after 3 years, it extends that 3 years to 7 years. By doing that, we will have more informed landlords in the state of Kansas, and it gives them more certainty to have lower rents ultimately. With that, I move my amendment.
Are there questions on the amendment? Chair recognizes Senator for Harvey.
Thank you, Mr. Chair. Thank you, Mr. Chairman. So really what this is a fundamental question, because what we're creating, or what is being created with this legislation, is a shall, right? It says that the eviction history shall be removed after 3 years, assuming all of the requirements are met. The question for the body is 3 years adequate? Does the body feel like, under the current amendment, 7 years is more appropriate for that automatic process to occur? And so I will absolutely leave it to the will of the body as to whether they feel it should be moved from 3 years to 7 years, because I have heard of another amendment that would actually lower it to 2 years potentially. So I think it's just a policy decision of this body, Mr. Chairman.
Thank you. Chair recognizes Senator from Johnson. Senator Rose. Would you like to respond?
I'll wait to close.
Chair recognizes Senator from Douglas, Senator Francisco.
Thank you, Mr. Chair, and I'll be brief. We are trying, I think, through this bill to help individuals who have had an eviction, have an opportunity to pay all the bills, and then to continue to be considered for housing. I don't want people to have to move out of state if they know that they might have difficulty renting for 7 years. So 3 is much more appropriate.
Thank you. Chair recognizes Senator from Johnson. Senator Rose.
Thank you, Chair. By extending this eviction history to 7 years, all we're doing is we're letting landlords know the rent history, the credit history of their potential tenant. The landlords can still rent to the potential tenant, knowing that they had an eviction in the past. But the more educated the landlords are on the rental history of their potential tenants, the better rents will be throughout the state for all tenants.
Chair recognizes Senator from Miami, Senator Shane.
Thank you, Mr. Chair. And I completely understand the thought process of the carrier of the amendment. I tend to think that 3 years gives us enough time to sort out whether or not this individual needed an opportunity to get back up on their feet, or if there's some sort of habitual problem with them. This would be typically 3 contract cycles. A lot of leases are one-year contracts. That's 3 contract cycles that they would go through demonstrating that they haven't had an issue. And many times people that are facing eviction, it's because they had some sort of issue come up in their life. They need to get back up on their feet. And I still think that 3 years would be a sufficient time period when we're considering expungement from the eviction registry. Thank you.
Thank you. Senator from Johnson, Senator Rose. Senator Harvey, any further questions? There being no more questions, you may move your amendment.
As we consider landlord-tenant relationships, I think that we should support policy that lowers rents. If you're a landlord, if you own a rental property, and if you know that you could be talking to a potential tenant that 3.5 years ago was evicted, which takes a lot to be evicted, how are you going to respond in your rents to every potential tenant? If it was me, if I owned the property, I would raise the rents just in case I was dealing with somebody who has a history of eviction.
Senator from Johnson, would you pause just a second? Senator from Sedgwick, are you to comment on the amendment? No. You may proceed.
Okay,
Sorry.
so more information is a positive, it's not a negative. Like I said, landlords can still rent to somebody knowing that they had an eviction yesterday if they want. It's not a bad thing for landlords to have information on their potential tenants. And with that, I move my amendment.
You've heard the motion. All those in favor say aye. Aye. All those opposed, same sign. Division. The chair is undecided. I'd like to count. Can we count? Can we count, please? All those in favor of the motion, please stand. You may be seated. All those opposed, please stand. You may be seated. With a vote of 16 to 17, the motion fails. We're back on the bill. Chair recognizes senators from Sedgwick. Senator Faust-Godot.
Thank you, Mr. Chairman, and I needed the chuckle, your division call. Thank you. I have a question for, well, Mr. Chairman, first I'll say this. So back in 2020, 2021-ish, from there, COVID, we dealt with COVID, and a lot of people lost their jobs, they lost housing due to COVID. And so this legislature held special committees to see what we could do about our homeless issue across the state of Kansas. In Wichita, we had a lot of workshops, and from the information that we gathered through our legislative interim committee meetings, that evictions was one of the main reasons for the increase of homeless people on our streets in the state of Kansas. Mr. Chairman, so I rise in strong support of House Bill 2357. I believe it's a catalyst to address this homeless issue across our state. I certainly appreciate the work that Representative Howerton and Representative Howell and others have done on this legislation. If you see the proponent, there are a diverse group of individuals that support this legislation. Mr. Chairman, from the meetings in Wichita and the legislative body that addressed our homeless issue in the state of Kansas, from that, a couple of years ago, I introduced for the city of Wichita. I've talked to my mayors, I've talked to city council, county commissioners, and I said to them, when they come up on Municipality Day, I want something that we all can support. So their joint legislative agenda, their wish list, was to address homelessness in our cities in this great state of Kansas. So I introduced for them to enact the Kansas Fair Chance, a Fair Chance Housing and Homeless Reduction Act. Therefore, an individual who was a veteran or a person who was disabled in a wheelchair, or a mother and her children who could not pay the rent because of COVID. We all know what happened during COVID. My brother died during COVID. So many people lost things during COVID, and they were evicted. Mr. Chairman, I serve on the Kansas Legal Services Board in Wichita. So I go out with the attorneys on the streets, Broadway, Main, Douglas, there in Wichita, and we talk to people who are homeless. And most of them were evicted due to their situation with COVID, Mr. Chairman. And so we know we have an issue with homelessness. I left today on our break to just get out in the fresh air. I saw homeless people around the Capitol today. Mr. Chairman, I saw that. I saw that, indeed I did. And I said, oh, I don't know how long we're going to be on the floor tonight, if it's going to be to the wee hours, or if I'm going to stay overnight and go home tomorrow. I said, let me gas up. A homeless person asked me for money, Mr. Chairman. Seriously, and I only had plastic on me. I'm going to start back carrying some cash to help people out. Mr. Chairman, right now in Wichita, and I feed the homeless, a lady prepares food, and I go down there with her, and because the Lord Diner and the Open Door program, they are closed on Sundays. And so most of the people that are homeless, and Kansas Legal Services can verify this when they go out and talk to the homeless people to try to help them get housing due to their eviction status. Most of them are disabled veterans, believe it or not. They actually get a disability check. They actually get Social Security benefits. They actually have money, they said. They can pay for housing, but no one will rent to them. So Kansas Legal Services, they try to get them some houses, and then they live in housing with mold, etc. And so I really do stand in favor of House Bill 2257, or 2357, because the legislature had a study, had interim committee meetings, and found the main reason for homelessness on our streets in the state of Kansas was due to evictions. So, Mr. Chairman, I rise in support, and I have an amendment.
Have you turned it in?
I have, Mr. Chairman.
What is the number?
I will tell you that number here right now. That is number 4490, Mr. Chairman.
The amendment appears short. Would you like to explain the amendment?
It is, thank you, Mr. Chairman. And we've already had some of that debate. And so, Mr. Chairman, as you see on line 32, we would just strike the 3-year waiting period and insert a 2-year waiting period, Mr. Chairman. And here's why. Here's why. If you have paid all of your money, you have satisfied your creditor, you have satisfied that landlord. 2 years, what are they going to do in between 3 years or 7 years? Where are they going to live? They can't live with me, Mr. Chairman. I don't know. What are they going to do in that meantime? They'll still be homeless, sleeping under the bridges, standing at the gas stations. They'll still be doing that. And so, you know, I get it. My credit score after 7 years, it falls off. Maybe, maybe not. But if I've paid my money and I'm in good standing for 2 years, hopefully we would let a landlord, let that person who was evicted have a second chance, be able to explain their situation, especially if they can verify that they've made their payment and they can verify that they have income to rent a roof over their heads. And so just changing 3 years to 2. With that, Mr. Chairman, I'll stand for questions.
Other questions on the amendment? The chair recognizes the senator from Harvey, Senator Owens.
Thank you, Mr. Chairman. I will say something very similar to what I said about 7 years. This is a complete policy decision by this body as to whether they think the time should be longer or should be shorter as it relates to this. I will note that in the bill, the defendant is the one that shall provide service of process to the plaintiff for this process to occur, and the plaintiff, being the landlord, does have 30 days after service of process to issue an objection on the expungement. Again, whether it's 3 years is what the Commerce Committee felt was appropriate. If the body, they came close to thinking 7 years was appropriate, If they feel like 2 years is appropriate, that's a policy decision from them. Thank you, Mr. Chairman.
Are there other questions on the amendment? You may move your amendment.
I move my amendment, Mr. Chairman.
You've heard the motion. All those in favor say aye.
Aye.
Opposed, no. Motion failed. We're back on the bill. Chair recognizes Senator from Sedgwick, Senator Clays.
Thank you, Mr. Chair. I have an amendment.
You turned it in?
I have. It is 4486.
Thank you. Do you want to explain it or have it read?
It is small. It is pup cup sized. So.
Thanks, Senator. We'll pause. Senator from Sedgwick, would you check the number again on your amendment?
I believe it is 4486. That's what it says. My glasses broke or something?
Senator, we have 96.
4486.
Okay.
4486?
We'll get it right.
It is bipartisan that this is 4486. Oh, he came over and gave it to. Oh. Can we hold on for a second?
We are stand at ease.
There. Oh, that one, yes.
Appears we have the amendment and you were not dyslexic, so we'll proceed.
Well, I'll go ahead and start then to
You may explain your amendment.
explain the amendment. So first of all, I just want to say I am a landlord, and I do support the underlying goal of the bill. One issue that we've had is that unproven election or eviction filings shouldn't be a permanent barrier to housing. Sealing records until there's an actual judgment does give landlords actually better information, and I hope that's well understood. I am offering an amendment that I think strengthens the bill without changing the purpose. My amendment addresses the mediation provision. The bill as written creates a presumption of mandatory mediation in every eviction case. A judge who wants to skip mediation has to make an affirmative finding. My amendment replaces that framework with a straightforward judicial discretion. The court may order mediation, period. No presumption, no required finding, no paperwork justifying a decision not to mediate. I think what people need to understand is that with mandatory mediation of an eviction proceeding, these are summary proceedings. They're designed to move quickly. A tenant who hasn't paid rent in 3 months and a landlord facing a mortgage payment, they don't need a mediator, they need a resolution. Mandatory mediation adds time, it adds cost, and in many cases delays the outcome that both parties may have already understood. But there are cases where mediation does make sense. Lease disputes, maintenance disagreements, situations where the relationship is salvageable. Judges can see the difference, and we should trust them to exercise that judgment. May gives every judge in Kansas the authority to order mediation. Shall takes away their ability to recognize when it's a waste of everyone's time. I encourage the adoption of my amendment, and I stand for questions.
Other questions on the amendment? Chair recognizes Senator from Harvey, Senator Owens.
Thank you, Mr. Chairman. As I am looking at page 6, line 1, where we are striking shall and adding may, I don't see that we're doing anything really different here, and I would like further clarification because it says the court shall consider mediation unless the court finds the mediation would not aid the parties materially or is impracticable. This says the court may consider mediation. So all this is saying is we're changing it from the court shall consider it to may consider it. It's still up for consideration, whichever word is there. And so I don't quite follow the change in the terminology when it's already going to be a consideration of the court.
Chair recognizes Senator from Sedgwick, Senator Claes.
So my reading of it at the time, and I'm sorry I don't have the bill pulled up, I will in a second here, but my understanding of it is that what this would do is under the current system, because there are two other things, striking, requiring, and authorizing, but it would get away from where the judge has to have an affirmative finding in order to do the mediation, whereas this would take away that affirmative finding.
Senator Harvey, Senator Owens.
If I may, Mr. Chairman, so the second paragraph on this amendment, page 1, line 7, page 1, line 10, is simply impacting the title of the bill. So there's no substance in the second portion of this. It is only changing the reading of the title of the act. So all of the substance in this amendment is what I read on page 6, and it says current law says the court, or current bill language says the court shall consider mediation unless the court finds mediation would not aid. This changes it to the court may consider mediation. I think because you have consideration in there already, you don't need to change it from shall to may. That's my reading of it, and unless I hear otherwise, I'm not going to support the amendment.
Senator from Sedgwick, Senator Claes.
I'm just going to say that's not my reading of it. Leave it at that.
Are there other questions on the amendment? Chair recognizes Senator from Sedgwick, Senator Faust-Cadeau.
Thank you, Mr. Chairman. So my question for the senator carrying the amendment is, so just from the dialogue, it sounds like you have may, shall, and consider. So, and if he's reading that, if he could clarify his amendment of, however, I rise in support of this amendment because it alleviates that additional work from the judge, and it allows to expedite the resolution for housing for those individuals. And so, but Mr. Chairman, my question is if the senator could clarify his reading or clarify his amendment. Thank you.
Senator from Sedgwick, Senator Claes.
I didn't quite catch the gist of your question, though.
Senator Faust-Cadeau.
Thank you, Mr. Chairman. So during the dialogue from the senator from Harvey and Sedgwick, who's carrying the amendment, I heard consideration, the judge may consider, then I heard shall, and I heard may. If the senator from Sedgwick would clarify his amendment, does it say shall, may, or consider? Thank you.
Senator from Sedgwick, Senator Claes.
Well, mine is changing the shall to a may, so it is, according to my reading of this, it is giving the judge discretion as to whether or not there will be mediation.
Other questions on the amendment? Chair recognizes Senator from Harvey, Senator Owens.
I don't think that I have anything to add, Mr. Chairman. I think that the language is clear under the current reading of the bill. The court shall consider mediation unless. This changes it to may consider mediation unless. It's a choice of the body, Mr. Chairman, and I think that shall is better that it considers mediation, shall consider mediation unless the court finds otherwise. So I would be in opposition to this.
Are there other questions on the amendment? Seeing none, you may move your amendment.
Thank you, Mr. Chair. I move my amendment.
Heard the motion. All in favor, say aye. Opposed, no. Ayes have it. Motion carried. We're back on the bill. Chair recognizes Senator from Harvey, Senator Owens.
Thank you, Mr. Chairman. I move that when the committee rises and reports,
Chair
I will
recognizes
yield.
Senator from Johnson. You may proceed.
Thank you, Mr. Chair. I do have an amendment.
It's turned in.
Yes, it is.
Number, please.
4496.
We'll pause. Got the right number?
I'm not doing anything with yours. I'm not doing anything with yours.
Senator from Johnson, Senator Holscher may proceed.
Thank you, Mr. Chair. I will preface this by saying it has nothing to do with changing the number of years in this bill, but to let you know, the issue of homelessness has been brought up and how evictions often lead to homelessness. What we have to consider is a driver of evictions is large fees that are charged for late rental payments. So this amendment puts a cap on late fees. As it states on here, late fees shall not exceed 5% of the amount of the periodic rent. We have over 15 states, I believe, that have similar cap. 10 states have a dollar amount of $15. This amendment puts it at 5%.
Other questions on the amendment? Chair recognizes Senator from Harvey, Senator Owens.
Thank you, Mr. Chairman. Here's what I would say to this amendment. This is a substantial change to the bill as it came to us. It was never part of the bill as it was introduced. This bill has went through about a year's worth of work by the bringers of the bill. The representatives Howell and Howerton worked diligently on this, and as it was introduced this year, they also worked diligently with the proponents, with the opponents, to bring everybody together to where this bill sits today. My primary concern with adopting this amendment is that it would then change who supports it and who is against it. And so I'm going to stand in opposition to this bill because I would really like to see this expungement process get through there, and I'm afraid we're going to lose votes in the event that this amendment gets added. So I'm going to be in opposition to this amendment.
Senator from Johnson, Senator Holscher.
I would hope that people who are in favor of the expungement process and changing that would also be in favor of helping people stay in their homes, because once you have these late fees and they are so large and there's no cap, often what happens, you start a downward spiral where renters can't afford the late fees and then they're evicted, which then makes it difficult for them to obtain housing in the future, which then adds to the homeless situation. So typically, like I said, people who are supportive of changing the expungement process are also in favor of changing and putting caps on late fees because that helps address the overall homeless situation.
Are there further questions on the amendment? Chair recognizes Senator from Cherokee. Senator.
Thank you.
Schallenberg.
Listen to this rent stuff about all I can take, to tell you the truth, but you know, there's a way to avoid a late fee. It's pay on time. And it doesn't seem like we're talking about that here. I own property. If my tenant doesn't pay me, I pay the utilities for this one, and I have a very good tenant. But if she didn't pay me, and I didn't pay the electric, there'd be a late fee. Or if I wrote a check in anticipating of her paying on time and she doesn't pay, then there's a fee associated with check. And you know, you just should pay your bills. You shouldn't show up in a credit score bad.
I know things happen to people. Landlords understand that. Now, maybe there's scrupulous people out there that don't have an understanding, Mr. Chairman, but, you know, and I don't think the 5%'s terrible. So the amendment sure could have been a lot worse. But I don't support this, and I think we've gone too far probably on this bill already in taking away the rights of the people who own the property, who want to rent the property, not being able to find out what the people they're renting to past history is, not being able to look past 2 or 3 years. I think we've gone far enough. Thank you, Mr. Chairman.
Senator Johnson, Senator Holshow. Chair recognizes Senator, would you like to respond? Chair recognizes Senator Sedgwick. Senator
I yield.
Fasquedo.
Thank you, Mr. Chairman. So, you know, housing goes back to, on my off days, I love to watch Westerns. So Gunsmoke, Bonanza, and all of them, there was always this little tax man that he'd go out to the farms. So people should pay their taxes. They should pay their bills, Mr. Chairman. But again, I reiterate that if we all use common sense here, everything went downhill after COVID. A lot of people could not go to work. And so they're the downtrodden. They're the people that we should, you know, also, not just we keep picking and choosing, you know, landlords have a right to receive their rent. The mortgage company has a right to receive the mortgage for the home or the car or whatever it is. But, you know, have mercy. You know, help the least of them, Mr. Chairman. And so, I don't know, we'll deal with it one way or the other. You know, they'll be homeless on the street, or we could give them a second chance. So I do have a question for the senator from Johnson carrying the amendment, Mr. Chairman.
She's standing, you may proceed.
Yes, so I know that I also watch a lot of judge shows, Mr. Chairman. And so some states, they do have a cap on late fees, or they, you know, they vary. So if the gentlelady from Johnson could tell me what is our cap, or what is our rate for late fees here in the state of Kansas.
Senator from Johnson, Senator Holscher.
We do not have in Kansas a cap. What is basically in legislation is reasonable, but that is not defined. And for example, I believe in some areas, and I will use Wichita for example, I believe we have a landlord there, one person who owns about 1/3 of the rental properties, who doesn't even live in Kansas, but tends to charge overly large fees on late rental fees. And this has led to several evictions, which then starts that downward spiral, which then contributes to homelessness. So it's an issue. It's not just an issue there. We have the issue in Johnson County and Wyandotte County and across the state, because we don't have a definition of reasonable, whereas 15 other states have the 5% figure, and 10 other states have a dollar amount defined, most of them at just $15.
Senator Sedgwick, Senator Fasquedo.
Thank you, Mr. Chairman. Again, I rise in support of this amendment, and I want to, Mr. Chairman, if the body would remember, even today in the building, we had those with physical and mental disabilities were here. I know for a fact on the streets of Broadway in Wichita that there are homeless people who are disabled that need housing. A lot of them, they wait for their Social Security disability checks so that they can pay. A lot of people are just getting caught up after homeless. And, you know, so, Mr. Chairman, I'm just kind of hurt. I'm hurt for the people that don't have housing when I drive around and I see them. And it's easy to say, you know, just pay your bills. But if that's the case, then why do we offer the Red Cross, and why do we offer these additional services for those downtrodden people? In the Bible, it says, if we help the least of them, we will help ourselves, Mr. Chairman. And I just think that's so contradictive. We ran for office to help people, senior citizens. It doesn't make sense. If they're on a fixed income and their Social Security check doesn't come that month, or whatever was going on with COVID, again, I have trust but verify. I have the facts where this body had interim committee meetings and found out that the homeless issue was on a rise because of evictions due to COVID. And so I just wanted to help some of the constituents or Kansans across the state get off the streets. I support the amendment. Thank you, Mr. Chairman.
Are there further questions on the amendment? Senator from Johnson, Senator Holster may close.
Thank you. We're in an affordability crisis all across the state where people are making choices, very, very heartbreaking choices and decisions between things like health care and paying rent. The advice of don't be poor probably is not a very good recommendation and certainly doesn't help in this situation. We have the ability to take action and actually make a difference in this affordability crisis with this particular amendment. With that, I move my amendment.
You've heard the motion. All those in favor will say aye. Aye. All those opposed, but no. The motion fails. We're back on the bill. The chair recognizes Senator from Harvey, Senator Owens.
Thank you, Mr. Chairman. I move that when the committee rises in report, it report House Bill 2357 as amended favorably.
You've heard the motion. All those in favor say aye. All those opposed, no. Motion carried. We'll now turn our attention to Senate sub for House Bill 2402. To carry the bill, the Senator from Johnson, Senator Thomas.
Thank you, Mr. Chairman. I move adoption of the committee report.
For the motion, all in favor, signal by saying aye. Opposed, same sign. You may proceed.
Thank you, Mr. Chair. Community Eligibility Provisions, CEP, is a federal program that is used to feed kids school lunches and make sure our kids go fed. What we know is kids with a full stomach will perform better, they'll do better in school. And as someone with 5 children who all went through public schools, it breaks my heart to think there's kids that go hungry. So what this bill does is rather than force or mandate that districts take this program, it gives school districts the option to accept this program. So what it does is it will allow the districts, if they choose not to participate, to simply take a vote and opt out of it. What this doesn't do, there was comments about at risk and all that, and I've had multiple conversations. This is about a 3-year process where we talked about at risk, and as long as the district has good internal processes, it should have little to no effect on their at risk. I know that was one concern. But at the end of the day, what we're trying to do with this program, this federal program that won't cost the state anything, is feed more kids. We've had many conversations about this. I believe this is a good solution on the table. And if you're like me and you want to feed kids, I think this is a pretty solid bill. So with that, I will happily stand for questions.
Are there questions for the Senator from Johnson? Chair recognizes Senator from Johnson, Senator Holscher.
Thank you, Mr. Chair. There have been a lot of conversations today about this bill. It is very good overall. There's a little clarification here in terms of some of the language. So with that, I have an amendment.
Have you turned it in?
Yes.
What's the number?
4518.
We'll pause for distribution. Amendment appears short. Would you like to explain your amendment?
Yeah, essentially what this does is this amendment satisfies the goals of maximizing the number of districts that must check if they can tap into the federal funds. It basically clarifies which districts have to go through this process and which ones don't. There was a concern in terms of districts having to do this yearly. This is just clarification that gets our school districts on board, essentially.
Are there questions on the amendment? Chair recognizes Senator from Miami, Senator Shane.
Thank you, Mr. Chair. I'll spare the body from a Q&A session. So on this amendment, so every spring, every school district is notified by the State Department of Education if their school district and or any buildings within their district qualify for participation in the CEP provision. That threshold is 25% of students that would be eligible to receive a free or reduced lunch. The 50% actually would more than double the federal standard for participation. Historically, before that was lowered to a 25% threshold, it was a 40% threshold, so 50% would even exceed the older national standard for eligibility to participate in the CEP. This bill simply asks that districts consider and then cast a vote on whether or not they're going to elect to participate in the CEP and go through that process. And they are already notified if they qualify for that or not. Nothing in the bill prescribes how deeply they need to dive into the economics for their district or anything like that. Really what this bill is doing is it's simply tasking the board to take an affirmative vote, either yes or no, to move forward with participation in the CEP. So for those reasons, I'll oppose this amendment.
Chair recognizes Senator from Johnson, Senator Holster. Sorry.
Again, for districts that are not close to qualifying because they have lower levels of district certification students, this just means they don't have to go through the review process every year, which then is a loss of funds. So this is clarification that is good for our districts, still allows the process and the bill to move forward, and does what we want in terms of the intent of the bill.
Chair recognizes Senator Johnson, Senator Thomas.
Thank you, Mr. Chairman. This amendment spurred from a conversation we had with our school district earlier today, Olathe School District, and this was at their request, and so I actually am supportive of the amendment.
Are there further questions on the amendment? See none, Senator Holster, may close.
I close.
You've heard the amendment. All in favor, signal by saying aye. All opposed, no. Motion fails. We're back on the bill. Chair recognizes Senator from Johnson, Senator Thomas. Seeing no questions, Senator, you may close.
Thank you, Mr. Chairman. I appreciate the work of all those that were involved in this, American Heart Association, Appleseed, Kansas Action for Children. This is something we worked on in a bipartisan effort. We were able to find a solution that didn't cost the state anything, and I'm very proud of the work done on this. And with that, I move that when the body rises and reports, it report Senate sub for House Bill 2402 favorably.
You've heard the motion. All in favor, say aye. All opposed, no. Motion carried. We now turn to Senate Bill 521. To carry Bills 521, recognize Senator from Barton, Senator Blue.
Thank you, Mr. Chair. I move we adopt the committee report.
You've heard the motion. All in favor, aye. All opposed, same sign. You may proceed.
Thank you, Mr. Chair. This is not a new tax credit. This is a current tax credit that we have on the books. It's called the Child Daycare Services Tax Credit. It's $3 million. This bill does not increase the amount at all. The issue is we do not have employers actively utilizing this tax credit. And so in tax committee, they increased the annual allowable tax credit amount to $100,000 per taxpayer. The tax credit would be for 75% for total expenses made by an employer. It is for paying for childcare for employees, establishing or expanding a childcare program primarily used by employees, paying for referral services that current, I think it said, I can't read my own handwriting, employees I don't know what that word is, employees to childcare providers and providing for collaborative childcare investment with other employers. So the original tax credit amount was only allowed at 30%, and this is now upping it to 75%. And hopefully more employers will utilize this so we can get more folks back into the workforce, because childcare services are so hard to find. And with that, I'll stand for questions.
Other questions for the senator from Barton? Chair recognizes Senator from Sedgwick, Senator Blousy.
Thank you, Mr. Chairman. I support this bill wholeheartedly. You know, child care has been an issue we've talked about a lot the last several years, and access to child care is sometimes one of the bigger hurdles for a lot of Kansas families. And so the current child tax credit allows employers to invest in their employees who need child care, but the original intent of Senate Bill 521 was to expand it a little bit. So I have an amendment, and it's 4474.
I assume you've turned it in?
I have.
We'll pause. The amendment appears long. Would you like to have it read, or would you explain the amendment?
Mr. Chairman, I'll go ahead and explain it. So this amendment, I think the tax committee had some concerns about how broad the original bill was written. And so the language has been tweaked a little bit with this amendment. I think there's been conversations had by child care advocates with members of the committee. But this amendment really allows the credit to be going back to third-party entities, which is defined in this amendment. I think there were some concerns about that. So it's defined as a community child care means a for-profit or non-for-profit provider of child care services that is open at least 9 hours per day and located within 45 miles of the employer that is seeking the credit or such employer's offices. But it also allows you to make a contribution to a third-party entity, such as like the YMCA. Maybe you really support the programs, the after-school programs, daycare programs, child care programs that these entities provide for Kansans. And so you can make a contribution and get a credit for that, a partial credit. And these entities can use the funds for establishing or expanding child care programs, purchasing learning materials or play equipment, compensating professional development for their child care staff, and even providing assistance for families who might need child care. So this amendment kind of restores provisions of the bill that were originally struck out of concern about how broad they were, hoping it's a little tighter. It also restores the current law, which is that this credit is refundable. And so, again, this tax credit is capped at $3 million annually, but it's hardly being used because of how it's structured. So this bill restructures it. But the refundability piece is critical because it essentially allows small and mid-sized employers with low tax liability to still fully participate. Because we know the Boeings and the Garmins of the world probably have the tax liability to get a credit, the full credit. But this allows the smaller mom and pop shops, small businesses, to utilize this tax credit. And with that, I'll stand for questions.
Other questions for the carrier of the amendment? You recognize the senator from Johnson, Senator Sykes.
Thank you. No questions, but I do rise in support of this amendment, support of the bill in general. This was a bill that I had worked to get the tax credit back available, and when we passed this a few years ago, I'm hoping that several businesses would take advantage of that, and it is capped at $3 million a year, but so many businesses are not taking advantage of this, and we do know that we have a child care shortage and access to that. So I think this is a step in the right direction because we have talked to those businesses about what would make this more beneficial to them in providing those additional slots and child care solutions for our working families. So I just rise in support.
Chair recognizes Senator from Sedgwick, Senator Erickson.
Thank you, Mr. Chair. Just a quick carrier of this amendment. Does this apply to home daycare?
Senator Sedgwick, Senator Blousy.
Yes, home daycare would apply under the definition of community child care if it's within 45 miles of the employer and open at least 9 hours a day.
Senator from Sedgwick, Senator Erickson.
Thank you, Mr. Chair. Is there any minimum number of children the home daycare would have to care for in order to get this?
Senator Blousy.
Mr. Chairman, I do not believe so, no.
Senator Erickson.
Thank you, Mr. Chair. Concern I would have about that is while I want to encourage home daycare facilities is someone like myself, when I stayed at home with my 2 children, I watched another child, a neighborhood child whose parents needed childcare. So I could have written off or gotten money through this for my children's toys or play fort or those types of things. So I'm just concerned with some of the guardrails. Thank you, Mr. Chair.
Chair recognizes Senator from Johnson, Senator Sykes.
Thank you. Just based on the previous speaker's comments, this tax credit is going to the businesses, and they could already decide to give help pay for that child care for at-home service. So that's not changing this because it's not going to that provider. It's going to the businesses trying to open up access for those child care slots.
Chair recognizes Senator from Sedgwick, Senator Blasey.
Oh, Mr. Chairman, I think the senator from Johnson explained it well. More or less, the credit isn't going towards to the provider. It's going to the employer who's contributing.
Are there further questions from the senator from Sedgwick? Chair recognizes Senator from Lynn, Senator Tyson.
Thank you, Mr. Chairman. I know the hour's late, but there was a comment made about child care and indicating that this tax credit will help save it. Well, the major problem with our child care system is, and part of it, most of it happened under this administration, the rules and regulations are so stringent that most schools or individual families could even keep up with those regulations. So we're putting those child care facilities out of business with those regulations. Thank you, Mr. Chairman.
Chair recognizes Senator from Wyandotte, Senator Petty.
Thank you, Mr. Chairman. I rise in support of this amendment. I've been involved in the last few years with an organization in Wyandotte County called Growing Wyandotte, and we have looked at how to help businesses use the current child care tax credit, and it has been very difficult to have the details so that it made it usable. This certainly would be much more attractive to employers, and employers have told us that they do want to work on providing or helping with child care for their employees. So this certainly would be a tool that would help in many ways. And we have, just a moment ago, it was said about the number of slots that have not been available because of stringent requirements. But in fact, over the last few years, we have added 7,700 slots under Governor Kelly.
Further questions on the amendment? Chair recognizes Senator from Barton. Seeing no further questions, Chair recognizes Senator from Sedgwick, Senator Blasey to close.
Thank you, Mr. Chairman. I would just encourage the Senate to support this amendment. I guess there's a senator standing, and I'm happy to yield to the senator from Johnson.
You may yield.
Thank you. I think
Senator from Johnson.
Thank you, Mr. Chair. I think you couldn't see me from behind the carrier of the bill. I'm just wondering if the carrier of the amendment is aware of an FSA or a flexible spending account for the employer and the employee.
Senator from Sedgwick, Senator Blasey.
Mr. Chairman, under federal law, FSAs are allowed to have a dependent care. It's up to $7,500 after the Trump tax cuts went into effect on July 4th, or at least was signed into law on July 4th. But this, I don't believe that has anything to do with the tax credit for employers.
Senator from Johnson, Senator Gossage.
An employer or an employee can contribute to a flexible spending account through the employer, and it is tax deductible, but it is completely tax exempt, and it can be used for child care. I would encourage employers to put funds in there which are completely tax exempt to help the employee and add to their account. Thank you, Mr. Chair.
Are there further questions on the amendment? Seeing none, you may close.
Thank you, Mr. Chairman, and I appreciate that. I did not know that. I too would encourage employers to contribute in those FSA accounts. That would be very helpful. But yeah, I encourage the Senate to adopt this amendment. I mean, this amendment has broad support from the business community, the Saline County Chamber of Commerce, the Hutch Chamber of Commerce, Wichita Chamber of Commerce, the Kansas City Chamber of Commerce have all testified in support of this bill. I've sat on roundtables throughout the interim the last year with business leaders, and one of the big concerns they always hear is access to childcare. And I think this is just one small step in that right direction to make it more accessible. Thank you. I move my amendment.
You've heard the motion. All in favor, say aye. Opposed, same sign. Motion carries. We're back on the bill. Chair recognizes Senator from Barton. Senator, you may close.
Great. I just want to state how in the end, childcare is very hard to find. I'm just going to also let you guys know, I pay over $10,000 a year for one child, and I was told that is extremely low for many other areas. I can't imagine paying $400 plus a week for childcare. So anything we can do to help out to make sure that we have employees that are able to work and have childcare slots. So with that, Mr. Chair, I move that when the committee rises and report, it report out Senate Bill 521 favorably as amended.
You've heard the motion. All those in favor say aye. All those opposed, no. Motion carried. We now will consider Senate substitute for House Bill 2595. The senator from Potawatomi, Senator Titus, please move the committee report.
Thank you, Mr. Chair. I move adoption of the committee report.
You've heard the motion. All in favor, say aye. All opposed, you may proceed.
Thank you, Mr. Chair. House Bill 2595 would establish the Attorney Training Program for rural Kansas to address the severe shortage of attorneys in our rural communities. Some Kansas counties no longer have a practicing attorney in residence, and this will eventually lead to a constitutional crisis when there are no attorneys to provide representation in constitutionally required cases such as criminal matters, child in need of care cases, and other critical matters. Communities will also suffer from a lack of professional engagement, and residents will incur increased costs to access the legal system for such matters as probate and retirement planning when they have to travel to urban areas to find those attorneys. This program was modeled after similar programs for rural doctors and veterinarians, and it would provide a $3,000 stipend for the 3 years of law school, and following graduation up to $20,000 per year for up to 5 years for loan repayment. If the student fails to graduate or does not remain in a rural community, they have to pay back any benefits received. A rural community is defined as any county other than Douglas, Johnson, Wyandotte, Shawnee, and Sedgwick. The program will be managed by the Department of Commerce in coordination with the University of Kansas Law School and Washburn University Law School, and is scheduled to sunset on July 1, 2031, and I will stand for questions.
Are there questions for the senator from Potawatomi? Seeing none, Senator, you may close.
I move that when the committee rises and report, it report sub for House Bill 2595 favorably for passage.
You've heard the motion. All in favor, say aye. Opposed, no. Motion carried. We'll now consider a Senate sub for House Bill 2111. Carry Senate Sub 2111. Senator from Montgomery, Senator Peck.
Thank you, Mr. Chairman. I move adoption of the committee report.
You've heard the motion. All in favor, say aye. Opposed, same sign. You may proceed.
Thank you, Mr. Chairman. With urban sprawl taking place in some of our larger areas, which is not necessarily a bad thing, there are parts of our state where we have agriculture producing land that has been in families for many years, and some of these families want to maintain that agriculture feel and agriculture production. So Senate substitute for House Bill 2111 would exempt certain registered agritourism operations from local code and regulation enforcement. Simply what that means is no city or county could enforce any building code, ordinance, or resolution regarding the use of a non-public registered agritourism business. These agritourism businesses are located in, we know where they're located. These agritourism locations are largely engaged in rural and in production agriculture, whether it be they're raising animals or some are still in row crops, and so they have crop operation. These agritourism businesses or locations will also allow visitors to come to their farm because they're so conveniently located to a lot of urban areas to visit, to see what does an actual working farm look like. However, you can only go to these places by invitation. So it's not something you can just show up and say, we're going to have tours from 8 in the morning till 5 in the afternoon. That's not the case. The tours are by invitation only, and so you have to have an appointment, and you have to go to the facility at their convenience, because when you're in production agriculture, it's not always convenient to have people around. If it's planting season, if it's calving season, etc. You don't want individuals around, especially individuals who do not understand what goes on a farm and production agriculture. So that's pretty much what the bill does. Again, it just exempts these agriculture producing areas from being forced to adopt building codes and other ordinances that it's not their fault that the city grew out to them. They want to maintain their rural lifestyle and their production. But before I stand for questions, Mr. Chairman, visiting with the revisers, realized that we do need a little bit of a technical cleanup on some of the language. So I have turned in an amendment. The amendment number is 4374. Again, technical, but we'll allow it to be passed out, Mr. Chairman.
We'll pause. Thank you. Would you like to explain your amendment?
Thank you, Mr. Chairman. Yes.
You may proceed.
In reading the bill on page 1, on line 17, it uses the words "does not include," and then the very next line, when you read it, it's like, well, that doesn't flow, that doesn't make sense. So this amendment strikes some language, adds a few words, does not change any of the intent of the bill. It's strictly technical, and then because revisers were taking a closer look at it, they realized that they had used the word protection when they should have been using the word promotion. So that is also a part of the cleanup language for the bill. So with that, Mr. Chairman, first off, I will stand for questions on the amendment.
Are there questions for the carrier of the amendment? Seeing none, Senator from Montgomery, you may proceed.
Thank you, Mr. Chairman. I would move my amendment for House Bill 2111.
You've heard the motion. All in favor, say aye. Opposed, no. Motion carried. We're back on the bill. Chair recognizes Senator from Cherokee, Senator Schallenberger.
Thank you very much. I just want to make sure I understand this. So this prohibits a city from regulating, permitting this agritourism business. Isn't that already exempt from zoning?
Senator from Montgomery, Senator Peck.
Thank you, Mr. Chairman. We've got situations where, again, this is going to be an urban area, grown out, enveloped production agriculture, and these are actually registered agritourism operations. They do that so that they can host visitors on an appointment-only basis. So I'm not certain that I can 100% answer the senator's question.
Senator from Cherokee, Senator Schallenberger.
Thank you. Just one last question. So a winery would fit this description, I'm assuming. Is that right?
Senator from Montgomery, Senator Peck.
We had discussion about wineries, and it was determined that the winery was not qualify for the exemption on 2111.
Senator from Cherokee, Senator Schallenberger. Are there further questions for the chair recognizes Senator from Douglas. Senator, you may proceed.
Thank you. Just one question for the senator from Montgomery. Did the fire marshal, state fire marshal, submit testimony on this bill?
Senator from Montgomery, Senator Peck.
Thank you, Mr. Chairman. The answer is yes.
Senator from Douglas, Senator Francisco.
Thank you. And with that testimony, the fire marshal requested an amendment to the bill. His explanation for us on the committee was that when it says no city or county shall enforce any building code or any other ordinance or resolution, then that leaves the responsibility for enforcing our statewide fire code to the state fire marshal. And he felt it was not appropriate for him to be making those inspections. With
Have you
that,
turned the
I have
amendment
an
in?
amendment.
What's the number?
4506. I've turned it in, and I can explain it.
We'll pause briefly. Amendment appears short. Would you like to explain your amendment?
Thank you, Mr. Chair. My amendment would add 4 words, except for safety codes, on line 7, so that except for fire safety codes, no city or county would enforce any building code. And I'd be happy to stand for questions.
Other questions for the Senator from Douglas? Chair recognizes Senator from Miami, Senator Shane.
Thank you, Mr. Chair. Question for the carrier of the amendment.
She's standing.
In committee, it was mentioned that some of the very codes that one of the proponent operations was having was actually directly tied to fire safety codes in the building of their barns and concerns over requirements for fire suppression and other fire prevention mechanisms. Would this potentially undo some of the intent of this bill?
Senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. I do not believe it would. The fire marshal indicated in his testimony that he had talked with the primary sponsor of the bill, and the intention was not to avoid fire safety. We did hear that they were required to meet a number of building codes, but this specifically is fire safety. I actually had that testimony up on my computer until we had just spent so long talking about other things. But we could find that testimony where he said he's talked to the sponsor of the bill.
Senator from Miami, Senator Shane.
Thank you, Mr. Chair. That would just be my concern, is that this would potentially undo some of the intent of this bill. This was a bill that myself and other senators worked on. But with that, I'll leave this to the will of the body.
Senator from Douglas, Senator Francisco.
If there are no more questions.
Are there further questions? Chair recognizes Senator from Montgomery, Senator Peck.
Thank you, Mr. Chairman. The amendment is, I heard the carrier say 4 words, it's actually 5, but maybe I just misheard. It just inserts the words except for the fire safety codes. But as far as a question, Mr. Chairman, if this goes on, could it potentially require that an agritourism operation install water sprinklers in barns, houses, other outbuildings?
Senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. I don't know that there would be any requirements for that in barns. I'm simply responding to the request from the fire marshal to not be the one that does the inspections for these agritourism businesses.
Senator from Montgomery, Senator Peck.
Thank you, Mr. Chairman. I understand the intent of the amendment and don't really have a problem with the intent. If this amendment does go on, I would assure the body that prior to this amendment this legislation making it through the final process, the chair of the committee will certainly seek an answer so that in conference we can make certain that we are not putting some onerous regulations on an agritourism business. So I probably will vote against it just because of that one uncertainty, but as far as the intent, I understand the intent, and that's fine. But with that, I'll leave it to the will of the body, Mr. Chairman.
Are there further questions for the senator from Douglas? Chair recognizes Senator from Johnson, Senator Thompson.
Thank you. Yeah, at first I was in favor because we did hear from the fire marshal and said he didn't want to mess with it. He wanted to turn it over to Lenexa, and I think the good senator from Douglas is trying to respond for that. But the more I think about it, the city of Lenexa and its fire department could impose some things that we don't anticipate. And I'm not sure that given the situation that I'm aware of there, that I'm as comfortable right now to do that. I would like to have some assurances that they wouldn't overstep their bounds. And so I too may not support this. Thank you, Mr. Chair.
Are there further questions on the amendment? Seeing none, Senator from Douglas, you may close.
Thank you, Mr. Chair. So we had a discussion earlier this afternoon about fire codes, and my understanding from that discussion is that we adopt a particular year for a fire code, and so I'm assuming that that code would be in effect in many ways throughout the state. There are a few entities that have adopted more specific codes. I would certainly want to work with the senator from Montgomery on a conference committee, and if this would require fire sprinklers in the barn, would be more than happy to take it out at that point. I think it would be easier to take it out in a conference committee than it would to add it in. So with that, I move my amendment.
You've heard the motion. All those in favor say aye. Opposed, no. Motion fails. We're back on the bill. I recognize Senator from Montgomery, Senator Peck.
I have nothing at this time, Mr. Chairman. There are a couple other senators.
I recognize Senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. I had another concern about this bill, and the testimony had been concern about requirements being added from a city. And yet this bill addresses to say no city or county shall enforce any code. And so I think we're going beyond what is necessary. And I think we should think very carefully if we start to say no city or county shall enforce any building code or any other ordinance or resolution regulating the use of a non-public registered agritourism location. And that's a location that's been specifically designed for this one event. Because of that, I'm concerned that we're including county. I have an amendment. I've turned it in.
What is the number?
4517.
We'll pause while the amendment's distributed. And the amendment appears short. We'd like to explain your amendment.
Thank you, Mr. Chair. The amendment is to strike the words or county on line 7. And so this would mean that a city couldn't enforce codes. The situation that we're talking about is an agritourism facility that's within city limits. But most agriculture, or a lot of agriculture, is in the county. In this particular case, it probably at some point was annexed. The land was annexed by the city. But generally, county rules would apply to agriculture. There's a lot of exemptions for agriculture in our county rules. So I think it's more appropriate that this bill address city requirements, not county requirements. I'd stand for questions.
Other questions for the carrier from the amendment? The chair recognizes Senator from Montgomery, Senator Peck.
Thank you, Mr. Chairman. County, those of us who live rural, of course, live in a county. And we a lot of times live rural because we do not want interference from government at any level, whether it's city. We realize there are certain regulations, guidelines that we do have to meet, of course, but removing the word county provides me with more heartburn than a bottle of Rolaids could cure. So I'm I'm not going to be supportive of the word, removing the words "or county" in this amendment. Thank you, Mr. Chairman.
Are there further questions on the amendment? Seeing none, Chair recognizes Senator from Douglas. Senator Francisco, you may close.
Thank you, Mr. Chair. We are taking away a lot of local control. We're saying that a business that has members of the public come to their location can be exempted from every rule. I think we should keep at least some county rules, if they exist, on these agritourism businesses. I move my amendment.
You've heard the motion. All those in favor say aye. Opposed, no. Motion fails. We're back on the bill. Chair recognizes the senator from Miami, Senator Shane.
Thank you, Mr. Chair. I wasn't quite ready to bring a bill called Crushing Municipal Agricultural Whitewashing, but this bill lives up to that spirit. These agritourism businesses, particularly in a municipal area, are a reminder to our suburban and urban friends of our agricultural roots and give folks the opportunity to go and experience that in a private way. The locations and the businesses that this bill seeks to address are not tourist destinations or theme parks or a place to go have a party. These are by invitation only operating farms where people can come and experience that. It's different than going to a vineyard where there's potentially an event venue and all of those things. The senators, including myself that worked on this bill, sought to narrowly tailor it. We don't believe that these operations should be forced to put in paved parking lots and ADA compliant sidewalks and ramps and have all kinds of extreme requirements put on them when they're simply trying to share the spirit and beauty of Kansas agriculture. So with that, I hope that this body will support this bill. I think it's a good bill that helps address this issue. Thank you.
I recognize Senator from Douglas, Senator Francisco.
Thank you, and I appreciate that because I was still standing. So I have some other questions. We're talking about this tourism location being invitation only. How does the senator from Montgomery know how you can get an invitation?
Senator from Montgomery, Senator Peck.
Thank you, Mr. Chairman. Just like about any other place you'd get an invitation to, as far as in the rural areas, if I know you or someone knows someone who knows me and reaches out, I'm most likely going to allow an invitation to dinner. However, these agritourism businesses, many do have a website, but it's very clearly stated, by invitation only. So from that, Mr. Chairman, I'm going to presume that individual would reach out to these agritourism, and then the landowner, the owner of the land and the working farm could say, well, yes, how about coming on such and such a date, or no, I'm not going to have any time because I'm busy harvesting, I'm busy planting, I'm busy calving, or whatever. So I guess I can't specifically address how an invitation is obtained, but you have to be invited to come to the facility for the tour of the working farm operation.
Senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. Yes, indeed, the business that came to us and was requesting this bill has a website. And the website announces the hours during which you can ask them to send you an invitation. So essentially, yes, they're giving you an invitation, but they've got a website that says we're open these hours Monday through Thursday, and we're open mornings on Saturday. So in fact, that's not very much of a jump. So they will know, but I don't know why it would be, having this invitation would be that much different from someone reaching out and saying you have to buy a ticket. So I continue to feel that there's some problems with this. I understand the underlying concern, but this to just say we're not going to have any rules and that all you have to do to get an invitation is to ask for one seems to be setting us up for having members of the public come to a place that we are saying the local municipalities can have no control.
Chair recognizes Senator from Barton, Senator Blue.
Thank you, Mr. Chair. I have a couple questions for the carrier of the bill. First, just want to make sure that this bill is dealing with the fact that cities are trying to encroach and put in their own rules, regulations, building codes on property that was not part of the city. I understand that correctly?
Senator Montgomery, Senator Peck.
Thank you, Mr. Chairman. Once a city has gotten its boundaries out to these locations, then they feel that since they have moved out to these locations, they should start regulating and passing ordinances and codes and resolutions, et cetera, telling the owners of these properties and their acreages. It's not like we're talking about a 5-acre plot of land. We're talking about an operating agriculture facility. So I talked so much I even forgot what the question was, but the cities, I'll let the question be asked again if I didn't answer it.
Senator Barton, Senator Blue.
Thank you, Mr. Chair. The major issue I have is that cities are telling areas that are not in city limits what to do with their property, all the way down to building permits and city ordinances, and it's not located in the city. Is that maybe something that's been happening or what could happen if we, I'm looking at this bill and I know that we're talking about one area, but the major issue I have is with the 3-mile radius that that cities have. So with that, I have an amendment and it's been turned in. It's 4507.
We'll pause for distribution. And the amendment appears long. Would you like to explain or have it read?
I would like to explain when the time is right, Mr. Chair.
Thank you. Senator from Barton, Senator Blue, the time is right.
Thank you, Mr. Chair. So this bill has to deal with the 3-mile radius. And I don't know if you guys have heard, or if anybody in the body has heard about the 3-mile radius being an issue, but I can tell you one thing, that as somebody who does not live in city limits, but according to the city, they say that I live in the 3-mile radius, which I don't, as I have measured it. Now I have to abide by city ordinances. I didn't choose to live in the city. The city limits have not grown, probably I don't know how long. We're actually losing population in my town. And each city is being more and more strict over this. We have had bills about this. We've had hearings about this. We have requested for interims over this issue. This is an issue. It's taxation without representation. And it's to the point that something needs to be done. Some cities are even going in and they're making stricter laws over the 3-mile radius than counties have over it. So with that, I think this needs to be done, and I think this is the perfect vehicle for it to be done, and I'll stand for questions.
Chair recognizes Senator from Reno, Senator Murphy. You may be seated, Senator. Chair recognizes Senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. In fact, the underlying bill, House Bill 2111, deals with city regulations over properties that are within city limits. This is not talking about city regulations extending beyond city limits. With that, I would question germaneness.
Germaneness has been questioned. We will form the Rules Committee for decision. We'll stand at ease. Chair recognizes Senator from Montgomery, Cherokee, Senator Schallenberger.
Thank you, Mr. Chairman. Without any further ado, we'll just say that the amendment is not germane.
The amendment has not been germane. The carry amendment. Chair recognizes Senator from Montgomery, Senator Peck. Any questions? Chair recognizes Senator Barton, Senator Blue.
Thank you, Mr. Chair. Well, that's a real shame. Hopefully, this will put a fuel under our fire to actually get this legislation passed or an interim committee done on it, because I had a ton of senators ready to speak in favor of this. So I look forward to hopefully getting this accomplished next session. Thank you.
Chair recognizes Senator from Reno, Senator Murphy.
Thank you. At the risk of dragging this out any further, I'm probably the only person here, Mr. Chairman, that actually has an agritourism business. And so just to kind of set this record straight, there's actually legislation and statutes that govern agritourism. And so we're not just unregulated, just out there doing whatever we want. The bottom line is I do support this bill, and I appreciate the opportunity. Thanks.
Chair recognizes Senator from Lynn, Senator Tyson.
Thank you, Mr. Chairman. I was just going to thank the good senator for her attempt on the 3 mile. It is very important and much needed legislation. Thank you.
Are there further questions for the senator from Montgomery? Chair recognizes Senator from Barton, Senator Fagg.
Thank you, Mr. Chairman. Was the question of home rule ever brought up in this, and where the law is on that type of thing?
Senator from Montgomery, Senator Peck.
Thank you, Mr. Chairman. I heard during committee the words home rule brought up, but it was not discussed at length.
Senator from Barton, Senator Fagg.
So who were the opponents on this bill?
Senator from Montgomery, Senator Peck.
Thank you, Mr. Chairman. I will need to look and see, but I believe it was the cities that would have been opponents. Yep, well, we've got the usual suspects, the League of Kansas Municipalities. We've got City of Shawnee. We've also got City of Overland Park. And Well, the fire marshal was in opposition, but primarily because of what has already been discussed. And now I've got my papers so jumbled up thanks to the senator from Butler. But no, it looks like those are all the opponents that we had.
Senator from Butler, Senator Fagg.
And I'm thinking it might be the county association too. I don't know, remember that part. But this home rule is a big deal. The 3-mile radius is a big deal. I think we got to be very careful of how we do this. So I'll be standing for no on this until we can understand that part of it. Thank you.
Chair recognizes Senator from Montgomery, Senator Peck. Seeing no further questions, you may close.
Thank you, Mr. Chairman. I do also want to say that it's too bad that the amendment was ruled not germane, because we've got cities that this 3-mile keeps getting further and further away from the original city, because as a city expands its boundaries, that 3-mile also is expanded. And we need to protect rural Kansas. We're going to really be encroaching into our production agriculture land if we're not careful, but that's a whole nother topic that will be gotten to hopefully at a future date. House Bill 2111 is not just about one location, it's about the state of Kansas and protecting agritourism across the state. One of the focuses of 2111 is not only to protect agritourism, but to protect these locations where those who do not know or understand exactly where our food comes from, like eggs. We've got kids that don't know where eggs come from. And I'm not going to tell you where they come from. If you don't know, look it up. Milk, where does milk come from? They do not understand where milk comes from. They do not understand that a hamburger once was, well, you know what it once was. It was an animal out in the field. And so I just think it's important as an agriculture state that we do everything we can to protect agritourism. And so there's probably more I could say, but probably more I should not say. So with that, I better just make a motion that when the committee rises and report, that it report House Bill 2111 favorable for passage as amended.
You've heard the motion. All those in favor say aye. All those opposed, no. Motion carried.
All right, body, we will now return to House Bill 2528. Chair recognizes the senator from Johnson, Senator Gossage.
Thank you, Mr. Chair. I believe we left off with there was an amendment coming.
Very good. Questions? The chair recognizes the senator from Wyandotte, Senator Petty.
Thank you, Mr. Chair. I do have a couple of questions for the senator from Johnson about the bill.
She's standing.
Thank you, 2528. And I was wondering if the good senator from Johnson could share with the body how many years with this legislation will certain records be voided?
Senator from Johnson.
I believe it's back to 2005, Mr. Chair.
Senator from Wyandotte.
Thank you. So we're talking about with 21 years?
Senator from Johnson.
I believe that math is correct.
Senator from Wyandotte.
Thank you. So can the board actually start identifying now with as under the current legislation, can they actually start voiding those files now?
Senator from Johnson.
The senator is in the committee, and in committee we had an amendment that made this bill effective upon the register.
Senator from Wyandotte.
Upon register, yes, but they could, yes.
Senator from Wyandotte.
Under current legislation, they could?
Senator from Johnson.
Well, I understand that there have been some of the nurses that have been questioning and asking for them to go back and look at the record, but I think it would be, this would be a matter of days if this was approved and the governor were to sign it, that they could go back. So as far as today, I would say I'm not certain, but as soon as this bill is approved, that would be yes.
Senator from Wyandotte.
Thank you. So yes, they actually couldn't, under current legislation, they could not avoid those files. And there currently are 3,688 over a 21-year period of cases that would have to be looked at individually because a nurse or a licensee under the Board of Nursing could have a license that was flagged for multiple reasons, not just one. When does, Senator from Johnson, when does the license expire?
Senator from Johnson.
There is a date in which the licensed is due, so for registration, and then there also is they have a 30-day grace period, and then they have, during that time, if the grace period, they could go ahead and pay their $300 fee, in which time they could be reinstated. If they have not done that, then I believe that the term is that it would, I'm sorry, I've forgotten the terminology that was added in one of the amendments. I apologize, I'll find that.
Senator from Wyandotte.
Thank you. I believe the word is lapsed. Is the word expired used in House Bill 2528?
Senator from Johnson.
The word was changed to lapse, and in checking with the compact that the nurses are a part of, they said they could use the understanding was they could use the term expire, lapse, as long as they have a date certain.
Senator from Wyandotte.
Thank you. Well, in fact, there are 43 states that are part of the nursing compact, and all of those states do have an expiration date. So there is a concern that now using just the word lapse could have an impact on Kansas's ability to be under the compact, because there's a difference of terminology from between expired and lapse. So does the bill now make it acceptable for the Kansas Board of Nursing to use the renewal date as the expiration date?
Senator from Johnson.
Typically, the renewal date is the renewal date, and the nurse's license would continue to function as a nurse during that grace period. So that lapse would not be until after the grace period. And Mr. Chair, during committee, the time in the Senate, the amendment was brought by the senator bringing the questions of asking if we could change that grace period from 90 days to 30 days, and that was voted on and approved in the committee.
Senator from Wyandotte.
Thank you. So there, and could the senator from Johnson, so what is the length of the contract that we're speaking, that a nurse would, or the license that a nurse would have once they apply?
Senator from Johnson.
That has not changed. It's still 2 years.
Senator from Wyandotte.
2 years, and the renewal date is in the month of their birthday. Is that correct?
Senator from Johnson.
The renewal date would, I believe, the month of their birthday.
Senator from Wyandotte.
Thank you. It is correct. It is in the month of the birthday, and it is, although that's it's a little difficult to find at times in this bill, but I appreciate that the senator has confirmed that it's a 2-year license. One of the things that I think it's important for the body to know is that the mission of the Board of Nursing is to protect and promote the welfare of the people of Kansas. And that is in their, probably not many people have had the time to look at, but it is in their annual report that comes out from the Board of Nursing every year. The other thing is that it has seemed that this has become quite a topic this year in the legislature. However, in 2024, I will just say that until this year, I had not heard anything about problems with the Board of Nursing until this interim period. And so I did a little looking around, and there, probably last year, you might remember, you got a report called The State of Nursing in Kansas. It was put out by the Kansas Nursing Workforce Center, and it's done every, I think, 3 years. And interestingly, in that report that came out in '24, there was no mention in the report about licensing being a hindrance for nurses in the state of Kansas. But what was in the report was the fact that we do have a higher number of nurses leaving the profession than in other states because they want to spend more time with their families, or the long hours of where they work, and that these are the issues that stand in the way of some staying into the profession. But it was never ever mentioned in this report about any problems with licensing. It also mentioned the fact that we have more slots for nursing students today in Kansas, but fewer going into it. So I think we do have some things to look at to attract people into the profession of nursing, but licensing, at least according to this report, which comes out every 3 years, was not an issue. As one of the things that I found as I looked at this very aggressive, invasive bill is that it has within the bill a section that no other board that none of our licensing boards have, not the Board of Pharmacies, not the Behavioral Science Regulatory Board, not the Board of Veterinary Examiners, the Emergency Medical Services Board, the Board of Healing Arts, the Board of Mortuary Arts, the Board of Examiners and Optometry, or the Dental Board. None of them have this, but we now, in this bill, are putting into statute sorry, I'm losing my train of thought here, a private right of action with this board. So with that, I have an amendment.
Has the amendment been turned in?
It has.
And what is the number, Senator?
The number is 4485.
Very good. Give us just a minute, please.
Mr. Chair, if I may, while the amendment is being distributed, I'm told that other states have other terms for expired. The only requirement by the compact is that the date of license is no longer eligible for practice. There needs to be a day certain. Thank you, Mr. Chair.
Thank you. Please make sure you're recognized, senators, before speaking. Senator, would you like to explain your amendment?
Yes, I can explain my amendment. For those that have the bill, as I mentioned, we have not, this is a private right of action is not something that we and Kansas have put in our legislation when it comes to our boards. And I just went through that list of those that are dealing with the medical profession. But this bill puts into statute the private right of action, which is very punitive, but yet it actually does, I think some people feel it's going to protect the licensees, but in fact, it is just that putting the cause that there could be many more lawsuits brought that would be frivolous and not necessary. So that's why on page 15, it removes all of the language dealing with the private right of actions with this board. It does not remove a licensee's ability to do that because that is available to them currently, but it does take it out of the legislation.
Will you stand for questions?
Yes, I will.
Questions for the senator from Wyandotte. Chair recognizes the senator from Sedgwick, Senator Clays.
Thank you, Mr. Chair. I'm generally against these private right of actions. I think they're a bit overdone, and we should be really careful about when we use them. But if any board deserved having a private right of action, it's this nursing board. They are just absolutely, well, I'll just leave it at that. But this is an amendment that I can't vote yes on because I think that needs to stay. Thank you.
Further questions on the amendment? Senator from Johnson, Senator Gossage.
No, I will hold till close. Thank you.
Good. Any further questions? Chair recognizes the senator from Johnson, Senator Corson.
Thank you, Mr. Chair. I stand in support of this amendment. I don't think it makes sense to create in statute a private right of action against one of our regulating boards when we don't have that anywhere else in statute with respect to any of our other boards that regulate licensees. Certainly if there's something that rises to necessitating or arises to being a valid legal claim, somebody could always bring a lawsuit against any board. But again, we have so many regulatory boards in Kansas, and none of them specifically state that licensees have private rights of action. So again, I don't think it's appropriate to single out one board when none of the others have it. So I'll be opposed to the amendment for those reasons. I will be supporting the amendment for that reason.
Further discussion? The chair recognizes the senator from Sedgwick, Senator Erickson.
Thank you, Mr. Chair. I'm on the Public Health Committee, and what we heard from nurses and the actions of this board is so egregious. I understand we don't do this for other boards. Other boards haven't acted as egregiously as the Board of Nursing, and if I could, I would join the comments from the senator from Sedgwick, Senator Clays. Thank you, Mr. Chair.
Any further questions on the amendment? Seeing none, Senator, you may close or move your amendment.
Thank you. I do think it's unfortunate that sometimes we listen to only one side, and I will note that if you look at any of the hearings, you will notice that never was it asked, are you currently working? And I think that if that question had been asked, and in many cases, you would have found that these licensees who are speaking of something that's happened to them are working. The other thing is that, and I had it put on each of your desks, information about the number of licensees that we're talking about. So if you heard from 5, there are 72,739 licensees under the Board of Nursing. In comparison, under the Board of Healing Arts, there are 36,000. This is a lean staff. They don't have 26 employees, unlike the Board of Healing Arts that has, I think, 67. So, as I said, that their mission is to protect and promote the welfare of the people of Kansas. Some of the stories you may have heard talk more about protecting that employee, because I want to remind you that there's never a investigation that isn't brought forward unless there's an action on the part of the licensee. So there has to be some action on the part of the licensee that would cause someone, an employer or a patient, to report that person, that licensee. Or they just didn't renew their license. In this bill, so much is put into statute, and this is just one example of the fact that you have this protection, you can bring it about, but we're putting it into legislation. It's a very poor move to go, whether it's the Board of Nursing. If we do it with the Board of Nursing, shouldn't we be doing it with every other regulatory board that we have? I'm not sure that that's where we want to go. This legislation now would basically say, if I think that the board thought about me in an adverse way, I can bring action against them and I can recover up to $10,000. These dollars are the license fees that have paid by the licensees. So they are Kansans, and they are Kansans dollars that are being used. And so where we may think this can benefit a few people, it is very adversely affecting over 72,000 nurse licensees that are under the Board of Nursing. So with that, I move my amendment.
You've heard the motion. Those in favor signify by saying aye. Those opposed, no. No. Motion fails. We are back on the bill. Senator, you still have the floor.
Thank you. I have another amendment.
Have you turned it in?
I have.
What is the number?
The number is 4487.
Very good. Give us a moment, please. Senator, would you like to explain your amendment?
I will. This is dealing with the same issue. However, within the bill currently, this would just remove the portion that deals speaking with the amount of money or payout that the person might get if they were successful in court. It says future losses or $10,000, whichever is more. Even though I still maintain that a licensee has a private right of action, this then keeps the language in but removes the amount of funds. So with that, I'll stand for questions.
Questions for the senator from Wyandotte.
If I may.
Senator from Johnson, Senator Gossage.
This is, initially, this is just trying to eliminate the provision that came from Federal No Fear Act, and it applies to federal regulatory boards. Additionally, this board has filed against licensees because licensees reported people affiliated with the board, and this gives them that protection from retaliation, Mr. Chair. Thank you.
Seeing no further questions, Senator from Wyandotte, you may move your amendment.
So actually, this does not. I mean, the language is in there about the fact that that a licensee could make any comments about a board member or an employee or what they perceive as a violation of law, whether it be fact or not. They can make these, and the board could do nothing about it. In turn, but the board could not do the same, could not take or make false actions against a licensee. And if the licensee thought that was the case, they do have a private cause of action. So that language is in there if the concern is about comments that the board might make, although the the actions of the board deals with discipline for those that have not either renewed their license on time or have committed egregious actions like drug abuse, sexual abuse, injury to a patient. And those are, I'm sure that no elected official wants to see those kinds of things occurring in the care of our patients, in the care of anyone that deals with the health profession in the state of Kansas. So this would just remove that monetary amount that would be that you would go to with those decisions. So it still has in there that they couldn't, that supposedly the board couldn't say or their staff say anything, but a licensee could say whatever they want to. That is still, the language is still in there. So with that, I move my amendment.
You've heard the motion. Those in favor say aye. Aye. Those opposed? Motion fails. We're back on the bill. Senator Petty, you still have the floor.
Thank you. So I just want to remind the body that this legislation has voided or eliminated 31 or affected 31 statutes that regulate the Board of Nursing. 31 statutes. As I was reading this bill, and I would not be surprised that most of us have not read it completely, it made me think of Senate Bill 361 when we changed juvenile justice oversight, that it was so encompassing, and that we have a reaction to what we've heard from, remember, we're talking about over 72,000 licensees that are under the Board of Nursing. That doesn't mean that some people may not feel that they actually applied for a license correctly and then it was not recorded correctly, but they may also have been practicing without a license. And that, and practicing without a license, if you're a nurse, doesn't just mean patient direct care. It means speaking and representing yourself as a nurse, just like we can represent ourselves as a senator, but it would be a little it would not be appropriate if we were saying we were senators and we were not. So that's the other part about licensing. This legislation makes a lot of changes. It also has a financial impact on what is available through the Board of Nursing to deal with the licensees. There were amendments that were made in the legislation as it was worked in the Senate committee that help with being able to work with this bill in the future. But I beg this body to remember that we want to have safe, qualified licensees under the Board of Nursing working in our state of Kansas. And we also want them to be able to be part of the nursing compact, because right now, of that over 72,000 licensees, around 22,000 of them are compact certified, which means they either are Kansas nurses that are working in another state, or they're nurses from another state working in Kansas. So I think that we should be sensitive to the fact that we need to have, one, boards that represent and do the job that's appropriate for them, and work under the legislation that we have put in place. Thank you.
Chair recognizes the senator from Harvey, Senator Owens.
Thank you, Mr. Chairman. I have an amendment. It has been turned in. The number is 4479.
Give us just a minute, please, to get that ready. Senator, would you like to explain your amendment?
I'd be happy to explain my amendment, Mr. Chairman. I followed this issue since it first was an interim committee, and we saw testimony after testimony of the egregious work by the Kansas State Board of Nursing and how it has impacted the lives of so many that serve in this noble profession. What we've also heard as this has worked through the legislative process is that they've done nothing wrong. They see no error in their ways. As I might just quote, appearing before the House Select Committee on Government Oversight on Friday, this was as of March 1st, I'm reading this out of the Sunflower Journal, the agency's executive director was asked directly whether the board believed it erred in making enforcement decisions related to licensing. Carol Moreland told lawmakers that the board did not believe it had made any mistakes, which not only frustrated lawmakers on the committee, including one key lawmaker who said it was time to remove the current board. I tend to agree with that, Mr. Chairman. And so what my amendment does is strategically removes the existing board. It calls for the governor to reappoint a temporary board, and then on January 1st of 2027, ensures that every single board member is replaced by a new administration. In addition, it makes it very clear that members of the Board of Nursing serve at the pleasure of the governor. While I believe there are very good members of the board, I believe that it is time for structural change in the leadership of that organization, and we as a legislature do not have the ability to terminate those employees, but the board does. And I think that it is time for the board to be held accountable, to undergo Senate confirmation, and to make sure that we truly see the change that we need to see with a new Board of Nursing. And I'll stand for questions.
Questions on the amendment? The chair recognizes the senator from Wyandotte, Senator Petty.
Well, I would encourage the body to not vote for this amendment. We are, and I'm sure it will pass today, Senate Bill 2528. We're passing legislation that it is making major changes, and also, which I mentioned earlier, it is directing the board to void 21 years of records that fall within the category of license that arise from it or is related to the applications for licensure, license renewal, license reinstatement, or practicing while the license has lapsed. In order to do that, as I mentioned earlier, there are over 3,000, almost 3,688, I think it is, that would have to be looked at on an individual basis. We need to have someone who has regulatory knowledge. And I would beg to say that we don't. We are, in this body, there is not a nurse. And even if there were, they may or may not be serving on the board. So there are guidelines for how they work. And also remember, these are volunteers that are that agree to serve. There are 11 of them on the board. And they're not being paid, but yet giving of their time and their expertise to make sure that we have over 72,000 licensees that are licensed, and we are protecting the health and welfare of Kansans. Removing the board now will, one, guarantee that they will not be able to meet the expectations of this legislation. And it will also mean, if that's what we want to see happen, that we will be spending their reserves to pay out because those, and I don't know the number, but it's been estimated that it could be around 600 over 21 years of license that need to be voided, that those would not be voided, and that we would then be paying out from the Board of Nursing's reserves, which are licensees' fees and those are Kansans. So if this body believes that it's appropriate to just have a slush fund to be setting out there, and then I would just remind you that I have a question I'm thinking about. How, once these are voided, and if I come up and say, I have been affronted in some way, what's the evidence? Because now everything has been voided for that if it was a licensee issue. That's a question that this bill is creating. But eliminating your board that is in place, and then expecting the board to, I guess, fire the staff, then where do you have the training and the ability to follow through and continue to license our nursing professions in the state of Kansas? This is a very poor way to deal with a problem, or to say that we have some problem with the personality of someone. This is just vindictive, and it's not, I think it doesn't say anything good about the Kansas Senate.
Senator from Harvey, care to respond?
I'll respond to my closing.
Chair recognizes the senator from Sedgwick, Senator Clays.
Thank you, Mr. Chair. There is no perfect bill. This bill came to our chamber today, and it was a good bill. And with this amendment, it becomes a great bill. This is exactly what we need, because our job is to hold people accountable, because we are working on behalf of our voters, and I believe our voters don't want to have a rogue group like this harming our nurses, and that's what I've seen. The stories are just, I mean, you want to say they're just a handful of stories. They're terrible stories. When I was a school psychologist, I left for 8 years and worked in the corporate environment. I let my license lapse. Why would I keep my license? I'm not working. And then when I came back, I got my license back. That wasn't unethical, was it? Was that unethical of me? Well, if you're a nurse, that is unethical, evidently. That's exactly what they've done to a lot of people, is they let the license lapse, they didn't practice during that time, and then they came back, and suddenly it's unethical. This board was just irresponsible, and therefore, it's incumbent upon us to remove them. Thank you.
Chairman recognizes the senator from Wyandotte, Senator Petty.
Mr. Chairman, I have to disagree with the senator from Sedgwick. If a licensee lets their license lapse and they're not practicing, they can reapply when they decide they want to come back into the profession. So that's available and has been available and will continue to be available. It's practicing without a license, which I'm sure that, as the senator from Sedgwick said, he did not do and would not do, but he did when he decided to come back to doing his profession, he reapplied for a license. Just like I could do as an educator, I no longer am practicing and I no longer have a current license. If I wanted to go back into the classroom full-time, I would have to renew my teaching license. So saying that a person is then violating because they let it lapse is different than not renewing or practicing without a license. Those are not the same things.
Further questions for the senator from Harvey?
Mr. Chair, we heard in committee that...
Chair recognizes the senator from Johnson, Senator Gossage.
Thank you. We heard in committee that reinstatement is actually quite difficult. And yes, we heard several stories of people who were trying to be reinstated and they already had some blight on their permanent record, saying that they had been practicing without a license or something of that nature. And this bill addresses that because it does give that 30-day grace period. There was no grace period. I just want to say also, the nurses' only issue with the board is that their lack of attention to the nurses' concerns. The nurses' real issue is with the administrators and they're being zealous with over-disciplined perceived licensing infractions, they're called. But it's true, the board does oversee the administration, and there are definitely some concerns about the board not having done that. Thank you.
Chair recognizes the senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. I have some concerns about this amendment because generally, if you're appointing members to a board, you try to have staggered terms so that you have some members with some experience rather than trying to start with a whole new board. So I'm looking at this amendment, and it says that if confirmed, such members shall serve for the terms described in subsection A. And would those terms then be all for the same number of years for all 11 members of the board?
Senator from Harvey.
I'm in the process of looking up the bill specifically where it references subsection A and what those terms are.
Senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. It's on page 19, starting on line 40. It took me a little while to find it.
Senator from Harvey.
So the way that this, you said page 19, what line was it?
Senator from Douglas.
I'm sorry, could you repeat that question?
Senator from Harvey.
Page 19, what line?
Senator from Douglas.
Thank you, line 40.
Senator from Harvey.
Very good. While I'm reviewing that, I want to be clear that what this says is from the time that this occurs, that this bill becomes law, which by the way is in the Kansas Register because of the urgency of this situation, that the governor shall then appoint an interim board. There's nothing specifically saying that she couldn't technically replace the existing board. They would then just, however, be subject to confirmation and oversight, which is a key part of this. So if there's any concern that there needs to be a specific member there, the governor, at least as I read this, would still have the ability to do that. They would just become subject to oversight. That being said, as I look at line 40, line 40 does not specifically talk about, it talks about the term being, sorry, I got to look a little bit closer here with my bifocals. It talks about the term being talks about the 11 members of which 6 shall be registered professional nurses or advanced practicing nurses, 2 shall be practical nurses, 3 shall be members of the general public. The 11 members shall constitute a board. Still looking for the part where it says how long they serve. I believe they serve 4-year terms, but it is not. Yeah, there you go. Thank you. I should have just turned to the professionals all along. They're 4-year terms is what they are.
Senator from Douglas.
Thank you, Mr. Chair. So then my question was, if they're all appointed at the same time or confirmed, then do their terms all expire at the same time?
Senator from Harvey.
Yes, unless some leave early or whatever, or choose to depart, or at the will of the governor, they serve at the will of the governor chooses to replace them.
Senator from Douglas.
Thank you, Mr. Chair. And I was just giving the senator the place where it started, and in fact, it continues on page 20, and it talks about the members of the general public shall be appointed for a term of 4 years, and others. So what we're doing is putting in place a new board all at once without individuals with experience, and then we may be requiring that changeover can happen, or we're saying it can happen every 4 years, and we can continue instead of having staggered terms. Thank you.
Any further questions? The chair recognizes the senator from Johnson, Senator Gossage.
I just have 2 clarifying questions that I think will help the body. So this board, as I believe the carrier of the amendment said, that needs to be reappointed by the governor. Could be the same people, could be different people, but the difference is this time the Senate would have oversight over the board. Under current law, without 2528, there is no Senate oversight. This would allow for the Senate oversight of the board, and it would be a temporary board, not changing the staggering of the board going forward.
Any further questions on the amendment? Seeing none, Senator, you may close.
Thank you, Mr. Chairman. Sometimes the writing is on the wall and we should read it and we wouldn't be having to be worrying about this amendment. But unfortunately, it has been made abundantly clear to the legislature in the House and in the Senate that they're not reading the writing on the wall, and it's time for a structural change within the Kansas State Board of Nursing, and I move my amendment.
All heard the motion. Those in favor say aye. Those opposed, no. Motion carries. We are back on the bill. Any further questions for the senator from Johnson? Senator from Finney, Senator Clifford.
Thank you, Mr. Chair. I appreciate your great job today. I appreciate the chairs of both the House Health Committee, Representative Carpenter, and especially our chair, Gossage, of the Senate Public Health and Welfare Committee. My chair gave me free rein in this investigation to look into the issues and discuss them with all stakeholders and seek their input. I want to especially thank Representative Pickard from the House, Representative Lewis, Representative Orpeza, and Representative Weichel. Also Mr. Darren Patterson, Senator Petty, Ms. Watson, the board chair, and Ms. Moreland. It was a pleasure to hear from all stakeholders. I think this is an aggressive piece of legislation, but appropriately crafted, and I will be voting aye. Thank you, Mr. Chairman.
Seeing no further questions, Senator, you may close.
Thank you, Mr. Chair. I move that when the committee rises and reports, it reports House Bill 2528 favorably for passage as amended.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion passes. Chair recognizes the majority leader from Sedgwick, Senator Blasey.
Thank you, Mr. Chairman. I move the committee rise and report.
You've heard the motion. Those in favor say aye. Those opposed, no. Motion passes.
Clerk will read the committee report.
On motion of Senator Blasey, the Senate resolved itself into the Committee of the Whole for consideration of bills on the calendar under the heading of General Orders. Recommended, House Bill 2781, House Bill 2644 be passed. Senate Bill 524, House Bill 2485, House Bill 2613, House Bill 2651, House Bill 2573, House Bill 2481, House Bill 2466, House Bill 2527, Sub-House Bill 2595 be amended by the adoption of the committee reports and the bills be passed as amended. House Bill 2402 be amended by the adoption of the committee report recommending a substitute bill and the substitute bill be passed. House Bill 2111 be amended by the adoption of the committee report recommending a substitute bill be amended by the Committee of the Whole and the substitute bill be passed as amended. House Bill 2767, House Bill 2596, House Bill 2114, House Bill 2521, House Bill 2553, House Bill 2739, House Bill 2357, Senate Bill 521, House Bill 2528 be amended by the adoption of the committee reports, be further amended by the Committee of the Whole, and the bills be passed as further amended.
Chair recognizes Senator from Johnson, Senator Thomas to adopt the committee report.
Thank you, Mr. President. I move we adopt the committee report.
With the motion, all in favor say aye. Opposed, no. Motion carries. Report's adopted. Chair recognizes the majority leader from Sedgwick, Senator Blasey.
Thank you, Mr. President. I move an emergency be declared, the rules suspended, the following bills be advanced to final action and roll call. Senate Bill 524, House Bill 2767, 2485, 2613, 2651, 2596, 2573, 2481, 2781, 2114, 2466, 2528, 2521, 2527, 2553, 2644, 2739, 2357, Senate substitute for House Bill 2402, Senate Bill 521, Senate substitute for House Bill 2595, and Senate substitute for House Bill 2111.
You've heard the motion. All those in favor say aye. Opposed, no. Motion carries. We'll hold for final action. We are now ready for final action. We will have multiple roll calls. On the first roll call, we'll take Senate Bill 524, House Bill 2767, 2485, 2613, 2651, 2596, 2573, 2481, 2781, and 2114. The clerk will read the titles.
Senate Bill 524, an act concerning public monies. House Bill 2767, an act concerning veterans and military. House Bill 2485, an act concerning post-secondary education. House Bill 2613, an act concerning the Crime Victims Compensation Board. House Bill 2651, an act concerning children and minors. House Bill 2596, an act concerning the Secretary of Corrections. House Bill 2573, an act concerning the Kansas Board of Accountancy. House Bill 2481, an act concerning tourism. House Bill 2781, an act concerning the State Historical Society. House Bill 2114, an act concerning water.
Clerk will call the roll.
Alley. Argabright. Bellinger. Lazy. Blue. Bowers. Bowser. Clays. Clifford. Corson. Dietrich. Erickson. Fag. Valscado. Francisco. Gossage. Haley. Hill. Holscher. Klemp. Cluse. Masterson. Miller. Murphy. Owens. Peck. Peterson. Petty. Rose. Reichman. Schmidt. Schallenberger. Shane. Starnes. Sykes? Thomas? Thompson? Titus? Tyson? Warren?
Has everyone had an opportunity to vote? Any senator wish to explain their vote? Senator from Johnson, Senator Holscher.
I need to switch a vote aye to no on 2485.
So ordered. Further changes or explanations? Senator from Johnson, Senator Corson.
Aye to no on 2485.
Further changes? Senator from Sedgwick, Senator Fauskido.
Aye to no 2485.
Senator from Sedgwick, Senator Miller.
I did no on 2485. Thank you.
Senator from Shawnee, Senator Schmidt.
I did no on 2485.
Starting to feel like a team sport. Further changes or explanations? Seeing none, clerk will close the roll, tally the vote. Forty having voted in favor and none opposed, the passage of Senate Bill 524. 39 in favor, 1 opposed to House Bill 2114. 33 in favor, 7 opposed to 2481. 25 in favor, 15 opposed to 2485. 40 in favor, none opposed to 2573. 36 in favor, 4 opposed to 2596. 40 in favor, none opposed to 2613. 2651 and 2767. 39 in favor, 1 opposed to 2781. These measures having received the required constitutional majority are hereby declared passed. Second roll call, we will take the following. House Bill 2466, House Bill 2528, 2521, 2527, 2553, 2644, 2739, 2357, Senate sub for House Bill 2402 and Senate Bill 521. Clerk will read the titles.
House Bill 2466, an act concerning economic development. House Bill 2528, an act concerning health, professions, and practices. House Bill 2521, an act concerning the Kansas Tort Claims Act. House Bill 2527, an act concerning sex offenders. House Bill 2553, an act concerning motor vehicles. House Bill 2644, an act concerning property taxation. House Bill 2739, an act concerning housing. House Bill 2357, an act concerning housing. Senate Sub House Bill 2402, an act concerning education. Senate Sub House Bill 2111, an act concerning agriculture.
I don't think that one was on the roll.
Take the last two off.
Should have ended in Senate Bill 521.
Senate Bill 521, an act concerning income taxation.
Clerk will call the roll.
Alley. Argabright. Bellinger. Lazy.
Senator from Sherman, they need you to repeat. They didn't catch your vote.
Lazy. Lou. Bowers. Bowser. Clays. Clifford. Corson. Dietrich. Erickson. Bag. Falscadeau. Francisco. Gossage. Haley. Hill. Holscher. Klemp. Cluse. Masterson. Miller. Murphy. Owens. Peck. Peterson. Petty. Rose. Reichman. Schmidt. Schallenberger. Shane. Starnes. Sykes. Thomas. Thompson.
Senator from Johnson, I'm going to need that one more time. Thank you.
Titus. Tyson. Warren.
Has every senator had an opportunity to vote? Any senator wish to explain their vote? Change a vote? Senator Douglas, Senator Francisco.
Thank you, Mr. President. I would like to change my aye to no on House Bill 2521.
So ordered. Senator from Johnson, Senator Holscher.
Thank you. Explanation of vote on HB 2528. While I acknowledge there are some issues that need to be addressed, this bill has a volume of changes. And while I agree that there are some changes that need to be made, I would prefer we continue the work of the task force that's been in place since November to complete their work and make recommendations. Therefore, I feel I have to vote no on this bill.
Final changes. Senator Wyandotte, Senator Petty.
Thank you, Mr. President. I would like to join the senator from Johnson in our remarks, and I will be submitting my own later.
So ordered. Further changes? Seeing none, clerk will close the roll, tally the vote. Thirty-four having voted in favor and 6 opposed. The passage of Senate Bill 521. 33 in favor, 7 opposed to House Bill 2357. 38 in favor, 2 opposed to 2402. 35 in favor, 5 opposed to 2466. 31 in favor, 9 opposed to 2521. 38 in favor, none opposed to 2527. 34 in favor, 6 opposed to 2528. 33 in favor, 7 opposed to 2553. 36 in favor, 4 opposed to 2644. and 39 in favor and 1 opposed to 2739. These measures having received the required constitutional majority hereby declared passed. On the third and final roll call, we will take the following two bills, sub for House Bill 2595 and Senate sub for House Bill 2111. Clerk will read the titles.
Sub House Bill 2595, an act concerning attorneys at law. Senate sub for House Bill 2111, an act concerning agriculture.
Clerk will call the roll.
Alley. Argabright. Billinger. Lazy. Lou. Bowers. Bowser. Clays. Clifford. Corson. Dietrich. Erickson. Bag. Vascado. Francisco. Gossage. Haley. Hill. Holscher. Klemp. Cluse. Masterson. Miller. Murphy. Owens. Heck. Peterson. Petty. Rose. Reichman. Schmidt. Schallenberger. Shane. Starnes. Sykes. Thomas. Thompson. Titus. Tyson. Warren.
Has every senator had an opportunity to vote? Does any senator wish to explain their vote? Change of vote. Senator from Douglas, Senator Francisco.
Thank you, Mr. President. During the discussion on House Bill 2111, it was noted that the opposition was cities or the League of Municipalities. I'd just like to add that the Kansas Department of Commerce testified in opposition to this bill, and they are the department that oversees agritourism.
For the explanation. Changes? Seeing none, clerk will close the roll, tally the vote. 26 haven't voted in favor and 14 opposed the passage of House Bill 2111. 34 in favor, 6 opposed the passage of House Bill 2595. These measures, having received the required constitutional majority, are hereby declared passed. Before adjourning, are there announcements? Senator Johnson, Senator Sykes.
Thank you. I just want to wish our guard Leo a happy birthday. I'm not sure this was the party he was envisioning for his birthday, but happy birthday.
I'm sure that wasn't the birthday he wanted. Senator Montgomery, Senator Peck.
Thank you, Mr. President. Conference Committee on House Bill 2158, Monday morning, 9 o'clock, with the House Commerce in room 159 South. This is a holdover from last year. It is a bill regarding honey. Thank you, Mr. President.
Senator Riley, Senator Starnes.
Thank you, Mr. Chair. As a reminder, as you head home, Monday, we need to have items to Senator Diedrich's office with the shrimp pill. Again, 100% of proceeds benefit Special Olympics. Get your items together. They need auction items, and consider contributing a local item from your area for the event. And the event is Wednesday, the 25th, starting at 5:30.
Senator Dickinson, Senator Hill.
Thank you, Mr. President. I want to recognize the young man that's been sitting and watching us all day. A couple of weeks ago, he was in the country of Jordan, and so he's looking forward to eating some barbecued pork tonight. Luke Walker.
Senator Sherman, Senator Billinger.
Thank you, Mr. President. The Conference Committee on the Budget will meet again here shortly, and we will be meeting tomorrow.
Senator from Shawnee, Senator Dietrich.
Thank you, Mr. President. We have Senate Financial Institutions and Insurance and House Insurance Conference Committee Monday, 8:30, 546 South. And then FI&I is going to be meeting with House Insurance Conference Committee, all bills in committee, Monday. Oh, I just said that wrong. I've got a missed page. One of them's at 8:30, the other one's at 9 o'clock, one's insurance, one's FI&I. Thank you, thank you. 546 South. So all bills in committee, thank you.
Senator McLeod, Senator Bowers.
Thank you, Mr. President. House Local Government and Senate Local Government Transparency and Ethics will conference on House Bill 2099 Monday morning, 9:30 in room 142 South. Thank you.
Any final announcements? Seeing none, Chair recognizes the Majority Leader from Sedgwick, Senator Blasey.
Thank you, Mr. President. I just want to take the opportunity to thank the Kansas Senate for all their work this week. I know it was a lot of work to get 66 bills done yesterday and 22 done today, but it takes a functional Senate to do that, and I just want to say hats off to everybody in the Senate chamber. The Senate will be gaveling in at 10 a.m. on Monday, and the plan for next week, just for scheduling purposes, is 10, 2, and 4, and then in the evening as we progress. So that's a suggestion to the conference committees that are trying to schedule, try to schedule around those hours, 10, 2, and 4. The Senate Republicans will probably caucus in 30 minutes prior to each of those hours, so just keep that in mind. Next week, for those who aren't in conference committees, next week is, just for those who are a reminder, it's a hurry up and wait game. So there's a lot of sitting around. So bring your puzzles and your cards, your knitting, whatever you do for fun. Or, meet with constituents. They still might be coming up here. Senate confirmation on page 7. I think there's 7 or 8 appointments by the governor that the Senate needs to confirm before we head out of town. They're on page 7, and the Senate will vote to confirm those on Monday afternoon. So last call on if you need a packet for those nominees, please contact my office. With that, Mr. President, wish everybody safe travels home and a happy weekend. I move the Senate adjourn pro forma until 9 a.m. on Friday, March 20th, 2026.
You've heard the motion. All those in favor say aye. Opposed, no. Motion carries. Senate's adjourned.